International law. Frequently asked questions on international law. Q. 1. Define international law. Give at least 3 definitions of international law. Critically analyze the definition given by Oppenheim. Ans. Definition. The words, international law, were used for the first time by Jeremy Bentham in 1780. Since then these words have been used to denote the body of rules and principles which regulate the relations among the members of international community. The term "members of international community" now denotes states, international organizations, individuals and certain non-state entities. I. Oppenheim's definition. Prof. L. Oppenheim has defined international law in the following words. The law of nations or international law is the name for the body of customary and conventional rules which are considered legally binding by civilized states in their intercourse with each other. Criticism. Oppenheim's definition, which was considered appropriate at one time, is now subjected to severe criticisms. This definition can be subjected to the following criticisms. 1. It is now generally recognized that not only states but international organizations have also certain rights and duties under international law. This view has been finally affirmed by the International Court of Justice in its advisory opinion on reparation for injuries suffered in the service of the UN, 1949. 2. It is also recognized that to some extent individuals have some rights and duties under international law. 3. It is also recognized that international law consists not only of customary and conventional rules, but also of general principles of law recognized by the civilized states. This has now been expressly recognized by Article 38 of the Statutes of the International Court of Justice. 4. The use of the term "civilized states" has also been criticized. A few decades ago Western states regarded only the Christian states as "civilized" states. For being considered "civilized", neither long history nor culture was the criterion. That is why, in later editions of Oppenheim's book the word "civilized" was deleted. New definition of international law. In latest edition of Oppenheim's book, the editors of the 9th edition of Oppenheim's book, 1992, Sir Robert Jennings and Sir Arthur Watts, have revised Oppenheim's definition of international law in the following words. International law is the body of rules which are legally binding on states in their intercourse with each other. These rules are primarily those which govern the relation of states, but states are not the only subject of international law. International organizations, and to some extent, also individuals may be subjects of rights conferred and duties imposed by international law. Thus the above concept and definition of international law given the 9th edition of Oppenheim's International Law is much better than the earlier definition and to a great extent similar to that given by Stark and Fenech. But it is still deficient in one respect. It is silent about the general principles. Some other definitions of international law similar to that of Oppenheim. West Rand Central Gold Mining Company Limited vs. King, 1905, 2 KB 391. In this case the court observed, International law may be defined as the form of the rules accepted by civilized states as determining their conduct towards each other and towards each other's subject. SS Lotus Case, 1927, PCIJ Series A number 101. In SS Lotus Case, international law was defined in the following words. International law governs relations between independent states. The rules of law binding upon states, therefore, emanate from their own free will as expressed in conventions or by usages generally accepted as expressing principles of law and established in order to regulate the relations between these existing independent communities or with a view to the achievement of common aims. Restriction upon the independence of states cannot therefore be presumed. Gray defines international law in the following words. International law or the law of nations is the name of body of rules which according to the usual definitions regulate the conduct of the states in their intercourse with one another. Hall. According to Hall, international law consists of conduct which modern civilized states regard as being binding on them in their relations with one another with a force comparable in nature and degree to that binding. The conscientious person to obey the laws of his country in which they also regard as being enforceable by appropriate means in case of infringement. Kelson. According to Kelson, international law or the law of nations is the name of a body of rules which according to the usual definition regulate the conduct of the states in their intercourse with one another. Criticism. The above definitions can be criticized in the same way as Oppenheim's definition has been criticized above. Q2. Trace the contribution of the Jews, Greeks and Romans in the development of international law. Ans. Jews. The Jews were in favor of foreigners. The Jews had the same laws for foreigners residing on Jewish territory as for themselves. A reading of Bible, however, illustrates that on account of their monotheism the Jews did not recognize other nations who professed faith in polytheism as their equals. They carried ruthless battles in rowing to the winds all cannons of warfare. Jews were having international relations only with their friendly nations. They faithfully observed treaties and considered ambassadors as sacrosanct. They gave full protection to foreigners. Greeks. The Greeks were more civilized than their neighbors whom they regarded as barbarians. Their notion of superiority prevented them from developing mutual relations with their neighboring nations. Before Macedonian conquest, the Greeks lived in numerous small city-states which were independent of one another. The inhabitants of the states belonged to the same race, blood and religion. This close affinity, in course of time united these independent fragments into a community of states which observed certain rules inter se in time of war and peace, their dispute. They frequently resorted to arbitration for settlement of treated heralds and priests who carried the holy fire as inviolable, commenced no war without a previous declaration, gave burial to warriors dying the battlefield, changed prisoners of war, regarded the temple of the god Apollo as permanently inviolable, and gave special privileges to ambassadors who were ceremoniously received and their persons treated as inviolable. Oppenheim observes that the Greeks left to history the examples that independent sovereign states can live in a community which provides a law for the international relations of the member states, provided that there exist some common interests and aims which bind these states together. It has, however, not to be forgotten that the Greeks never made the same distinction between law, religion and morality which the modern world makes. But the fact remains that the Greeks set an example to the future that independent states can live in a community in which their international relations are governed by certain rules and customs, based on the common consent of the members of that community. Romans. The Romans had an advanced notion of international law. They had a set of 20 priests, termed fetiales, who managed relations with foreign states by the laws called jus fetiales or jus sacrale. The Romans had one set of laws which were applicable exclusively to themselves, viz., jus civil, the law applicable to Romans, and another set for foreigners, jus gentium, the law which they had in common with other nations. The jus gentium was later on strengthened by the development of jus natural, which was the law that was constituted by right reason, common to nature and to man. It was ultimately this law or jus fetiales that governed the relation of Romans with foreign countries in times of peace and war, also when they entered into treaties of friendship with them. There were three kinds of such treaties, viz., treaties of friendship, amicitia, of hospitality, hospitum, or of alliance, foedus. Roman law recognized four just reasons for war, viz. a. Violation of the Roman dominions, b. Violation of ambassadorial privileges, c. Violation of treaties, and d. Support given during war to an opponent by a hitherto friendly state. War could be ended according to Romans, I. through a treaty of peace, e. by surrender, Judicial, or e. through conquest of the enemy's country, occupation. Treaties as said above were divided into three kinds, i.e. I. Treaty of friendship, e. Treaty of alliance, e. Treaty of hospitality. The Romans had great respect for treaties which could be terminated by notice. Q. 3. Explain the viewpoints of naturalists, the positivists and the Grotians on international law. Ans. The 17th and 18th centuries gave birth to three different schools of writers on the law of nations, viz., the Naturalists, the Positivists and the Grotians. 1. Naturalists. The Naturalists denied that there was any positive law of nations based on custom or treaties, but maintained that it was only a part of the law of nature. Samuel Pufendorf, 1632–1694, led this school. He maintained that states were bound to regulate their conduct towards one another by the law of nature as they had no common superior. He agreed with Hobbes, the Sive, that natural law is divisible into natural law of individuals and of states, and that the latter is the law of nations. Pufendorf further observed that outside the natural law of nations there is no positive law of nations having the force of real law. The German philosopher Christian Thomasius, 1665–1728, was a great follower of Pufendorf. So were the English philosophers Francis Hutcheson and Thomas Rutherford, the French philosopher Jean Barbeyrac, 1674–1744, and the Genevan philosopher Jacques Burlamaqui. 2. Positivists. The Positivists differed fundamentally from the Naturalists and ascribed the growth of international law to custom and international treaties. They do not consider natural law as of any importance but regard customary law based on treaties and customs to be positive international law and of highest importance. They gained importance in the 18th century. The Dutch jurist Biancashoek, 1673–1743, the German writer John Jacob Moser, 1701–1785, and George Friedrich B. Martens, 1756–1821, were the leading exponents of this school. Biancashoek observed that the law of nations was based on the common consent of nations, expressing itself either in international custom or international treaties. This school represents the modern view of international law. 3. Grotians. The Grotians occupied a position midway between the Naturalists and Positivists. They maintained the distinction between natural and voluntary law of nations as propounded by Grotians and kept both as the basis of the law. But unlike Grotians, they considered the positive or voluntary law of nations as important as the natural law of nations. They gained enormous influence during the 17th and 18th centuries. Q. 4. Whether international law is a law in the true sense of the term or not. Comment. Ans. Whether international law is law in the true sense of the term or not. The controversy whether international law is true law or not depends upon the definition of the word "law". If we subscribe to the view of Hobbes, Austin and Pufendorf, that law is command of sovereign enforced by superior political authority, then international law cannot be included in the category of law. On the other hand, if we subscribe to the view that the term "law" cannot be limited to the rules enacted by the superior political authority, then international law can be included in the category of law. According to Austin, law is given by a determinate superior political authority to political inferiors and is backed by a coercive enforcement agency. Thus, according to Austin, sanction occupies an important place in the enforcement of law. Hobbes also subscribes to this view. In the view of Hobbes, man is by nature nasty, brutish and violent, and fear or sanction which is inherent in law is necessary to maintain order in society. The definition of law by Austin is not correct. In the words of Prof. Oppenheim, this definition is not correct. It does not cover that part of municipal law which is termed as unwritten or customary law. There is, in fact, no community and no state in the world which exist with written law only. In his view, law is a body of rules of human conduct within a community which by consent of this community shall be enforced by external power. Brierly and Prof. Hart have also criticized the Austinian definition of law. According to Oppenheim, the existence of law presupposes the existence of three prerequisites: I, a community; E, a body of rules; and E, common consent of the community that if necessary these rules shall be enforced by an external power. The three requirements of this definition, i.e. Oppenheim's definition of law, are satisfied by international law, to a greater or lesser extent. Conclusions. On the basis of the above arguments, it may be concluded that international law is in fact law. International law operates entirely in different setting. It operates in a decentralized system. According to Strake, international law is a "weak law" because existing international legislative machinery operating mainly through law-making conventions is not comparable in efficiency to state legislative machinery. International law can be said to be "weak" only when it is compared with municipal law. Much of the controversy relating to international law is due to the fallacy that the system of municipal law is an ideal one and all legal systems, and for that matter international law also must conform to that ideal. Municipal law operates in a centralized system, whereas international law operates in a decentralized system. The comparison is therefore not a happy one. International law must be understood in its own setting and the system in which it operates. It is as strong and as effective as it can be under the system in which it operates. Q. 5. Is international law a mere positive morality? Comment. Ans. Various jurists have given their views on whether is international law a mere positive morality. A rule of morality applies to conscience and is, therefore, not binding. On the other hand, a rule of law is binding and can be enforced by external power. Most of the jurists agree that international law has binding nature, whereas the rule of morality is simply a standard of right behavior based on the personal judgment. As pointed out by Edward Collins, although attitudes about morality, when widely shared, influence the development of international law, there is no recognized legal obligation to obey the norms of morality until they are accepted by authoritative decision-makers. International law. Frederick Pollock has rightly observed, if international law were only a kind of morality, the framers of state papers concerning foreign policy would throw all their weight on moral arguments. But as a matter of fact, this is not what they do. They appeal not to the general feeling of moral righteousness, but to precedents, to treaties and to opinion of specialists. Prof. Hart also subscribes to this view. He adds, the rules of international law, like those of municipal law, are often morally quite indifferent. A rule may exist because it is convenient or necessary to have some clear fixed rule about the subjects with which it is concerned, but not because any moral importance is attached to the particular rule. Q. 6. Whether international law is the vanishing point of jurisprudence? Comment. Ans. According to Holland, international law is the vanishing point of jurisprudence. In this view, international law is followed by courtesy and, therefore, it cannot be kept in the category of law. Austin also subscribes to this view. The view of Holland does not seem to be correct. In the first place, sanction is not most essential element of law. Even if it is regarded as an essential element, it will be proper to say that international law has no sanctions at all. War reprisals, retortion, Pacific blockade etc. were regarded as sanctions under the traditional international law, i.e., before the establishment of the United Nations. The Charter of the United Nations also contains a provision wherein the Security Council may recommend or decide upon the measures to be taken to implement the decision of the International Court of Justice. In the view of Holland, there is no judge or arbitrator to decide international disputes. This statement cannot be accepted because the International Court of Justice is the judicial organ of the United Nations, and its decisions are binding upon the parties to a dispute. It is true the International Court of Justice lacks compulsory jurisdiction in the real sense of the term. Its decision cannot be applied to future cases as precedents, and, above all, the binding force of its decisions is very limited. Under Chapter 7 of the UN Charter, the Security Court possesses wide powers to declare sanctions against the states who are guilty of violation of the provisions of the UN Charter relating to international peace and security. UN action in the Gulf War, 1991, is a glaring example of this. Reference may also be made to the UN sanctions against Libya in Lockerbie case, i.e. bombing of Pan American flight airliner in 1988 over Lockerbie, Scotland, killing 270 persons. Earlier, the UN had taken enforcement action under Chapter 7 of the Charter in several cases, such as in 1948 against North Korea and in 1961 in Congo. On the basis of above discussion, it may be concluded that international law is, in fact, law, and it is wrong to say that it is the vanishing point of jurisprudence. Q. 7. Distinguish public international law with private international law. Ans. Distinction between public international law and private international law. The main points of difference between public and private international law are the following. I. Public international law, for its major part, deals with states and to a lesser extent with the individuals. Private international law deals with the individuals. E. Public international law is a part of municipal law, but so it is not always the case with public international law. E. Public international law, at least the rules having general application, is same for all the states, whereas private international law may be different in different states. IV. Private international law determines as to which law will apply in a case having a foreign element. There is no such problem in the field of public international law. V. Private international law also determines the court which will have jurisdiction to decide the issue in question. In this respect also it differs from public international law. V. According to Robert Fillimore, rights arising out of public international law are absolute and their breach constitutes a casus belli, i.e. whatever involves or justifies war. This view does not seem to be correct in the presence of the provisions of Kellogg-Briand Pact and the UN Charter, which have outlawed war. But private international law does not at all confer absolute rights. V. International law comprises mainly of the rules recognized by states in their relations with each other and mostly arises out of international customs and treaties. On the other hand, rules of private international law are framed by the legislature of a state and recognized and developed by state courts. Q. 8. What are the weaknesses of international law? What do you think are the suggestions for the improvement of international law? Ans. Weaknesses of the international law. Following are the weaknesses of the international law. 1. It lacks effective authority to enforce its rules. 2. It lacks effective legislative machinery. 3. The International Court of Justice has no compulsory jurisdiction in the true sense of the terms. 4. The sanctions behind international law are very weak. 5. It cannot intervene in the matters which are within the domestic jurisdiction of states. 6. Many rules of international law are uncertain and vague. 7. International law has failed to maintain order and peace in the world. Suggestions for improving international law. 1. The International Court of Justice should be given compulsory jurisdiction in the true sense of the term. 2. An international criminal court should be established to decide cases of international crimes. 3. International law should be properly codified and scientifically revised from time to time. 4. The machinery to enforce the decisions of the World Court should be strengthened. 5. The powers and scope of the activities of the International Law Commission should be expanded. 6. The doctrine of judicial precedents should be applied in the field of international law. 7. In order to strengthen the legislative machinery of international law, more law-making treaties and conventions should be made and there should be a provision for their revision from time to time. 8. The legislative activities of the General Assembly should be further enlarged. 9. Such activities of the UN should be encouraged as may develop the feelings of international community in the true sense of the term. 10. The UN Charter should be amended as to authorize the UN to intervene in such matters with the domestic jurisdiction of state as are of international concern. Q. 9. What are the major sources of international law? Describe each source in detail. Ans. Sources. The first 5 sources find mention in Article 38 of the Statute of International Court of Justice. 1. International conventions. The term convention applies to any treaty, protocol or agreement, regardless of its title or form. According to Article 38 of the Statute of International Court of Justice, it is the first source of international law. In the modern period, international treaties are the most important sources of international law. As defined by Article 2 of Vienna Convention on the Law of Treaties. 1969, a treaty is an agreement whereby 2 or more states establish or seek to establish relationship between them governed by international law. 2. International customs. International customs used to be the most important source of international law in the past. In the modern period, their importance has lessened. Custom is a habit which has been repeated for a long time and has ultimately assumed the force of law. Usage is the earlier stage of the development of custom. By usages mean those habits which are often repeated by the states. Custom begins where usage ends. Usages may be inconsistent and opposed to each other, but so is not the case with custom. 3. General principles of law recognized by the civilized states. According to Article 38 of the Statute of International Court of Justice, the general principles of law recognized by the civilized nations are also one of the sources of international law. This is an important source of law through which international law adapts itself in accordance with the changing times and circumstances. Res judicata, estoppel, etc. are the examples of the general principles of law recognized by civilized states. The general principles of law are those principles which are recognized by most of the civilized states. When the court finds that a principle has received general recognition, the court may apply it as a principle of international law. Chorzów Factory, Indemnity Case, Pub. PCIJ, 1938, Series A, Number 17. In this case, the Permanent Court of International Justice applied the principle of res judicata, also held that one who violates a rule is liable to make reparation. A. Mavromatus Palestine Concessions Case, Pub. PCIJ, 1924, Series A, Number 2. In this case the court applied the general principle of subrogation. G. Barcelona Traction Case, Preliminary Objections, ICJ Rep. 1964, page 6. In this case also the International Court of Justice applied the principle of estoppel. 4. Decisions of judicial and arbitral tribunals. The decisions of judicial and arbitral tribunals are also the sources of international law. But according to Article 38 of the International Court of Justice, they are subsidiary means for the determination of the rules of law. This source includes international as well as state decisions. As regards the decisions of the International Court of Justice, Article 59 of the Statute of International Court of Justice provides that they will have no binding force except between the parties and in respect of that particular case. Since the doctrine of precedent does not apply in field of international law, the international judicial decisions are not generally binding. They are regarded as subsidiary means for the determination of the rules of international law. The arbitral decisions have still less value because it is generally said that arbitrators work more as mediators rather than as judges. 5. Justice works. The opinions of jurists are also regarded as sources of international law. But they are also subsidiary means for the determination of the rules of international law. While deciding the case, if the court does not find any treaty or judicial decision or legislative act or any established custom, the court may take the help of opinion of jurists as subsidiary means for the determination of rules of international law. 6. Decisions or determinations of the organs of international institution. In the modern age, the decisions or determinations of organs of international institutions are also treated as sources of international law. International organizations have also become a subject of international law. The decisions and determinations of the organs of such institutions are also, therefore, regarded as the source of international law because they help in the development of customary rules or international law. The International Court of Justice has recognized it in a number of cases such as Southwest African cases, 1996, military and paramilitary activities in and against Nicaragua, 1986. Q. 10. What are the necessary ingredients of a custom? Discuss the importance of the custom as a source of law. Uns. Ingredients of elements of custom. Following are the main elements of an international custom. I. Evidence of a general practice accepted as law. Long duration is an essential element of a custom in municipal law. But this is not necessary for an international custom. Article 38 of the ICJ directs the World Court to apply international custom as evidence of a general practice accepted as law. E. Uniformity and consistency. The custom should be uniform and consistent. E. Generality of practice. Though universality of practice is not necessary, the practice should have been generally observed or repeated by numerous states. IV. Opinion juris necessitates. As pointed out by the International Court of Justice in North Sea Continental Shelf cases, ICJ, Representative 1969, page 3. Customary practice, even when it is general and consistent, is not customary law unless an opinion juris is present, that is to say, unless the practice is recognized as being required by international law. Importance of custom as a source of international law. There has been a marked decline in the importance of customs as a source of international law in the modern times. This is mainly due to the fact that the process of development of a new custom is very slow. However, in modern time also the development of new custom is possible, and at times customs have developed with accelerated speed. Principle relating to sovereignty over airspace in continental shelf are its glaring examples. But in view of the accelerated speed of the changes in international community, custom has become an inadequate means for bringing about the desired changes and development of international law. Thus, though the custom has been relegated to second place in importance, it still occupies an important position as a source of law. Q. 11. What are the main theories regarding the relationship between international law and municipal law? Ans. There are 5 theories regarding the relationship between international law and state law. 1. Monism. 2. Dualism. 3. Specific adaptation theory. 4. Transformation theory, and 5. Delegation theory. The 2 main theories are monism and dualism, and other theories have been derived from these 2 theories. 1. Monism. According to this theory, law is a unified field of knowledge, no matter whether it applies on individuals, state or other entities. Thus international law and state law are intimately connected with each other. They are the 2 branches of unified knowledge of law. According to monist belief, international obligation and municipal rules are phases of same phenomenon, the 2 deriving ultimately from one basic norm and belonging to the unitary order comprised by the conception of law. In the ultimate analysis of law we find that individual is at the root of all laws. In the ultimate analysis, all laws are made for individuals. Wright, Kelson and Dugvie, etc., are some of the prominent exponents of monism. Theoretically and logically this appears to be the correct theory, and it is very difficult to disprove it. However, it may be noted that this theory is not based on the actual practice of state. 2. Dualism. According to this theory, international law and municipal law are 2 separate laws. Triappel and Inzilati are the chief exponents of this theory. According to Triappel, international law and state law are different because their subject and origin are different. In his view, individual is the subject of state law, whereas state is the subject of international law. Besides this, origin of the state law is the will of state, but origin of the international law is common will of the states. As regards origin of international law, the conception of state will is not correct. It is rather metaphorical. In fact, the state will is nothing but the will of the people who compose it. There are certain fundamental principles of international law which are binding upon the state even against their will. Whether monism or dualism is the correct theory. The above discussion shows that monism is a more correct theory, but it is submitted that no theory can be complete in itself and it is not possible to include all the elements in it. The practice of state indicates that sometimes there is a primacy of international law, sometimes there is the primacy of the municipal law, sometimes there is mixture of different legal systems. For example, in the Greco-Bulgarian Communities case, PCIJ, 1930, Series B, number 17, the Permanent Court of International Justice held. It is a generally acceptable principle of international law that in relations between powers who are contracting parties to a treaty, the provisions of the municipal law cannot prevail over the treaty. On the other hand, when the municipal courts find that the conflict between the international law and municipal law is of such nature that cannot be avoided, they give primacy to the municipal law. In this connection, Mortensen vs. Peters, 8, Sessions Cases, 5th Series, 93, 1906, and Shri Krishna Sharma vs. the State of West Bengal, Air 1954 Cull, 598, deserves a special mention. 3. Specific adaptation theory. This theory is based on the theory of positivists. According to this theory, international law can be enforced in the field of state law only after it has been specifically adopted by state law. This theory can also be subjected to criticism because there are several principles of international law which are applied in the field of municipal or the state law without specific adaptation. However, this view is generally followed by state in respect of international treaties. It is argued that unless there is specific adoption of the international treaties such as Tokyo Convention Act, 1975 and Vienna Convention of Diplomatic Relations Act, 1972 enacted by Indian Parliament, or there is some sort of transformation, international treaties as such cannot be enforced in the municipal field. While considering the International Convention on Civil and Political Rights, the Supreme Court of India has held in Jolly George vs. the Bank of Kochi, Air 1980 South Carolina 470 at pp. 474, per Krishn Iyer. J. The positive commitment of the state parties dignifies legislative action at home but does not automatically make the covenant enforceable part of the corpus juris of India. As regards specific adoption of international treaties by Indian Parliament, the Anti-Apartheid, United Nations Convention, Act, 1981, the Anti-Hijacking Act, 1982, the Suppression of Unlawful Acts Against the Safety of Civil Aviation Act, 1982 and the International Monetary Fund and Bank, Amendment, Act, 1982 deserve a special mention. It may, however, be noted here that there are many principles of international law, especially customary rules which are applied in the field of municipal law without specific adaptation. 4. Transformation theory. According to the exponents of this theory, the rules of international law to be applied in the field of municipal law must undergo transformation. This theory is also based on the theory of consent, which has been already criticized earlier. There are several law-making traits and principles of international law which become applicable in the field of municipal law without undergoing the process of transformation. The Headquarters Agreement between the United States of America and the United Nations is a glaring example of this. 5. Delegation theory. The critics of transformation theory have put forward a new theory called delegation theory. According to this theory, the constitutional rules of international law permit each state to determine as to how international treaties will become applicable in the field of state law. The constitution of each state contains provisions in this connection. Thus no transformation takes place. This theory is based on presumption and has been severely criticized. Q. 12. What do you mean by codification? What are the major factors which led to codification? Ans. Meaning and definition of the term codification. By the term codification we ordinarily mean the process of reducing the whole body of law into code in the form of enacted law. It generally connotes a systematic arrangement of the rules of law which are already in existence. According to R. Y. Jennings, codification means any systematic statement of the whole or part of the law in written form, and that it does not necessarily imply a process which leaves the main substance of the law unchanged. Even though this may be true of some cases. History of codification. The history of codification dates back to the 18th century when the idea of codification of international law was conceived by Bentham. Before him an unsuccessful attempt was made by the French Convention to draw up a Declaration of the Rights of Nations in 1792. Declaration of Paris, 1856. The Declaration of Paris occupies a place of significance in the development of codification of international law. This declaration was signed by Britain, France, Austria, Russia, Turkey, Prussia and Sardinia after the end of the Crimean War in 1856. This declaration laid down the principles relating to a. Abolition of privateering, b. Non-capture of neutral goods except contraband of war, under enemy flags, c. Blockade to be binding must be effective, and d. Except contraband of war, enemy goods cannot be captured under neutral flag. Codification under the United Nations. Article 13, 1, of the UN Charter lays down that the General Assembly shall initiate and make recommendations for the purpose of promoting international cooperation in the political field, and encouraging the progressive development of international law and its codification. The UN General Assembly took the task of encouraging the progressive development of international law and its codification in all seriousness. On December 11, 1946, the General Assembly appointed a committee for the progressive development of international law and its codification. In 1947, the General Assembly decided to set up an International Law Commission. An International Law Commission was elected and it met on April 11, 1949. As provided under Article 1 of the Statute of the International Law Commission, the Commission shall have for its object the promotion of the progressive development of international law and its codification. Further, Article 24 provides that the Commission shall consider ways and means for making the evidence of customary international law more readily available, such as the collection and publication of documents concerning state practice and of the decisions of national and international courts on questions of international law, and shall make a report to the General Assembly on this matter. Work of the International Law Commission. The Commission began its work in 1949 and since then it has done commendable work in respect of the codification of international law. It decided to give priority to the following three topics: I. Law of treaties, E. Arbitral procedure, and E. Law relating to the high seas. In addition to this, the Commission has also worked on the various recent conventions and treaties. Geneva Conventions on the Law of Sea, 1958, Vienna Convention on Diplomatic Relations, 1961, 1965, Convention on Settlement of Investment Disputes between the state and nationals of other states. Vienna Convention on the Law of Treaties, 1969 are some of the landmarks in the field of codification and progressive development of international law. Besides these, UN Conventions on Biodiversity, 1992, UN Convention on Forestry, 1992, UN Convention on Climate Change, 1992, etc., deserve a special mention. Moreover, for the progressive development and codification of international trade law, a United Nations Commission has been established. Q. 13. What are the merits and demerits of codification? What do you think about the future of codification? Ans. Merits and demerits of codification. Merits of codification. 1. One of the defects of international law is uncertainty. Codification not only makes rules clear and certain but also reconciles conflicting and divergent views. 2. Codification will be helpful in filling numerous gaps existing in international law and also by providing for rules where there is none. 3. Yet another merit of codification is that it will bring uniformity in the international legal system. 4. Codification will also go a long way to end or at least greatly minimize the disagreement and confusion that prevails on many important matters. 5. Codification will enhance the efficacy of international law by increasing its binding force. 6. The International Court of Justice and other tribunals will find it easier to apply and enforce codified international law. 7. It will be easier and convenient to amend the codified international law so as to keep it at pace with the tide of time. Demerits of codification. 1. Codification is detrimental for the natural growth and future development of international law. This defect can be remedied by a regular and scientific international law. This defect can be remedied by a regular and scientific revision of codes in order to incorporate changes in international conditions. 2. Yet another disadvantage of codification is that it makes the system of law too rigid and unadaptable to new situations. 3. Codification also makes the law too formal and conservative. This defect can be removed by progressive interpretation of international law. 4. New controversies arise due to codification. 5. It gives rise to controversies in interpretation because of the hair-splitting tendency of judges to interpret the law. 6. International law still being in its infancy, only a partial codification is possible. 7. Last but not the least disadvantage of codification is that customary rules still form the bulk of international law, and many of them are not yet fully settled, covering the whole area of international rules. Conclusion and future of codification. A critical perusal of the advantages and disadvantages of codification will lead us to irresistible conclusion that the advantages outweigh the disadvantages. Codification will make the law certain, single, intelligible and, above all, easily accessible to all. Many of the disadvantages of codification may be removed by carefully planning and regular and scientific revision of the code to incorporate changes in international conditions. International law can flourish only if the states are ready to yield their interests in the larger interests of international security. As suggested by Sir Cecil Hurst, in every country some small body of men devoted to the study and advancement of international law should take this work, of codification, in hand. Working if possible to a plan which would have been drawn up and agreed on by some central international scientific organization like the Institute of the International Law. And that this central organization would set up machinery for the joint study and coordination for the contribution emanating from all national groups. Its value to government would be that of providing a firm foundation for the modification by treaty of any of its provisions which were found to be unjust or to work badly under modern conditions and, in consequence, to require amendment. Q. 14. Define state. What are the essential elements of state? Briefly describe the functions of state. Uns. Definitions of state. State is the main subject of international law. According to Salmond, state is a community of people which has been established for some objectives, such as internal order and external security. In the view of Oppenheim, the existence of state is possible only when the people of state have settled under the highest governmental authority and habitually follow its order. Ideal definition of term "state" is not possible. However, in the modern period it is finally settled as to what are the essential elements of a state. Essential elements of a state. According to Article 1 of Montevideo Convention, 1933, the state as a person of international law should possess for ingredients a permanent population, b. a defined territory, c. a government, and d. a capacity to enter into relations with other states. According to Oppenheim, population, a defined territory, government and sovereignty are the essential elements of a state. Holland has added one more essential element, namely, to some extent, civilization, because of which the state becomes an international person. Functions of state. The modern period has witnessed revolutionary changes in regard to functions of a state. Previously, the concept of a police state prevailed. According to this concept, essential functions of a state were to maintain internal peace and order and to defend it from external aggression. It cannot be denied that even today these are the essential functions of a state, but in the present period the concept of state has undergone significant changes. Instead of the concept of police state, the present concept is that of welfare state. That is to say, for the benefit of the people, state has to perform many social, economic, educational and cultural functions. However, these functions may not be termed as essential functions. They are in fact subsidiary functions, although the significance of these functions is constantly increasing. Q. 15. What do you mean by the term "sovereignty of state"? What is the importance of sovereignty in modern times? Ans. Sovereignty. Sovereignty of states. Sovereignty is a legal term signifying the supreme power by which any state is governed. It denotes in ordinary parlance the unrestricted power of self-determination by the state of its external and domestic affairs. Austin termed sovereignty as essential, indivisible and illimitable. As a result of the exercise of sovereignty, there emerge two legal assumptions in the domain of international law, viz. the independence and equality before the law of each sovereign state and the prohibition to interfere with the external and internal sovereignty of each independent state. The doctrine of independence of state implies that it is free to adopt any constitution it likes, is free to deal with its own citizens, either inside or outside its territories, and aliens within its territory in any manner, and is at liberty to shape its foreign policy, join any bloc or adopt a neutral attitude, conclude treaties with other states or make war or peace accordingly as it suits its interests. In the modern period there have been revolutionary changes in the concept of sovereignty, because of which it is not proper to say that states' sovereignty is essential, indivisible and illimitable. In the present time, states have entered into many international treaties, thereby surrendering a part of their sovereignty. For example, the members of the United Nations have accepted many obligations under the Charter. It has, therefore, been rightly remarked by Stark, sovereignty has a much restricted meaning today than in the 18th and 19th centuries, when with the emergence of powerful highly nationalized states, few limits on states' autonomy were acknowledged. At the present time there is hardly a state which in the interest of the international community has not accepted restrictions on its liberty of action. In Union of India vs. Sukumar Sengupta, Air 1990 South Carolina 1962 at page 1701, Sabyasachi Mukherjee, CJ of the Supreme Court of India, quoted with approval the above observation of Stark. His lordship added, "Any state in the modern time has to acknowledge and accept customary restraints on its sovereignty inasmuch as no state can exist independently and without reference to other state. Under the general international law, the concept of interdependence of states has come to be accepted." Q. 16. Distinguish between a. confederation and federation. B. Real union and personal union. Ans. A. Confederation. A confederation or Staatenbund is constituted by a number of full sovereign states linking together by an international treaty into union with organs of government extending over the member states but not over the subjects of those states. They unite by means of a compact for the purpose of mutual cooperation or defense, each constituent member retaining its sovereignty and separate identity. Such a confederation is not a state. It is more or less a society of an international character, and the member states remain full sovereign states and maintain their international position. Federation. A federation or Bundesstaat, on the other hand, is a perpetual union of several sovereign states which has organs of its own and invested with power, not only over the member state, but also over their citizens. Professor Oppenheim. The ordinary powers of sovereignty are partly vested in the federal government and partly in the separate state, both the authorities being coordinate within their respective spheres. It is a real and sovereign state within the sphere of the powers granted to it and has, unlike a confederation, direct power not only over the member states but also over the citizens of those states. The federal state has the power to declare war, make peace or conclude treaties, and the member states exercise power and control within their competence and retain a considerable measure of autonomy. B. Real union. A special form of confederation is the real union, which exists when two or more sovereign states have the same monarch and for international purposes and external relations act as one state. Although the constituent elements retain their separateness in domestic matters. A real union is not itself a state, but merely a union of two full sovereign states, which together make one single but composite international person. Personal union. A personal union is in existence when two sovereign states and separate international persons are linked together through the accidental fact that they have the same individual as monarch. These states retain their separate identities for external purposes. Q. 17. Equality of states is a general principle, but there are several exceptions to the principle. Comment. Ans. Principle of the equality of states. As the members of international community, in principle, all states are equal. This equality is due to their international personality. Despite the dissimilarity in respect of their territories, population, power, civilization, prosperity, etc., all states as international persons are equal. According to Oppenheim, following are the consequences of this legal equality. I. When any question is to be decided by consent, each state is entitled to have one vote. But there are exceptions to this rule, such as the vote of the permanent members of the Security Council. Legally, the importance of the votes of the weak as well strong nations is same. There are some exceptions to this rule also. No state can exercise jurisdiction over another state. This rule has been applied by the courts in many cases. Generally, the courts of a state cannot challenge the validity of the official acts of another state so far as these acts are related to the jurisdiction of that state. The cases of A.M. Luther and Company versus Sugar and Company, 1921, 3 KB 532 and Underhill vs. Hernandez, 1897, US 250, 18 Sup. Et. 83. Deserve special mention in this connection. In principle all states are equal. But in reality they are unequals in respect of their respective powers, territory, property, etc. Oppenheim has rightly pointed out the legal equality must not be confused with political equality. The enormous differences as regards their strength are the result of their natural inequality which, apart from rank and titles, finds its expression in the province of police. Politically, states are in no manner equals. The UN Charter is based on the principle of "sovereign equality" of states, but in reality great powers are unequal to small states, and legally also because they possess the power of veto under the Charter. Thus the equality of states is a general principle, but there are several important exceptions of this principle. Q. 18. What is the difference between a. protectorate and vassal state, b. neutral state and neutralized state? Ans. Difference between protectorate and vassal state. Protectorate state. Vassal state. 1. A protectorate state generally entrusts its defense, external affairs etc. to another state. 1. Vassal state is generally autonomous in its internal matters, but is completely dependent upon another her state in external matters. 2. A protectorate state remains a state under international law. 2. A vassal state is not treated as state under international law. 3. Since a protectorate state retains a sufficient measure of sovereignty, declaration of war or peace made by the protecting state with another state is not binding upon it. 3. A vassal state is bound by treaty of war or peace entered into by the state under whose international guardianship it remains. Distinction between a neutral state and neutralized state. A neutral state is a state which does not support either belligerent state during war. A neutralized state on the other hand is a state whose independence and territorial sovereignty is collectively accepted by an international agreement. A neutral state may at its will give up its neutrality, but a neutralized state without violation of the treaty cannot give up its neutrality. Switzerland, Belgium, Austria are some of the neutralized states whose neutrality has been guaranteed by international agreements. Switzerland is an ideal neutralized state because it has not even joined United Nations. Austria became a member of the United Nations in 1955. Stark has expressed the view that a neutralized state may become a member of the UN because under Article 48, the Security Council may exempt a neutral state from giving support in any enforcement action. The view of Stark is only partly correct because the membership of the UN invariably and undoubtedly dilutes the neutrality at least to some extent because under Article 48, the Security Council may exempt neutral states from taking part in enforcement action, but that is not a mandatory provision. In case the Security Council decides that such a state has to support the enforcement action, the neutrality of such a state will end as regards that particular case. Q. 19. Discuss the international positions of a. Bhutan, b. Tibet, C. Holy See or Vatican City. D. Commonwealth of Nations. Ans. A. Bhutan. Bhutan is a protectorate state of India. It is a hilly region in northeast of Nepal. In 1949, through a treaty, Bhutan entrusted the matter of foreign affairs and defense to India. It thus became a protectorate state of India. Since a protectorate state retains a sufficient measure of sovereignty, Bhutan remains a state under international law. In 1971, Bhutan became a member of the United Nations. B. Tibet. In Simla Conference, 1914, Tibet was declared a protectorate state of China. This was further confirmed by the Treaty of 1951. China accepted Dalai Lama as the spiritual head of Tibet. Tibet was autonomous in its internal matters, but China started interfering in the internal matters of Tibet. In 1959, the situation deteriorated so much that the conflict took the form of war between China and Tibet. China ruthlessly suppressed the movement of the people and Dalai Lama was compelled to leave Tibet. He fled away from Tibet and took asylum in India. China criticized action of India in granting asylum to Dalai Lama and claimed that it was an interference in her internal affairs. At its very face, this argument is absurd because as a sovereign state, India was within her rights to grant asylum to Dalai Lama and his followers within her territory. C. Holy See or Vatican City. Holy See or Vatican City is a place where Pope resides. In the middle of 19th century, the rulers of Italy seized the territory of Pope and occupied his capital Rome. He, therefore, fled to his residential place called Vatican City. In 1871, Italy granted some guarantees to Pope. Next important change took place in 1929 when a treaty was concluded between Pope and Government of Italy. Vatican City, comprising of 100 acres of land, was accepted as a state and Pope was treated as a sovereign of the state. The present position of Vatican City is that it is an international person and possesses all the rights and duties of a sovereign state. D. Commonwealth of Nations. Commonwealth of Nations is an association of those states, except Britain, which were at some time the colonies of the British Empire. Britain, Canada, Austria, Cyprus, Nigeria, New Zealand, India, Pakistan, Ceylon, Malaysia, Singapore, etc. are its members. Before 1948 it was called the British Commonwealth of Nations. In 1948 the term "British" was dropped. It is now called the Commonwealth of Nations. All the members of the Commonwealth of Nations are now sovereign states. Under international law, Commonwealth of Nations is neither a state nor a federation. It is in fact a loose association of equal and sovereign states who are members of the United Nations and have agreed to follow certain general principles. Thus, under international law, Commonwealth is not a separate independent entity. Q. 20. What do you know about the various theories of international law? Briefly explain. Ans. There are three main theories of international law. 1. Only states are subjects of international law. According to this view, only states are the subjects of international law. This view has been severely criticized. It fails to explain the case of serfs and pirates who have been conferred some rights under international law. But those who subscribe to the view that states are the only subjects of international law, say that they are not the subjects but objects of international law. They further point out that they get these rights only through the medium of the state. In reparation for injuries suffered in the service of the UN, ICJ Representative. 1949, page 174. The International Court of Justice rejected the proposition that states only are subjects of international law, and hence the traditional view that states only are the subjects of international law is not a rule of modern international law. It is now well settled that besides states, individuals, international organizations and certain non-state entities are also the subjects of international law. 2. Individuals alone are the subjects of international law. The chief exponent of this theory is Kelsen. According to Kelsen, both state law and international law apply on the individuals. If we make an analysis, we find that individual is at the root of all laws. Thus there is no real difference between international law and state law. Kelsen, however, admits that the difference is simply this, that state law applies on individuals immediately or directly, whereas the international law applies mediately. It may be noted that the logic behind the views of Kelsen is very strong and it is very difficult to disprove it, although the practice of the state is just contrary. In practice, international law is generally regarded as comprising of the major part of its rules regulating the relations of state. This view seems to be a reaction of the view that only states are the subjects of international law. This is in fact a very extreme view and cannot be regarded as completely correct. Individuals are now recognized as subjects of international law, and present practice shows that international organizations and certain non-state entities are also to some extent regarded subjects of international law. 3. States are main subjects of international law, but individuals, international organizations and certain non-state entities are also subjects of international law. This view, besides making the synthesis of the first and second views, goes a step ahead to include international organizations, certain other non-state entities as subjects of international law. This is definitely a better view than the first two views. As per this theory, equal attention is given to promoting the growth of a body of world law transcending states, and applicable on a footing of equality of individual corporations, international organizations and states. Conclusion: on the basis of the above discussion, it may be concluded that not only states, individuals, international organizations and certain another non-state entities are the subjects of international law. The fact, however, remains that major part of the rules of international law deal with the intercourse of states with each other. Q. 21. What is the place of individual in international law? Ans. Place of individuals in international law. As pointed out earlier, individuals are also now treated to be the subjects of international law. In recent times, several treaties have been entered into wherein certain rights have been conferred and duties have been imposed upon the individuals. In this connection, following may be noted. I. Pirates. Pirates are treated as enemies of mankind under international law. Every state can apprehend and punish them. Harmful acts of individuals. Under certain circumstances, states are responsible for the harmful acts of their individuals. If a person causes harm to the personal property of the ambassador of another state, then under international law the state is responsible for his act. Such persons are, therefore, given stringent punishment. Foreigners. To some extent international law regulates the conduct of foreigners. It is the duty of each state to give them those rights which it generally confers upon its own citizens. War criminals. War criminals can be punished under international law. According to Nuremberg and Tokyo tribunals, since war crimes are committed by the individuals, it is by punishing them the provisions of international law can be enforced. Espionage. Espionage is a crime under international law and, therefore, spies can be apprehended and punished. In addition to the above-mentioned examples, certain treaties and conventions have been entered into wherein individuals have been conferred upon the rights directly. The 1965 Convention on the Settlement of Investment Disputes between the state and the nationals of other states is a glaring example of such benign trend. The International Covenant on Human Rights confers rights directly upon the individuals. These, along with the UN Commission on Human Rights, have enabled the individuals to send petitions even against their own states. Thus slowly and gradually individuals are occupying an important place under international law. It may therefore be concluded that individual has become a subject of international law, not having the same quality as a state but capable of asserting rights himself before some international tribunals, although lacking procedural capacity to bring actions in most cases. The legal order will continue to be imperfect as long as it faces new challenges such as apartheid and modern technological advance. And the individual as a subject of international law will continue to play an important role in the development of the law. Q. 22. What do you mean by recognition? What are the conditions for recognizing a new state? What are the main theories of recognition? Meaning and definition of the term recognition. In the words of Prof. Oppenheim, in recognizing a state as a member of international community, the existing states declare that in their opinion the new state fulfills the conditions of statehood as required by international law. Conditions for recognition of a new state. According to Kelson, a community to be recognized as an international person must fulfill the four conditions. A. The community must be politically organized. B. It should have control over a definite territory. C. This control should tend towards permanence, and D. The community thus constituted must be independent. But international law does not provide as to how those essential conditions are to be determined. International law leaves the members of international community free to determine whether the states to be recognized contain essential conditions of statehood. It is because of this reason that recognition is very often said to be a political diplomatic function. Theories of recognition. There are two main theories of recognition. 1. Constitutive theory, and 2. declaratory or evidentiary theory. 1. Constitutive theory. According to Oppenheim, a state is, and becomes, an international person through recognition only and exclusively. According to this theory, recognition clothes the recognized state with duties and rights under international law. Recognition is a process through which a political community acquires international personality by becoming a member of the family of nations. Hegel, Ancelotti, Holland, Oppenheim, etc. are the chief exponents of this theory. Judge Lauterpacht has written that there is a legal duty on the part of the states to recognize any community that has in fact attained statehood. As pointed out by P. E. Corbett, according to the constitutive theory, statehood and participation in the international legal order are attained by political groups only insofar as they are recognized by established states. This theory does not conform to the practice of states. In practice, most of the states accept the declaratory theory. Criticism. This theory has been severely criticized by many jurists. In practice, states do not accept any obligation to recognize a community that has attained statehood, although they may normally recognize it. According to this theory, unrecognized state can have neither rights nor duties under international law. This is a very absurd suggestion. 2. Declaratory theory. According to this theory, statehood or the authority of the new government exists as such prior to and independently of recognition. Recognition is merely formal acknowledgement through which established facts are accepted. The act of recognition is merely declaratory of an existing fact that a particular state or government possess the essential attributes of statehood as acquired under international law. The chief exponents of this theory are Hall, Wagner, Brierly, Pitt, Corbett and Fisher. Brierly has remarked that, the granting of recognition to a new state is not constitutive, but a declaratory act. A state may exist without being recognized if it exists in fact, then whether or not it has been formally recognized by other states, it has a right to be treated by them as a state. Criticism. This theory has also been subjected to criticism. The view that recognition is only a declaratory of an existing fact is not completely correct. In fact, when a state is recognized, it is a declaratory act. But the moment it is recognized, there ensue legal effects of recognition which may be said to be of constitutive nature. Conclusion. On the basis of the above discussion, it may be concluded that recognition is declaratory as well as constitutive. As pointed by Stark, the truth lies somewhere between the two theories. Oppenheim has also admitted that recognition is declaratory of an existing fact but constitutive in nature. To conclude in the words of Prof. Briggs, juridical theories of recognition deduced from jurisprudential concepts fail to explain the facts of state conduct, and induction from state conduct have failed to provide a judicial, unambiguous theory of recognition. Q. 23. What are the modes of recognition? Distinguish between de facto and de jure recognition. Ans. Modes or kinds of recognition. Following are the two kinds of recognition. 1. De facto recognition, and 2. De jure recognition. 1. De facto recognition. As pointed by Prof. Schwarzenberger, when a state wants to delay recognition de jure of any state, it may, in the first stage, grant de facto recognition. De facto recognition is given because it is doubted that the state recognized may not be stable or it may not be able and willing to fulfill its obligations under international law. De facto recognition means that the state recognized possesses the elements of statehood and is fit to be a subject of international law. According to Prof. Oppenheim, the de facto recognition of a state or government takes place when, in the view of the recognizing state, the new authority, although actually independent, has not acquired sufficient stability or does not yet offer prospects of complying with other requirements of recognition such as willingness or ability to fulfill international obligations. Further, de facto recognition is in a sense provisional and liable to be withdrawn if the absent requirement of recognition fails to materialize. Under de facto recognition, diplomatic relations are not established. 2. De jure recognition. De jure recognition is granted when, in the opinion of the recognizing state, the recognized state or its government possesses all the essential requirements of statehood and is capable of being a member of the international community. As pointed out by Prof. H. A. Smith, the British practice shows that 3 conditions precedent are required for the grant of de jure recognition of a new state or a new government. The 3 conditions are: a reasonable assurance of stability and permanence, b. the government should command the general support of the population, and c. it should be able and willing to fulfill its international obligation. Distinction between de facto and de jure recognition. As pointed out by Schwarzenberger, de facto recognized is by nature provisional and may be made dependent upon conditions which the new entity has to comply. It differs from de jure recognition in that there is not yet a formal exchange of diplomatic representatives. De jure recognition is complete, implying full and normal diplomatic relations. In Luther vs. Sagar, 1921, 3 KB 532, it was held that there is no distinction between de facto and de jure recognition for the purpose of giving effect to the internal acts of the recognized state. The majority of the jurists agree that so far as legal effects are concerned, there is hardly any distinction between the 2 types of recognition. If at all there is any difference between 2 types of recognition, it is chiefly political rather than legal. Q. 24. What do you mean by recognition of insurgency? What are the effects of such recognition? Ans. Recognition of insurgency. Insurgency presupposes a civil war or political revolt in a state. In fact, insurgency is an intermediate stage between tranquility and belligerency. Essential conditions for recognizing insurgents. Following are the essential conditions for recognition of insurgency. 1. Control over a considerable part of the territory. 2. Considerable support to the insurgents from the majority of the people living in the territory. And 3. Insurgents should be capable and willing to carry out international obligations. Effects of recognition of insurgency. Following are the effects of recognition of insurgency. 1. Insurgents are not treated as pirates. 2. The rebels of civil strife are treated as hostis generis humani, the enemy of human beings, until they are recognized as insurgents. 3. The international rules of war become applicable to them. Q. 25. What factors will govern the recognition of belligerency by a third state? What is the effect of such recognition? Ans. Recognition of belligerency. On the outbreak of rebellion or insurrection in any country, the outside powers generally maintain an attitude of non-interference in the domestic affairs of that state. However, it may frequently render it not possible for other states to maintain an attitude of indifference, either because the rebellious forces are in effective occupation of a large part of the territory of the parent government, or the actual war between the parent government and the rebellious forces has reached a stage when outside powers will not treat it merely an intermediate struggle. In such cases, the political communities struggling to attain a condition of separate statehood are accorded a de facto recognition of belligerency pending the determination of the question whether they are formally admitted to membership or are formally brought back to subjection. Recognition of belligerency is a question for the executive department of the government, whose declarations are binding on the court. Such recognition is a question of policy and not of law. It depends on various considerations, e.g., whether the belligerent community has an organized government capable of carrying on war according to recognized rules and methods, whether there exists actual war at time, and whether the interests of the state conceding such recognition are being affected by the outbreak of war. Effect of recognition. Recognition, besides conferring rights, imposes duties on the insurgent, viz., the establishment of price quotas and issue of lists of contraband. Insurgents can, therefore, be recognized belligerents only if they are capable of fulfilling their obligations to other states. The recognizing state becomes entitled to neutral rights, which are respected by rival parties. Such recognition protects the belligerents from being treated as traitors on land or pirates on the sea. It also grants immunity to the parent state for acts of omission and commission on the part of the belligerents detrimental to the recognizing states. Recognition of belligerency confers an international status on the belligerents for purposes of war. Although there is no exchange of embassy or the conclusion of a treaty, yet consuls are generally exchanged for the protection of commercial interests. The recognizing state also recognizes within its jurisdiction the flag of the revolted government and the commissions it issues. Q. 26. What do you mean by state succession? Define its kinds. Ans. Definition. Oppenheim has described state succession in the following words. A succession of international person occurs when one or more international persons take place of another international person, in consequence of certain changes in the latter's conditions. State succession. There is a succession of states where the territory of one state passes from its supremacy to that of another. A state may succeed another state by incorporating a certain portion of the latter's territory. It may be split up into two or more states. Or new states may emerge out of the territory of a dismembered state, as happened to the territory of Austro-Hungarian monarchy as a result of the First World War. or to the territory of German Reich as a result of the Second World War. In other words, the succession of state implies the substitution of one state for another. The succession is of two kinds, viz., universal and partial. Universal succession. There is universal succession, i.e., when one state is completely absorbed by another as a result of annexation or conquest, i.e., the South African Republic was annexed by Great Britain in 1900. Korea by Japan in 1910 and Abyssinia by Italy in 1936. When several states agree to merge into a federal state or union, e.g., in 1871 the German states united together to form the German Empire. The merger of Egypt and Syria on the 22nd of February 1958 and later Yemen on the 22nd of March 1958, to form the United Arab Republic of Egypt and Syria, or the merger of Iraq and Jordan on the 14th of February 1958, to form the Arab Federal State, and when one or more states are formed or one or more international persons take the place of another international person by division of a former single state or international person. Each of the independent states being a successor state, e.g., the division of India into India and Pakistan in 1947. Partial succession. Partial succession arises, by succession, when another state is established by a part of the territory breaking off from the parent state and thereby gaining independence, e.g., the separation of the United States from the parent state Great Britain in 1776. By cession or conquest, when one state acquires a part of the territory of another state and assumes sovereignty over the portion ceded, e.g., cession of California to the United States in 1847. By dismemberment. When a full sovereign state loses part of its independence through incorporation into a federal state or coming under the suzerainty or protectorate of a stronger power, or when a not full sovereign state, i.e., a suzerain or protectorate or even a member of a federal state, becomes full sovereign, e.g., Czechoslovakia was dismembered in 1938 as a result of the Munich Agreement. There is a considerable body of authority among the text writers inclined to the view that the successor state is bound by the contracts of the extinct state. The new state becomes liable for all local debts and contractual obligations. The earlier view is laid down by an English court in West Rand Central Gold Mining Company Limited versus Rex that the sovereign of a conquering state was not bound by the obligations incurred by the conquered state, has undergone substantial change, and modern practice has tended to modify the rigidity of this doctrine of non-succession. The Permanent Court of International Justice in the German settlers' case held that private rights acquired under existing law, including those acquired from the state as the owner of the property, are valid as against a successor in sovereignty, i.e., they do not cease on a change of sovereignty. The successor state is, however, justified in refusing to own the obligations of the ceded state which the latter incurred for the purpose of war against the former. Contracts, however, purely personal to the extinct state. do not survive purpose distinctly against the interests of the inhabitants of the territory transferred or contracted for financing of wars or other hostile undertaking against the successor state. Arrangements with respect to public debts are usually made in treaties. 6. The succeeding states are under no liability for the delicts of the extinct state. The Robert E. Brown claim. 7. Succession to property lying in foreign state. The successor state may claim any state property in the territory over which it acquires sovereignty. 8. Laws. The civil law of the former sovereign continues unless changed by the successor state. Public law, however, changes simultaneously with the transfer of sovereignty. Whatever public law continues to remain in operation after a territorial transfer derives its force as a positive law owing to its acceptance by the acquiring state. 9. Nationality. As regards nationality, the inhabitants of the ceded or vanquished territory become subjects of the annexing state and lose citizenship of the former state. Usually a certain period of time is allowed to the inhabitants to elect for themselves as to which state they want, or their allegiance. Q. 27. As a result of civil war, a province X secedes from the parent state and is recognized as independent. Consider the effect of this on a. The public debt of the parent state, b. Treaty rights and obligations binding the parent state, and c. Mining concessions in X granted by the parent state to subjects of other powers. Uns. Secession from parent state. In the absence of treaty or insofar the provisions of the treaty may not extend, the following consequences ensue. A. The new state X will become liable for all debts locally connected with such territory, e.g., debts charged on local revenues or on revenues charged on property situated within the territory. The new state will not incur any legal liability to the general debts of the parent state, unless otherwise provided for by the treaty. B. The new state X will not be liable under, or entitled to, any personal treaties relating exclusively to the persons of the contracting parties, e.g., treaties of alliance, arbitration or neutrality. But it will succeed to any treaties specifically relating to the territory comprised in the new state, such as treaties relating to the boundary or regulating the navigation of rivers flowing through its territory. C. The succeeding state is obliged to respect the concessionary rights which were legitimately conferred by the parent state. Such concessionary rights, especially the mining concessions, can be regulated and modified by the new state within its legislative competence so far as it relates to aliens and deal with them at its discretion. Q. 28. As a result of the pressure of War 10, a part of the state Y is ceded to Z, another neighboring state. Discuss its consequences on a. The public debt of the ceded part 10. B. Treaties and political obligations binding the ceded part. C. Mining concessions in the territory of the ceded part granted to aliens. And d. An injury in the nature or a tort or delict committed by an official of the ceded part affecting an alien. Uns. Cession of territory. In the case of cession of territory, the question of succession is generally dealt with in a treaty, but in its absence the following are the rights and obligations to the transferred state. Two contingencies may arise in the case. If the government of the absorbing state be a federal state not annexing X as an integral portion of its territory and maintaining the internal sovereignty of the constituent states, X will retain its internal sovereignty and the rights and obligations of X will inhere in the part ceded. But such debts or obligations will be enforceable only through the government of the Union. Treaties inconsistent with the terms of the federal state will extinguish, but personal treaties, e.g., extradition treaties, may remain operative if not inconsistent with the central government or not denounced by it. If, however, the absorbing state Z is a united government so as to completely extinguish the identity of X, the consequences will be: A. The absorbing state will be liable for all civil obligations, including the public debt of the ceded part without regard to the value of the assets received. B. Treaties and political obligations binding the ceded part will not be enforceable except treaties locally connected with the territory of the part absorbed. C. Mining concessions granted to foreigners in the ceded part will not be binding on the state. D. The succeeding state is under no liability for the delicts of the extinct state. West Rand Central Gold Mining Company vs. The King, 1905, 2 KB 391, and Robert E. Brown Claim, American Journal of International Law, 1926, Vol. 20, page 328. Q. 29. What do you understand by intervention? State briefly the just grounds for intervention. Or, in what circumstances may a state exercise its right of intervention to protect persons, property and interests of its subjects abroad? Ans. Intervention. Oppenheim calls intervention as dictatorial interference by a state in the affairs of another state for the purpose of maintaining or altering the actual condition of things. Mere friendly advice and general political influence do not strictly come under this term as the essential requisite of intervention, viz., use of force or a threat to use force, is lacking in them. Kinds of intervention. There are three different kinds of intervention, viz. 1. Internal. It is the interference by one state between disputing sections of the community in another state either for protection of the legitimate government or the insurgents. 2. External. It is the intervention by one state in the relations generally of the hostile relations of other states. It is, in other words, an intervention in the foreign affairs of another state, such intervention being directed against hostile relations of such state. 3. Punitive. It is a punitive measure falling short of war and is in the nature of a reprisal for an injury suffered at the hands of another state. Legal occasions of intervention. According to Prof. Briefly, the strictly legal occasions of an intervention may be brought under three heads, viz., self-defense, reprisals and the exercise of a treaty right. There are few interventions which can be justified by right and as such are not violations by the intervening state of the independence of another. They are discussed below along with other grounds which may not afford a reasonable justification for intervention. 1. Self-preservation. The supreme interest of the state overrides law. The right of self-preservation is more sacred than the duty of respecting the independence of other states. A state has a right to interfere in the affairs of another state where the security and immediate interests of the former are compromised. Interventions, therefore, in order to ward off imminent danger to the intervening state are justified by the force of circumstances. The danger must be direct and immediate, not contingent and remote. Further, the immediate cause for intervention must be sufficiently important to justify war. And, lastly, the necessity of self-defense must be instant, overwhelming, leaving no choice of means and no time for deliberation. The Caroline. 2. Enforcement of treaty rights. A state is justified in interfering in the affairs of another state if the provisions of any treaty oblige the former to preserve the independence or neutrality of the latter. Such intervention does not violate any right of independence because the state that suffers has conceded such liberty of interference by treaty. Invitational intervention. As regards invitation by the lawful government of the state to intervene in its internal affairs, the matter is not free from difficulty. It is again highly controversial whether the invitation from the government could be legitimately regarded as from the lawful government in such cases. The most conflicting intervention has been the involvement of the United States and other states in the Vietnamese conflict. Although many writers, notably American, have justified the United States intervention in that conflict as a lawful intervention. It cannot be denied that the civil war in that case had been sponsored, aided and promoted by the United States of America, much to the woe of Vietnamese. This intervention may be said to be the outcome of the policy of maintenance of balance of power in the region. 3. Grounds of humanity. Another justification for intervention is based on the ground of humanity. Lawrence observes that in the opinion of many writers such interventions are legal, but they cannot be brought within the ordinary rules of international law, which does not impose on the state the obligation of preventing barbarity on the part of their neighbors. The barbarities committed in East Bengal by the government of Pakistan in the name of a united Pakistan following a civil war towards the end of March 1971 were unprecedented. And in spite of the loud proclamations of the United Nations, established with the pious object of saving succeeding generations from the scourge of war and establishing conditions under which justice and respect for the obligations arising from international law can be maintained. It did not take cognizance of the serious situation encompassing East Pakistan until the breaking out of war between India and Pakistan in the early part of December 1971. When also it completely ignored the basic cause of Bangladesh tragedy. The brutal and unprovoked killings by West Pakistani forces and barbarities were in the teeth of the provisions of the Convention on the Prevention and Punishment of the Crime of Genocide, 1948. 4. Intervention to prevent illegal intervention. Intervention undertaken for the purpose of prevention or ending illegal intervention on the part of another state is regarded lawful. 5. Balance of power. Preservation of the balance of power has been an undoubted maxim of European diplomacy from the middle of the 17th century. It is condemned by jurists of all ages. 6. Protection of persons and property. Protection of the persons, property and interest of its nationals abroad or defense of national honor may provide justification for intervention. The necessity for protection may arise due to gross injustice or due to injury caused by unfair discrimination. Such persons are primarily subjects to the local law, but they may claim their own state's protection on account of unworthy treatment. Such right of intervention is afforded on the ground of international comity and tolerance with which a state is expected to comply. 7. Collective intervention. Collective intervention pursuant to Chapter 7 of the Charter undertaken under the authority of the Security Council may afford another reasonable ground of intervention. Q. 30. That intervention is, as a rule, forbidden by the law of nations which protects the international personality of the states, there is no doubt. On the other hand, there is just as little doubt that this rule has exceptions. Oppenheim. Discuss and illustrate the foregoing statement. Ans. Intervention. Professor Oppenheim observes that intervention is, as a rule, forbidden by the law of nations, but there are circumstances where interventions take place by right and still there are cases where, although they do not take place by right, are nevertheless admitted by the law of nations, and are excused in spite of the violation of the personality of the respective states which they involve. Right or intervention. Oppenheim mentions 7 reasons when a state may have a right of intervention against another state, viz. 1. A state which holds a protectorate has a right to intervene in all the affairs of the protected state. 2. If an external affair of a state is at the same time by right of an affair of another state, the latter has a right to intervene, in case the former deals with that affair unilaterally. 3. If a state which is restricted by an international treaty in its external independence or its territorial or personal supremacy does not comply with the restrictions concerned, the other party or parties have a right to intervene. 4. If a state in time of peace or war violates such rules of the law of nations as are universally recognized by custom or are laid down in law-making treaties, other states have a right to intervene and to make the delinquent submit to the rules concerned. 5. A state that has guaranteed by treaty the form of government of another state, or the reign of a certain dynasty over the same, has a right to intervene in case of a change of form of government or of dynasty, provided that the treaty of guarantee was concluded between the respective states and not between their monarchs personally. 6. The right of protection over citizens abroad, which a state holds, may cause an intervention by right to which the other party is legally bound to submit. 7. Finally, the Covenant of the League of Nations provided, as does the Charter of the United Nations, for the collective intervention of the member states for the purpose of restraining states which disturb the peace of the world by resorting to war or force generally or to threats of force in breach of the provisions of the Covenant. In contradistinction to intervention by right, Professor Oppenheim observes, there are other interventions which cannot be considered illegal, although they violate the independence or the territorial or personal supremacy of the state concerned. And although such state has by no means a legal duty to submit patiently and suffer the intervention. They are of two kinds, viz., intervention in self-preservation and intervention which is necessary in the interest of the balance of power. Q. 31. Write short notes on a. The Monroe Doctrine, b. Drago Doctrine, and c. The Brezhnev Doctrine. Ans. A. The Monroe Doctrine. The doctrine embodies a principle of American policy enunciated by President Monroe of the United States in 1823, declining any European intervention in political affairs of the American continent. It was never affirmed by Congress nor made the subject of a treaty, and as such is not a rule of international law. The declaration was to the following effect. 1. The American continents, by the free and independent condition which they have assumed and maintained, are henceforth not to be considered as subjects for future colonization by any European powers. 2. In the wars of the European powers, in matters relating to themselves we have never taken any part, nor does it comport with our policy to do so. 3. The United States had not intervened, and never would intervene, in wars in Europe, but they could not, on the other hand, in the interest of their own peace and the happiness, allow the allied European powers to extend their political system to any part of America, and to try to intervene in the independence of the South American republics. We should consider any attempt on their part to extend their system to any portion of this hemisphere as dangerous to our peace and safety. The Monroe Doctrine, as observed by Oppenheim, is largely of political and not legal character. It established a fundamental principle of American policy by declaring that there must be no territorial agreement by any non-American power on American soil, and also embodying the non-intervention by the United States in European policies. It asserts a claim of political hegemony by USA over the whole American continent. B. Drago Doctrine. The Foreign Secretary of the Republic of Argentine, Luis M. Drago, in 1902, at the time when Venezuela had been pacifically blockaded by Great Britain and Germany, on behalf of their nationals, expressed the opinion that a state should not have recourse to armed force for the recovery of contract debts claimed from the government of one country by another as being due to its subjects. He observed that the failure of a state to make payment of its public debt did not give rise to the right of intervention. Drago's objections were confined to the use of armed force in the collection of public debts only. This view was incorporated in the Second Hague Convention, 1907, but was qualified by the addition that armed intervention could apply when the debtor either refused arbitration or failed to submit to the award. C. The Brezhnev Doctrine. The communist countries, notably the USSR, have evolved a new socialist international law overriding the conventional law, which takes into account new developments in international relations. Lenin first propounded this theory in February 1918 by stating that the interests of socialism are higher than the interest of the right of nations to self-determination. The doctrine, which bears the name of the author, was propounded by L.I. Brezhnev, General Secretary of the CPSU, at the Fifth Congress of the Polish Communist Party on November 12, 1969. Which affirms that when internal and external forces hostile to socialism attempt to turn the development of any socialist country in the direction of the restoration of the capitalist system, there is a threat to the security of socialist Commonwealth as a whole. This doctrine has received trenchant criticism from independent nations. The USSR's intervention in Czechoslovakia in August 1968 was deplored by all right-thinking people of the world, and only proved that, until a more equitable order was established, the smaller states would only serve as factors in the grand design of the superpowers. Q. 32. What do you mean by territorial jurisdiction? What are the limitations on territorial jurisdiction? Ans. Territorial jurisdiction. Jurisdiction of a state over its territory is called territorial jurisdiction. It implies that a state enjoys civil as well as criminal jurisdiction over all persons and things within the territory of a state which falls under its territorial jurisdiction. The principle of territorial jurisdiction extends to land territory within boundaries, internal waters, territorial sea, airspace above the land territory and subsoil under earth. To exercise jurisdiction by state over its territory is a right of state. Limitations on territorial jurisdiction. It is to be noted that a state has an exclusive jurisdiction over the territory. However, exclusive jurisdiction of a state within its own territory is not absolute. Certain limitations have been imposed upon the rule of territorial jurisdiction which have developed partly through customs and partly by the conclusion of treaties. 1. Diplomatic agents. Diplomatic agents enjoy privileges and immunities from the civil and criminal jurisdiction of the receiving state. Since a long time, there appears to be general agreement that a diplomatic agent, during the term of his office, is totally exempt from both criminal and civil jurisdiction in the state where he is accredited. 2. Embassies. Embassies situated in other states are immune from the jurisdiction of the state. The agents of the state cannot enter in the foreign embassies except with the consent of the head of the mission. 3. Foreign sovereigns. Foreign sovereigns enjoy immunities and they are exception to the principle of territorial jurisdiction. No local jurisdiction, whether criminal or civil, could be exercised over them. Under general international law, immunity granted to foreign sovereigns includes immunities to head of states, prime minister, ministers residents acting in their official capacity, ministers, departments, agencies and offices. 4. Property of foreign sovereigns. The property of the foreign sovereigns remains immune from the jurisdiction of the state. As long as the foreign sovereign has some interest in the property, it remains immune, and it is immaterial for what purpose the property was employed. 5. Foreign armed forces. Armed forces of a state remain in the foreign territory on several occasions in the service of their home state. Such forces are considered by some to be extraterritorial, and therefore they remain under the jurisdiction of the state to which they belong. Q. 33. Discuss international rivers and interoceanic canals. Or, write short notes on I. Suez Canal, E. Kiel Canal, Panama Canal. Uns. Maritime territory. Beyond inland waters, the sovereignty of a coastal state extends to maritime belt or territorial waters. Besides territorial waters, the coastal state also exercises sovereign rights, for certain limited purposes, over continent held, exclusive economic zone and contiguous zone. Each of these maritime zones has been briefly discussed in a separate chapter entitled, The Law of the Sea. International rivers. Rivers which run through several states are described as "non-national rivers". Such rivers are owned by more than one state. Each state owns that part of the river which runs through its territory. Rivers which are navigable from the open sea and pass through several states, between their sources and mouths, are called "international rivers". They are termed international, because freedom of navigation in time of peace on all such rivers in Europe and on many of them outside Europe for merchantmen of all nations is recognized by conventional international law. As regards the utilization of flow of waters of non-national and international rivers, Oppenheim has pointed out that it is not within the arbitrary power of one of the riparian states, for it is a rule of international law that no state is allowed to alter the natural conditions of its own territory to the disadvantage of the natural conditions of the territory of a neighboring state. Reference may also be made here to the Indus Waters Agreement signed on the 19th of September 1960 by India, Pakistan, and the International Bank for Reconstruction and Development for regulating the use of the waters of Indus, Chenab and Jhelum rivers. This further confirms that in the absence of a treaty or agreement there can be no definite obligation of a riparian state in respect of the use of waters of a river. Interoceanic canals. Interoceanic canals are the canals which connect international waterways and are available for the shipping of all states. Their use and control are governed by international treaties. The most important of oceanic canals are the following. 1. Suez Canal. It is the most famous interoceanic canal. In the beginning, it was under the control of French government. Later on, it came under the control of British government in 1954. A treaty was concluded between British and Egypt whereby Britain withdrew its forces from the Suez Canal. In 1956, Suez Canal was nationalized by Egypt. France, Britain and Israel reacted strongly against this action of Egypt and made a joint armed intervention to prevent Egypt from nationalizing the Suez Canal. The problem was resolved through the efforts of Russia, Security Council and the General Assembly. Subsequently, an agreement was entered into whereby it was provided that the Suez Canal remain aloof from international politics and all the states shall have the right of shipping over this canal. However, Egypt would be entitled to realize taxes from the ships passing through the canal. In the Arab-Israel conflict, the canal was greatly damaged and had to be closed for several years. After the ceasefire between Israel and Egypt, the latter cleared the canal. But later on it was again opened for shipping etc. by states. 2. Kiel Canal. It is another important interoceanic canal connecting Baltic Sea and North Sea. In the beginning this canal was under the control of Germany. After the First World War, it was thrown open for all the states. A leading case relating to Kiel Canal is SS Wimbledon, PCJI, 1923, Series A, Number 1, WCR 163. In this case, the Permanent Court of Justice held that the canal should remain open for all the states who are not at war with Germany. If some states are on war and Germany remains neutral in that war, even then the canal should remain open for such states. The facts of this case are as follows. On March 21, 1921, the German authorities stopped a British ship named SS Wimbledon on the ground that it contained military equipments being shipped to Poland, who was at war at that time with Russia. The German authorities contended that allowing the ship to pass through the Kiel Canal would amount to violation of the German neutrality. The prominent Allied nations filed case against Germany in the Permanent Court of International Justice. Deciding in favor of the Allied nations, the World Court held that under Article 380 of the Treaty of Versailles, Germany was bound to allow the passage through Kiel Canal to the SS Wimbledon. The court, therefore, ordered that Germany should pay compensation for violation of its treaty obligations. 3. Panama Canal. Panama Canal connects Atlantic Sea with the Pacific Sea. Under the Treaty of 1901, the Panama Canal came under the control of United States of America. This is a very important canal for commercial and transport purposes. Recently there has been a lot of controversy between Panama and America regarding the control and use of this canal. In March 1973, the Security Council held a session on Panama. In the said session a proposal was brought which could have removed the control of America over this canal. But this proposal was vetoed by America. America, however, expressed desire to enter into fresh treaty with Panama in connection with the use and control of this canal. Subsequently, Panama and the United States agreed on certain principles regarding the use and control of the canal, and on the basis of the said principles, they hope to enter into a treaty in near future. After prolonged negotiations for more than 3 years, the USA and Panama finally signed on 7 September 1977 two treaties, a treaty guaranteeing the permanent neutrality of the canals, and a basic treaty governing the use and defense of the canal through December 1999. Changing the status of the Panama Canal. One of the two treaties provides that the USA will turn over control of the canal and the canal zone to Panama by the end of this century. The other treaty allows the USA to defend the strategic waterway if needs be, for an indefinite period. The treaties guarantee the permanent neutrality of the canal. Q. 34. What are the various modes of acquiring territories? Discuss with relevant case. Ans. Modes of acquiring territories. Following are the modes of acquiring territories under international law. 1. Occupation. According to Stark, occupation consists in establishing sovereignty over a territory not under the authority of any other state, whether newly discovered or an unlikely case abandoned by the state formerly in control. A leading case regarding occupation is Island of Palama's arbitration, 1929, award of the Permanent Court of Arbitration, 1929, Hinson case page 361. See also Agil, Vol. 1968, pp. 867 to 912. In this case there was a dispute between America and Netherlands over the island of Palamas. America claimed to have acquired it under a treaty of 1898 with Spain. This island was discovered by the Spaniards. On the other hand, Netherlands claimed to have occupied it since 1700. According to the Court of Arbitration, Island of Palamas was a part of Netherlands because although it was discovered by Spaniards, they never occupied it and established contracts with the inhabitants of the island. Thus, for occupation of a territory it is not sufficient to have an intention to establish sovereignty over the territory concerned. It is also necessary to make some actual exercise of such authority. 2. Prescription. Yet another mode of acquiring territory is by prescription. In words of Stark, title by prescription is the result of peaceable exercise of de facto sovereignty for a very long period over a territory, subject to the sovereignty of another state. But international law does not prescribe any fixed period for prescription. As pointed out by an eminent writer, D.H.N. Johnson, a state may acquire some territory by prescription only when the following conditions are fulfilled. I. When it has not accepted the sovereignty of any other state over the said territory. E. Possession should be peaceful and uninterrupted. E. Possession should be in public. IV. Possession should be for a definite period. D.H.N. Johnson, Acquisitive Prescription in International Law. BYBIL. Vol. 27, 1950, page 332 at pp. 335, 344 to 347. It may, however, be noted that in the presence of some treaty or convention, territory cannot be acquired by prescription through administrative acts only. See Frontier Lands Case, Belgium Netherlands, ICJ Representative. 1959, page 209. Temple of Prayer Vihar, Merits, Cambodia vs. Thailand, ICJ Representative, 1962, page 6. 3. Accretion. As pointed out by Stark, title by accretion occurs when new territory is added mainly through natural causes to territory already under the sovereignty of the acquired state. No formal act or assertion of title is necessary. IV. Cession. Territory may also be acquired through cession. It may either be a voluntary act or in consequence of a war. Cession is generally considered valid only when the sovereignty of the territory concerned is transferred to another state. In Re. Berubari Union and Exchange of Enclave, Air 1960 South Carolina 845 at pp. 856 to 57, the Supreme Court of India observed. It is an essential attribute of sovereignty that a sovereign state can acquire foreign territory and, in case of necessity, cede a part of its territory in favor of a sovereign state, and this can be done in exercise of its treaty-making power. Cession of national territory in law amounts to the transfer of sovereignty over the said territory by the owner state in favor of another state. This power, it may be added, is of course subject to the limitations which the constitution of the state may either expressly or by necessary implication impose in that behalf. In Union of India vs. Sukumar Sengupta, Hare 1990, South Carolina 1692. Popularly known as Tin Bigha case. Tin Bigha area was given to Bangladesh by India under the 1974 and 1983 agreements to connect Dahagram with Panbri Moza, S. Patram, of Bangladesh. As per agreement, lease in perpetuity was given over the area at the rate of Rs.1/2 per annum, but the Government of India waived its right to charge such rent in respect of the leased area. The agreement provided that sovereignty over the leased area shall continue to vest in India. Delivering the judgment, Sabyasachi Mukherjee, CJ observed, "A fortiori, the said transaction did not amount to cession of the said area of Tin Bigha in favor of Bangladesh. Cession as understood in international law would result in an actual and physical transfer of the said area to Bangladesh, following which Bangladesh would have the exclusive right to treat the said transferred territory as part of its own territory and exercise full control, dominion and right over the same. This is not the position or the situation which is contemplated under the agreement. The rights intended to be conferred on Bangladesh under the said agreements would amount to what is known as servitude in international law, Hare 1990 SC 1692, at page 1706. v. Annexation. A territory may also be acquired by annexation. It is, however, necessary that after conquest, sovereignty must be established over the territory. That is to say, effective occupation after conquest is necessary. This mode has become obsolete after the commencement of the Charter of the UN. Article 2.4 of the Charter makes it incumbent upon member states to refrain in their international relations from threat or use of force against the territorial integrity or political independence of any state, or in any other manner inconsistent with the purposes of the United Nations. In view of this provision, acquisition of territory by annexation is no more legal. A recent example of this is the annexation of Kuwait by Iraq. After annexation, Iraq declared Kuwait to be its 19th province. But the Security Council of the UN declared the annexation of Kuwait as well as the said declaration of Iraq as null and void. Subsequently, Kuwait was freed. v. Lease. Yet another mode of acquiring territory is by way of lease. A state may lease a part of its territory to another state. For example, State of Malta has leased an island to Britain for some time. Similarly, Panama leased Panama Canal area to the USA. 7. Pledge. Sometimes a state may pledge a part of its territory to another state in return of some money. 8. Plebiscite. There is controversy as to whether a territory may be acquired through plebiscite or not. A recent example of acquiring territory by this mode is that of West Iran, which was claimed both by Netherlands and Indonesia. A plebiscite was held under the auspices of United Nations. The people of West Iran decided to merge with Indonesia. Example of Kashmir. In case of Kashmir, Pakistan has claimed that there should be plebiscite so as to enable the people of Kashmir to decide whether they like to merge with India or with Pakistan. In the beginning, India had agreed to hold plebiscite was necessary. Some jurists contend that the right of plebiscite is related to the right of self-determination expressed in the Charter of the United Nations. Thus, so far as legal position is concerned, plebiscite has yet to become an obligatory norm of international law. India cannot, therefore, be rightly blamed for violating the rules of international law. Acquisition of territorial sovereignty by newly emerged state. Yet another method of acquiring territorial sovereignty is through the emergence of a newly independent state. This is particularly true in case of those states who were previously the colonies of some states. In this connection, the difficulty is how the territory which was previously part of another state can acquire sovereignty after becoming independent. This has been aptly explained by Stark in the following words: "This abstract difficulty may be resolved by treating the people of the territory as such, provided they have sufficient degree of political maturity, as having or acquired sovereignty pending attainment of statehood. Upon the foundation of new state, there is simply a crystallization of the situation, territorial sovereignty of the people then becoming that of the state itself." Q. 35. Differentiate between occupation and subjugation. Ans. Distinction between occupation and subjugation. As pointed out by Prof. Oppenheim, occupation is a mode of acquisition which differs from subjugation chiefly in that the subjugated territory previously belonged to another state. Thus, while in the case of subjugation the territory previously belonged to another state, in case of occupation it did not belong to any other state. Q. 36. What are the various modes of loss of territory? Ans. Modes of loss of territory. Following are the modes through which a territory may be lost. 1. Cession. As one state acquires the territory through cession, the other state loses it. 2. Operation of nature. Sometimes a state may lose its territory through the operation of nature such as earthquake, etc. 3. Subjugation. A state may acquire territory through the operation of nature. 4. Prescription. When a state occupies a particular territory for a long period, then it is entitled to acquire it through prescription. On the contrary, the state which had occupation over it earlier may lose it. 5. Revolt. Sometimes a state may lose its territory and a new state may emerge. For example, as a result of revolt, Pakistan lost the territory of East Pakistan and a new state of Bangladesh emerged. 6. Dereliction. When a state renounces a part of its territory or fails to exercise or slackens to exercise sovereignty over it, then it may lose such territory. Such examples are, however, very rare in history. 7. Losing a territory by granting of independence to a colony. Britain, France and other imperialist states lost territories during last few decades by granting independence to colonies, or otherwise acquiring of independence by the colonies. Q. 37. Discuss the accession of Kashmir in the light of international law. Ans. Legal implications of the accession of Kashmir, Jammu and Kashmir, the northernmost state of India, borders on the USSR. Sinkiang and Tibet in the north and northeastern Pakistan on the west and southwest. Before the dawn of independence, Kashmir, like other Indian states, was directly under the suzerainty of His Majesty the King of England. With the passing of the Independence Act, 1947, by the British Parliament transferring power to Indian hands, there lapsed the suzerainty of the Crown over the Indian states, and the Indian states were left free to join either the Indian Dominion or the Dominion of Pakistan. The ruler of Kashmir was at liberty to choose the future constitutional status of the state. Shortly after the conclusion of the standstill agreement with Pakistan for the continuance of the economic and administrative relations as also to maintain communications, supplies, etc. on the same basis as existed before the partition of India, the government of Kashmir complained that the Pakistan authorities were withholding supplies of commodities like food grains, salt, sugar and petrol by denying transport facilities. This conduct on the part of the government of Pakistan gave ground for a legitimate apprehension that pressure was being brought on Kashmir for its accession to Pakistan. The strong economic pressure resorted to by Pakistan in the beginning later assumed the form of a full-scale blockade against Kashmir. In September 1947, there was concentration of tribesmen at the northwest frontier province, who along with the western Punjab Muslims trekked into the villages on the border of Kashmir and committed loot, arson and murder. The Kashmir government lodged a strong caveat with the government of Pakistan through whose territory the raiders entered Kashmir, but it was of no avail. The raiders were highly organized and soon they occupied a large portion of Kashmir territory in the Poonch area and threatened the occupation of Srinagar. This mass invasion of tribal people, aided and abetted by Pakistan, placed the government of Kashmir in a very difficult predicament. They felt that they were unequal to the task and without outside assistance they could not resist the tribal onslaught on the independence of their state. Accordingly, the Maharaja of Kashmir appealed to the Government of India for military aid. India had no jurisdiction to intervene in the internal affairs of the Kashmir state without its accession to India. To overcome the difficulty, on the 26th of October, 1947, the Maharaja in concurrence with Sheikh Abdullah, President of the National Conference, offered to accede the state of Kashmir to India. The Indian Independence Act, 1947, did not provide for the consultation of the wishes of the people of the princely states in order to determine the question of accession to either dominion. And as such India was free to accept the offer of the Maharaja of Kashmir acceding the state to India as final. On the 27th of October 1947, India accepted the accession of Kashmir, by which Kashmir became an integral part of India. But for political rather than constitutional reasons, India volunteered that the accession should be subject to a plebiscite of the people to be held after the restoration of normal conditions in the state. The Indian Prime Minister observed that India could not finalize anything in a moment of crisis and without the fullest opportunity being given to the people of Kashmir to express their wish. It is, however, to be noted that above declaration by the Prime Minister of India was made after the acceptance of the accession, and accession was not made subject to that condition. In February 1954 the Kashmir Constituent Assembly finally decided to accede to the Indian Union, thus ending a state of suspense, instability and uncertainty which impeded the progress of the people of Kashmir. It is often argued that after August 15, 1947, the state of Jammu and Kashmir became an independent state and its negotiation about the accession of the state to India assumed the character of an international treaty between two sovereign states. Even assuming that position to be correct, the principles of international law governing treaties will apply to the instrument of accession. International law is explicit that the contracting parties cannot revoke the treaty obligation unilaterally unless it becomes obsolete owing to force majeure and impossibility of performance or due to vital change of the circumstances. The accession of the state to the Indian Union was further strengthened when the state of Jammu and Kashmir sent its representatives to the Constituent Assembly of India and accepted the Constitution of India. It thereby became a member state of the Indian Union. The undertaking given by the Prime Minister of India that the matter of accession could be reaffirmed or cancelled or cut by the people of Kashmir if they wished to, can at best only have moral value and has no semblance of any legal character. The accession of the state of Jammu and Kashmir was unconditional. It was not subject to any plebiscite. Q. 38. Discuss the 5 freedoms of the air. To what extent are they observed by powers? Ans. 5 freedoms of the air. At the International Civil Aviation Conference held at Chicago in November 1944, an attempt was made to arrive at an agreement on commercial air traffic rights and the enlargement of the horizon of international civil aviation. The United States, the largest operator of international airlines, advocated very elaborate rights of aircraft undertaking transcontinental and transoceanic aviation, which have come to be known by the name of the 5 freedoms of the air. These are: 1. To fly foreign territory without landing. 2. To land for non-traffic purposes, e.g., to repair a machine. 3. To disembark in a foreign country traffic originating in the state of the origin of the aircraft. 4. To pick up traffic from the state whose territory is used for landing destined for the state to which the aircraft belongs. 5. To take on traffic from the state whose territory is used for landing for any contracting state, or disembark traffic on that territory coming from any contracting state. Only 19 states appended their signatures to the convention embodying the 5 freedoms of the air. Great Britain and some other states did not agree to the convention unconditionally and instead proposed an international control authority to apportion the world's air traffic equitably between all states. Canada supported by stating that the first 4 freedoms be controlled and regulated by an international body that would allocate frequencies to states with agreed principles. There thus emerged 2 different groups, one group adhering to the 5 freedoms of the air, i.e., favoring free competition, and the other adhering to the proposal of an international control over the enjoyment of these freedoms. The result was that the Chicago Conference failed to bring about a rapprochement between the competing and conflicting principles of air navigation. The matter was left to the states to enter into bilateral agreement for evolving harmony to the divergent rules. Finally, in 1946 the United States withdrew its name from being a party to the Five Freedoms Agreement and entered into an understanding with Great Britain by means of the Bermuda Agreement the same year, whereby it was made clear that an international regulation and control of air traffic was still a thing of the future. Q. 39. Writ short notes on A. The continental shelf. B. International servitude. Uns. A. Continental shelf. The International Law Commission has defined the continental shelf as that part of the seabed continuous to the coast, but outside the areas of marginal seas, where the depth of the superjacent waters admitted of the exploitation of natural resources of the seabed and subsoil. The Commission has provided that the coastal states might exercise control and jurisdiction for the purpose of exploiting the natural resources of the shelf. But the legal status of the superjacent waters and of the air space above might not be affected thereby. The main reason for the present near chaos of the law of the sea seems to be the elastic definition of the outer boundary of the continental shelf given by the relevant Geneva Convention. B. International servitude. Stark defines an international servitude as an exceptional restriction imposed by treaty on the territorial sovereignty of a particular state whereby the territory of that state is put under conditions or restrictions serving the interests of another state. Servitude may either be positive or negative in character. The former means that a state has a right to perform acts on the territory of another state. The latter connotes that the state bound by the servitude must refrain from doing something on that territory or abstain from exercising its territorial rights in some ways. Oppenheim mentions two more kinds of servitudes, viz., military and economic. The former is a servitude acquired for military purposes, such as the right to keep troops in foreign territory. The latter is a servitude which is acquired for the purpose of commercial interests. Q. 40. What do you mean by hijacking? Discuss aircraft hijacking with a case law. Uns. In wider sense, hijacking is an act against the safety of traffic in the air, is comparable to piracy, an act against the safety or traffic on the open sea. Article 1 of the Hague Convention, 1970, contains the concept of hijacking in the following words. Any person who on board an aircraft in flight, a. unlawfully, b. force or threat thereof, or by any other form of intimidation, seizes or exercises control of that aircraft, or attempts to perform any such act, or b. is an accomplice of a person who performs or attempts to perform any such offense. This provision again, instead of defining the term hijacking, simply enumerates the constituent elements of hijacking. The concept of hijacking has been further widened in the Montreal Convention 1971. Article 1 of the Montreal Convention provides 1. Any person commits an offense if he unlawfully and intentionally a. Performs an act of violence against a person on board an aircraft in flight if that act is likely to endanger the safety of that aircraft, or b. Destroys an aircraft in service or causes damage to such an aircraft which renders it incapable of flight or which is likely to endanger its safety in flight, or c. Places or causes to be placed on an aircraft, in service, by any means whatsoever, a device or substance which is likely to destroy that aircraft, or to cause damage to it which renders it incapable of flight, or to cause damage to it which is likely to endanger its safety in flight, or d. Communicates information which he knows to be false, thereby endangering the safety of an aircraft in flight. 2. Any person also commits an offense if he a. Attempts to commit any of the offenses mentioned in paragraph 1 of this article, or b. Is an accomplice of a person who commits or attempts to commit any such offense. Hijacking of an Indian aircraft in the ICAO jurisdiction case. On January 30, 1970, two persons hijacked an Indian aircraft to Lahore, Pakistan. Instead of apprehending and punishing them, the government of Pakistan encouraged them. Consequently, the hijackers burned the aircraft at the airport, and this incident was shown to the people of Pakistan through television. Thus Pakistan flagrantly violated Article 11 of the Tokyo Convention. It was also the violation of the United Nations Security Council Resolution 286, 1970, which called on states to take all possible legal steps to prevent further hijacking or any other interference with international civil air travel. Consequently, India banned all Pakistani flights through her territory. Pakistan filed a complaint in the Council of the ICAO against this. On the other hand, India filed an application in the International Court of Justice challenging the jurisdiction of the Council of ICAO to hear and decide Pakistani complaint. ICJ Reports 1972, pp. 46 ff. It was argued on behalf of India that India, being a sovereign state, is fully entitled either to allow or not to allow overflights of aircraft of other countries through her territory. But Pakistan challenged the jurisdiction of the World Court to hear and decide India's application. The court, by 13 votes to 3, rejected the government of Pakistan's objections on the question of its competence and held that it had jurisdiction to entertain India's appeal. By a majority of 15 votes to 2. The World Court further held the Council of ICAO to be competent to entertain the application and complaint laid before it by the government of Pakistan on March 3, 1971. And in consequence rejected the appeal made to the court by the Government of India against the decision of the Council assuming jurisdiction in those respects. It may be noted here that the World Court simply gave its verdict relating to the competence of the Council of ICAO. It did not go into the merits of respective claims of the parties relating to the banning of Pakistani overflights and the incidents which led to such ban. Later on, India and Pakistan entered into similar agreement and agreed to settle all their disputes through peaceful means and through bilateral negotiations. Subsequently, Delhi Agreement, 1973, and Delhi Tripartite Agreement, 1974, were entered into to resolve matters relating to the repatriation of Pakistani prisoners of war. The representatives of India and Pakistan have also held several rounds of talk relating to the resumption of flights of aircraft by both countries over the territory of each other, but with no success so far. The main stumbling block in the solution of this problem is Pakistan's persistent refusal to withdraw her case pending before the Council of ICAO. India made it clear that she would not entertain any proposal for resumption of Pakistani overflights through her territory unless and until Pakistan first withdraws her case from the Council of ICAO. This stand was in conformity with the letter and spirit of the similar agreement between the two countries. Later on, Pakistan withdrew the complaint from the ICAO Council and India allowed the resumption of overflights through her territory. Q. 41. What do you understand by the term piracy? What are the essential elements of piracy? Ans. Definition. There has been a great controversy in respect of the definition of the term piracy. Different jurists have given different definitions of the term piracy. In an American case, the Emborse Light, 25 Fed. Re. 408, the federal court expressed the view that the armed ship in the sea should be under the authority of some state, and if such a ship is not under the authority of any state, it would be treated in the category of pirate ships, irrespective of the fact whether it has committed piracy or not. The law relating to piracy was codified in the Geneva Convention on High Seas, 1958. Article of the Convention defines piracy in the following words. Piracy consists of any of the following acts. 1. Any illegal act of violence, detention or any act of depredation committed for private ends by the crew or the passengers of a private ship or a private aircraft, and directed a. on the high seas, against another ship or aircraft, or against persons or property on board such ship or aircraft. B. Against a ship, aircraft, persons or property in a place outside the jurisdiction of any state. 2. Any act of voluntary participation in the operation of a ship or of an aircraft with knowledge of facts making it a pirate ship or aircraft. 3. Any act of inciting or of intentionally facilitating an act described in subparagraph 1 or subparagraph 2 of this article. The definition noted has been retained without any change in Article 101 of the UN Convention on the Law of the Sea, 1982. A ship or aircraft is considered a pirate ship or aircraft if it is intended by the persons in dominant control to be used for the purpose of committing one of the acts referred to in Article 15. The same applies if the ship or aircraft has been used to commit any such act, so long as it remains under the control of the persons guilty of that act. Article 17 of the 1958 Geneva Convention on the High Seas. Essential elements of piracy. Following are the essential elements of piracy. 1. Violence or robbery at high seas must be for private ends. Such acts committed by warships, government ships or aircraft cannot be called piracy. For example, In the Second World War, German U-boats sank enemy ships in the area of long-distance blockade in the high seas without any prior intimation. This act cannot be called piracy, because it was committed under the authority of the state of Germany. In fact, this act is violation of the laws and custom of war and a war crime. 2. Illegal acts of violence, detention or any act of depredation committed for private ends must be by the crew or passengers of a private ship or a private aircraft. The only exception to this is recognized in Article 16, which provides that the acts of piracy committed by a warship, government ship or government aircraft whose crew has mutinied and taken control of the ship or aircraft are assimilated to acts committed by a private ship. 3. Illegal acts of violence, detention or any act of depredation may be either on the high seas or in a place outside the jurisdiction of any state. 4. Such acts must be directed against a ship, aircraft, persons or property. 5. Violence, detention or any act of depredation may constitute piracy provided that above elements are satisfied. 6. Committing of actual robbery is not essential for piracy. Even an unsuccessful attempt to commit robbery at high seas will constitute piracy. This was held in Re Piracy Jua Gentium, 1934, AC 586. The facts of this case are as follows. In 1931, some Chinese citizens were arrested on the charge of piracy. They were tried in Hong Kong and held guilty. In this case, accused had made an unsuccessful or abortive attempt to commit robbery at high seas. The court was confronted with the question as to whether actual robbery was essential for piracy. The Hong Kong court referred this question to the Privy Council for its opinion. The Privy Council held that an act to constitute piracy, actual robbery, is not essential. Even if an accused is guilty of making an unsuccessful attempt to commit robbery, he will be guilty of having committed piracy and will be punished. 7. Any act of voluntary participation in the operation of a ship or an aircraft with knowledge of facts making it a private ship or aircraft will also constitute piracy. Article 15, 2, of the Geneva Convention on the High Seas. 8. Any act of inciting or of intentionally facilitating any illegal act described above will also constitute piracy. Q. 42. Define. A. Maritime belt or territorial waters. B. Contiguous zone. Uns. A. Maritime belt or territorial waters. The 1958 Geneva Convention on Territorial Waters and Contiguous Zone provided that the coastal state exercises sovereignty over that part of the sea which is called maritime or territorial waters. The coastal state exercises sovereignty not only over the territorial waters, but also over airspace above it. Article 2 of the UN Convention on the Law of the Sea, 1982, contains a similar provision. Problems of width of the territorial waters. Up to 18th century the cannon shot rule was prevalent. According to Biancar-Schuch, the breadth of the maritime belt extends to that distance where a cannon can fire. Up to 19th century the range of cannon shot was generally 3 miles. In the 19th century, the 3-mile cannon shot rule became very much prevalent. Scientific inventions and discoveries made this rule inadequate because the range of cannon shot increased considerably. According to Grotians, the sovereignty of a coastal state over maritime belt should extend to that area up to which it can exercise effective control. Famous jurist Judicial also subscribed to this view. Few countries of the world still voluntarily subscribed to 3-mile rule, but international law did not fix any width of the territorial waters. In order to fix the width of maritime belt, the first important attempt was made in the Hague Conference of 1930, but with no success. The next important attempt was made in the Geneva Conference on the Law of the Sea, 1958, but no agreement could be reached. Different states claimed different width of territorial waters. The extreme case was that of Chile, Peru, Equator, claiming territorial waters extending to 200 miles. The general consensus was, however, between a territorial waters extending from 3 miles to 12 miles. In order to solve this unresolved problem, another Geneva Conference was held in 1960, wherein the United States of America submitted a compromise formula. This formula envisaged 6 miles of territorial waters, and outside this there should be another 6 miles given to the coastal state for fishing, etc. Unfortunately, this proposal could not be accepted as it was defeated by a majority of a single vote. India claimed territorial waters up to 3 miles up to the year 1956. In that year, India extended its territorial waters of 3 miles to 6 miles through a presidential proclamation and later on to 12 miles in 1967. The controversy finally ended with the adoption of the UN Convention on the Law of the Sea, 1982. According to Article 3 of the Convention, breadth of territorial sea is 12 nautical miles measured from baseline. B. Contiguous zone. Contiguous zone is that part of the sea which is beyond and adjacent to the territorial sea of the coastal state. According to Article 53 of the UN Convention on the Law of the Sea, 1982, in a zone contiguous to its territorial sea, the coastal state may exercise the control necessary to a. Prevent infringement of its customs, fiscal, immigration or sanitary regulation within its territory or territorial sea. B. Punish infringement of the above regulations committed within its territory or territorial sea. The contiguous zone may not extend beyond 24 miles from which the breadth of territorial sea is measured. That is to say, it is 12 miles beyond the territorial sea. Q. 43. Define. A. Continental shelf. B. Exclusive economic zone, EEZ. Uns. A. Continental shelf. The construction of the oceans and seas is such that as we proceed seaward they become more and more deeper and a place from where sea becomes steepy. Around most continents there is a belt of fairly shallow sea, unusually less than 600 feet, and this depends only as one passes through seaward from coast. The seabed and subsoil of this fringe of shallow sea, which may be several hundred miles wide, is called the continental shelf. The legal concept of continental shelf came into limelight since Truman Proclamation of 1945, wherein it was declared that the United States of America considered the resources of the shelf contiguous to the United States as appurtenant to the United States and subject to its jurisdiction and control. It was, however, made clear that this was in no way to affect the character of the high seas above the shelf. Being encouraged by the Truman Proclamation, certain other states such as Mexico, Argentina and Cuba made similar proclamations. Article 1 of the Geneva Convention on the Continental Shelf, 1958, defined continental shelf in the following words. The continental shelf is, the seabed and subsoil of the submarine areas adjacent to the coast but outside the area of territorial sea to depth of 200 meters or beyond that limit to where the depth of superjacent water admits all exploitation of natural resources of the said areas. B. To the seabed and subsoil of similar submarine areas adjacent to the coast of island. The above definition has been severely criticized. It is said, and rightly too, that it has created more problems than solved them. The definition does not fix any outer limit of the continental shelf. It was, therefore, urgently felt that the definition of the continental shelf contained in the Geneva Convention on the Continental Shelf, 1958, should be revised at an early date. Outer limits of continental shelf. Though the problem of the definition of the continental shelf was satisfactorily solved, the problem of the outer limits of continental shelf still remained. This was due to the problem of precisely defining the outer limit of the continental margin. With a view to avoid any ambiguity in the legal regime of the continental shelf to be established and to fix precise outer limits of the continental shelf of coastal state. Paragraph 4, of Article 76 of the UN Convention on the Law of the Sea, 1982 provides the following. For the purposes of this convention, the coastal state shall establish the outer edge of continental margin wherever the margin extends beyond 200 nautical miles from the baselines from which the breadth of the territorial sea is measured by either a line delineated in accordance with paragraph 7 by reference to the outermost fixed points at each of which the thickness of sedimentary rocks is at least 1% of the shortest distance from such point to the foot of the continental slope. Or after having provided the above method of establishing the outer edge of the continental margin, the Draft Convention on the Law of the Sea lays down the formula for fixing the precise limits of the continental shelf of a coastal state in paragraph 5 of the Article 76 in following words. The fixed points comprising the line of the outer limits of the continental shelf on the seabed drawn in accordance with paragraph 4, A, I, and E. Either shall not exceed 350 nautical miles from the baselines from which the breadth of the territorial sea is measured, or shall not exceed 100 nautical miles from the 2,500 meters isabath, which is a line connecting the depth of 2,500 meters. B. Exclusive economic zone. After the concept was first advocated by Kenya, it has attracted many adherents. The Third UN Conference on the Law of the Sea deserves credit for having settled the provisions relating to the concept of exclusive economic zone. These provisions now find mention in UN Convention on the Law of the Sea, 1982. Article 55 of the Convention provides that the exclusive economic zone is an area beyond and adjacent to the territorial sea, subject to the specific legal regime established in this part, i.e. Part 5, under which the rights and jurisdictions of the coastal state and freedom of other states are governed by the relevant provisions of this convention. Article 56, which deals with rights, jurisdictions and duties of a coastal state in the exclusive economic zone, provides the following. 1. In the exclusive economic zone, the coastal state has a. Sovereign rights for the purpose of exploring and exploiting, conserving and managing the natural resources, whether living or non-living, of the seabed and subsoil and the superjacent waters. And with regard to other activities for the economic exploitation and exploration of the zone, such as the production of energy from the water currents and winds. b. Jurisdiction as provided for in the relevant provisions of this convention with regard to I. The establishment and use of artificial islands, installation and structures. e. The protection and preservation of the marine environment. c. Other rights and duties provided for in this convention. 2. In exercising the rights and performing its duties under this convention in the exclusive economic zone, the coastal state shall have due regard to the rights and duties of other states and shall act in a manner compatible with the provisions of this convention. As regards the breadth of the exclusive economic zone, Article 57 provides that it shall not exceed beyond 200 nautical miles from the baseline from which the breadth of the territorial sea is measured. As regards the rights and duties of other states in the exclusive economic zone, Article 58 provides the following. 1. In the exclusive economic zone, all states whether coastal or landlocked, enjoy, subject to the relevant provisions of this convention, the freedoms referred to in Article 87 of navigation and overflight and of the laying of submarine cables and pipelines and other internationally lawful uses of the sea related to these freedoms such as those associated with the operation of ships, aircraft and submarine cables and pipelines, and compatible with the other provisions of this convention. 2. Articles 88 to 115, these articles relating to the high seas and other pertinent rules of international law apply to the exclusive economic zone insofar as they are not incompatible with this part. 3. In exercising their rights and performing their duties under this convention in the exclusive economic zone, states shall have due regard to rights and duties of the coastal state and shall comply with the laws and regulations adopted by the coastal state in accordance with the provisions of this convention, and other rules of international law insofar as they are not incompatible with this part. It may be noted here that the concept of exclusive economic zone as highlighted by the 1982 Convention on the Law of the Sea has already become part of modern law. Case concerning the continental shelf, Tunisia, Libya, ICJ, Reop. 1982, p. Q. 44. Define. A. Freedom of high seas. B. International seabed areas. Ans. A. Freedom of the high seas. Definition. The concept of freedom of open sea or high seas is very old. In the modern time it has assumed an added significance. According to Fenwick, open sea or high sea is the sea outside the territorial waters. Charles C. Jenwick, International Law, 3rd Indian reprint, 1971, page 496. In 1958 a convention was adopted on the high seas which is known as the Geneva Convention on the High Seas, 1958. Article 1 of the said convention provides, the term, high seas, means the parts of the sea that are not included in the territorial sea or in the internal waters of a state. See UN Doc. A. Conference 13, L53. In view of the recent developments, particularly the emergence of the concept of exclusive economic zone, this definition has become obsolete and inadequate. Article 86 of the UN Convention on the Law of the Sea, 1982, therefore, provides that the provisions of this part, i.e. Part 7, apply to all parts of the sea that are not included in the exclusive economic zone. In the territorial sea or in the internal waters of a state, or in the archipelagic waters of an archipelagic state. This article does not entail any abridgment of the freedoms enjoyed by all states in the exclusive economic zone in accordance with Article 58. Article 2 of the 1958 Geneva Convention on the High Seas provides that the freedom of the high seas comprises inter alia, both for coastal and non-coastal state. 1. Freedom of navigation. 2. Freedom of fishing. 3. Freedom to lay submarine cables and pipelines. And 4. Freedom to fly over the high seas. These freedoms, and others which are recognized by the general principles of international law, shall be exercised by all states with reasonable regard to the interests of other states. This is to say, the freedoms enumerated are not exhaustive. They are in addition to those recognized by the general principles of international law. B. International seabed area. Definition and delimitation of the area. The first essential requirement of a legal regime of the international seabed area, hereinafter called the area, is that the precise limits of the area should be clearly defined and they should be delimited from other maritime zones. The area has been defined as the seabed and ocean flow and subsoil thereof beyond the limits of national jurisdiction. A pertinent question therefore arises as to what is the outer limit of coastal states' jurisdiction in seabed. The first and second UN conferences on the law of the sea failed to solve this question satisfactorily. The first UN Conference on the Law of the Sea, which was held in Geneva in 1958 and which adopted 4 conventions including the Convention on the Continental Shelf, failed miserably to fix the outer limits of continental shelf. It need not be overemphasized here that the outer limit of continental shelf is the limit where the coastal state's national jurisdiction in seabed ends. Beyond the continental shelf, the sea bottom falls away more steeply into deep water, until it levels out again in the flow of main ocean basins. which lie as much as 10 or even 15,000 feet below the surface. The area may therefore be defined as the seabed and ocean flow of the sea and subsoil thereof beyond the continental shelf of a coastal state and extending up to the continental shelf ends. Q. 45. Enlist the important provisions of Outer Space Treaty. Ans. The Outer Space Treaty. Some of the important provisions of the Outer Space Treaty of 1966 are as follows. 1. Outer space, including the Moon and other celestial bodies, shall be free for exploration and use by all states without discrimination of any kind. On a basis of equality and in accordance with law, there shall be free access to all areas of celestial bodies. There shall be freedom of scientific investigation in outer space. Article 1 of Outer Space Treaty of 1966. 2. Outer space, including the Moon and other celestial bodies, is not subject to national appropriation by claim of sovereignty, by means of use or occupation, or by any other means. Article 2. Therefore, if a state X lands craft on the Moon and claims to have acquired an inchoate title to territory, the claim will be invalid. If the state concerned is the party to the Outer Space Treaty, the claim will be invalid by virtue of Article 11 noted above. The answer will be same even if the state concerned is not a party to the treaty because of General Assembly Resolution 1962-18. Entitled, Declaration of Legal Principles Governing the Activities of States in the Exploration and Use of Outer Space, which was adopted unanimously by the United Nations General Assembly on December 1963. 3. State parties to the treaty undertake not to place on orbit around the Earth any objects carrying nuclear weapons, or any other kind of weapons of mass destruction. Install such weapons on celestial bodies, or station such wearers in outer space in any other manner. 11. Article 4. See also General Assembly Resolution 1884-17, dated the 17th of October 1963. 4. The Moon and other celestial bodies shall be used by all states parties in treaty exclusively for peaceful purposes. The establishment of military bases, installations and fortifications, the testing of any type of weapons and the conduct of military maneuvers on celestial bodies shall be forbidden. Article 4. 5. State parties to the treaty shall regard astronauts as envoys of mankind in outer space and shall render to them all possible assistance in the event of accident, distress or emergency landing on the territory of another state party or on the high seas. When astronauts make such a landing, they shall be safely and promptly returned to the state of registry of their space vehicle. Article 5. 6. State parties to the treaty shall bear international responsibility for national activities in outer space. Article 6. 7. And each state party from whose territory or facility an object is launched is internationally liable for damage to another state party to the treaty or to its natural or judicial persons by such object or its component parts on the Earth, in airspace or in outer space, including the Moon and other celestial bodies. Article 7. 8. A state party to the treaty on whose registry an object launched into outer space is carried shall retain jurisdiction and control over such object and over any personnel thereof, while in outer space on a celestial body. Article 8. As remarked by an eminent author, B. Bhatt, Legal Controls of Outer Space, 1973, pp. 276–277, at page 278. The Space Treaty is a landmark in the process of development of space law. It represents the common interests of mankind. It has ended the mere speculative phase. It represents in more specific and more binding terms the rules of customary law such as contained in various UN resolutions. A major failure of Space Treaty is that it does not provide any international control machinery to look after the larger interest of the international community. The treaty does not provide for compulsory jurisdiction of the International Court of Justice, ICJ, for the settlement of disputes. Moreover, the treaty has not resolved the boundary problem between airspace and outer space. Q. 46. What problems of international law arise in the man's conquest of Moon and Mars? Discuss with reasons. Ans. Conquest of Moon and Mars. According to Oppenheim, occupation is the act of appropriation by a state through which it intentionally acquires sovereignty over such territory as is at the time not under the sovereignty of another state. It, therefore, relates to the establishment of sovereignty over a territory which had either been unoccupied or had recently been discovered. It is a means of acquiring territory not already in the dominion of any state. In order to constitute occupation, there must be the intention or will of a state to take possession of unappropriated territory and settlement upon the land, i.e., establishment of some form of control over the occupied area. Oppenheim calls possession and administration as the two essential facts that constitute an effective occupation. By possession he means that the occupying state must take the territory under its sway, corpus, with the intention of acquiring sovereignty over it, animus. This is done by settlement on the territory, accompanied by some formal act which announces both that the territory has been taken possession of and that the possessor intends to keep it under his sovereignty. By administration, Oppenheim means that the possessor must establish some kind of administration on the territory which shows that the territory is really governed by the new possessor. Now in the instant case there cannot be any territorial claim on the Moon arising from the landing of cosmic rocket on the Moon's surface. Even the planting of flags on the Moon or any other heavenly body is not enough to claim sovereignty over it. The assertion of sovereignty must be displayed. It should be actual and not merely a nominal one on a paper claim. The claimant must act in a way which is legitimate of an international sovereign to act in order to exercise sovereignty. Nothing is to happen by man's conquest of Moon and Mars. Mere discovery of a land or conquest of Moon does not constitute acquisition through occupation. It gives an inchoate title, which is incapable of perfection by effective control and administration, i.e., by means of settlement is an act of possession since the inchoate title cannot be perfected into a real title of occupation within a reasonably sufficient time. The inchoate title will wither away and no problem of international law is to arise in the foreseeable future. Article 1 of the Treaty of Principles Governing Activities of State in the Exploration and Use of Outer Space, including the Moon and other celestial bodies, signed at Washington, London and Moscow on 27 January 1967, specifically lays down that the exploration and use of outer space, including the Moon and other celestial bodies, shall be carried out for the benefit and in the interests of all countries irrespective of their degree of economic or scientific development and shall be the province of all mankind. Outer space, including the Moon and the other celestial bodies, shall be free for exploration and use by all states without discrimination of any kind, on a basis of equality and in accordance with international law, and there shall be free access to all areas of celestial bodies. Article 2 lays down that outer space, including the Moon and other celestial bodies, is not subject to national appropriation by claim of sovereignty, by means of use or occupation, or by any other means. Article 4 provides that the Moon and other celestial bodies shall be used by all states parties to the treaty exclusively for peaceful purposes. The establishment of military bases, installations and fortifications, the testing of any type of bodies shall be forbidden. After tough negotiations lasting 7 years, the 47-nation United Nations Outer Space Committee reached agreement in July 1979 on a draft treaty on the Moon, proclaiming that its unexplored natural resources shall be the common heritage of mankind and that the Moon is not subject to national appropriation by any claim of sovereignty, by means of use or occupation, or by any other means. The draft treaty was then sent to the General Assembly for adoption. Q. 47. Write a short note on the peaceful uses of the seabed and outer space. Uns. Peaceful uses of seabed. In June 1968, the General Assembly set up a standing committee on the peaceful uses of the seabed and the ocean floor beyond the limits of national jurisdiction. It functions largely through two subsidiary bodies: a legal subcommittee which studies the legal principles to promote international cooperation and to ensure exploitation of the resources of the seabed and ocean floor for the benefit of mankind, and a scientific and technical subcommittee which deals with these specified aspects. In 1962, the General Assembly declared that, pending the establishment of an international regime, states and persons should refrain from all exploitation of the resources of the seabed and ocean floor beyond national jurisdiction, and no claim on the part of the sea or its resources shall be recognized. On December 17, 1970, the General Assembly of the United Nations, while planning for a third United Nations Conference on the Law of the Sea, adopted a Declaration of Principles, which inter alia laid down that the seabed beyond that limits of national jurisdiction and its resources shall constitute a common heritage of mankind, i.e., a space not subject to appropriation by individual states or persons and to be exclusively used for peaceful purposes for the benefit of mankind as a whole, to be administered and exploited by the international community as such. Peaceful uses of outer space. The Treaty on the Peaceful Uses of Outer Space, commended to the states by the General Assembly and containing principles to be observed in the exploration and use of outer space, was signed on January 27, 1967, and came into force on October 10, 1967. The accretion of this treaty to the law of nations has forged a permanent disarmament agreement for outer space. This treaty on principles governing the activities of states in the exploration and use of outer space, including the Moon and other celestial bodies, provides that there shall be freedom of scientific investigation in outer space, including the Moon and other celestial bodies. And the states facilitate and encourage international cooperation in such investigation, and that outer space, including the Moon and other celestial bodies, was not subject to national appropriation by claim of sovereignty, by means of use or occupation, or by any other means. Further, the Moon and other celestial bodies shall be used by all states parties to the treaty exclusively for peaceful purposes, and the establishment of military bases, installations and fortifications, the testing of any type of weapons and conduct of military maneuvers on celestial bodies shall be forbidden. In order to promote international cooperation in the peaceful exploration and use of outer space, states parties to the treaty conducting activities in outer space including the Moon and other celestial bodies, have agreed to inform the Secretary-General of the United Nations of the nature, conduct, locations and results of such activities to enable him to disseminate it immediately effectively. Besides the treaty, there is an agreement which came into effect on December 3, 1968, on the rescue and return of astronauts and the return of objects launched into outer space, under which parties agree to procedures for aiding the crews of spacecraft in the event of accident or emergency landing. On January 27, 1971, the Academy of Science of the USSR and the U.S. National Aeronautics and Space Administration signed an agreement for better cooperation in space efforts. It aims at exchange of information and joint endeavors in the fields of meteorology, environment, space biology and medicine and space exploration. The Convention on International Liability for Damage Caused by Space Objects as adopted by the General Assembly on November 29, 1971, provides that a state, or states, launching or jointly launching a space object shall be absolutely, or jointly and severally, liable to pay compensation for damage caused by its space object on the surface of the Earth or to aircraft in night. Q. 48. Define nationality. What are the various modes of acquiring and losing of nationality? Ans. Nationality is the status of natural person who is attached to a state by the tie of allegiance. Harvard Draft Convention on Nationality, 1929, AJIL, Special Supplement, page 13. In the words of Hyde, nationality refers to the relationship between a state and an individual which is such that the former may with reason regard the latter as owing allegiance to itself. Hyde. International Law, Vol. 2, page 1064. Acquisition of nationality. Following are the modes of acquisition of nationality. 1. By birth. A person acquires nationality of the state where he is born. He also acquires the nationality of his parents at the time of his birth. 2. By naturalization. Nationality may also be acquired by naturalization. When a person living in foreign state acquires the citizenship of that state, then it is said to be acquired nationality through naturalization. 3. By resumption. Sometimes a person may lose his nationality because of certain reasons. Subsequently, he may resume his nationality after fulfilling certain conditions. 4. By subjugation. When a state is defeated or conquered, then all the citizens acquire the nationality of the conquering state. 5. Cession. When a state has been ceded in another state, then the people of the territory which has been ceded acquire the nationality of the state in which their territory has been merged. In addition to the above-mentioned modes, there may be some other circumstances whereby a person may acquire nationality. For example, if a person is appointed in the public service of another state, then acquires the nationality of that state. Loss of nationality. Following are the modes of loss of nationality. 1. By release. In some states, law provides that the citizens may lose the nationality by release. In the loss of nationality by release, it is necessary to submit an application for the same. If the application is accepted, the person concerned is released from the nationality of the state concerned. 2. By deprivation. In certain states, law provides that if the national of that state without seeking prior permission of the government obtain employment in another state, then he may be deprived of his nationality. 3. Long residence abroad. Yet another mode of loss of nationality is the long residence abroad. The state laws of many states contain provisions in this connection. Thus, if a person resides for a long period abroad, then his nationality ends. 4. By renunciation. A person may also renounce his nationality. The need for renunciation arises when a person acquires nationality of more than one state. In such a condition, he has to make a choice as to of which country he will remain the national. Consequently, he has to renounce the nationality of one state. 5. Substitution. Some states provide for the substitution of nationality. According to this principle, a person may get nationality of a state in place of the nationality of another state. This is called nationality by substitution, whereby he loses the nationality of one state and acquires the nationality of another state. Q. 49. Differentiate between a. Nationality and domicile. B. Nationality and citizen. Uns. A. Distinction between nationality and domicile. It has been pointed out earlier that basis of nationality is the membership of a man with an independent community. On the other hand, domicile denotes the residence of the person. Thus, there is a great difference between nationality and domicile. While nationality denotes the relation of a man with his nation which protects him and the person is bound to follow the rules enacted by that state, on the other hand, domicile denotes the residence of the person. Consequently, a person may acquire nationality through domicile. In different countries there are different rules and processes in regard to the acquisition of nationality through domicile. In Boldrini vs. Boldrini, 1932, Probate 9:15, it was held that a man may change his domicile without losing or changing his nationality. Conversely, it has been held in Wall vs. AG, 1932-147 LT 382, that a man may change his nationality without a change of his domicile. The Indian courts have also applied these principles. Attaullah vs. Attaullah, Air 1953 Cal. 530, and Michael Anthony Rodriguez vs. State of Bombay, Air 1956 Bom. 729 deserve mention in this connection. The point that a person acquired British nationality would not imply that he had acquired the domicile of UK too. This was held by the Calcutta High Court in S.P. Ghouse vs. Deputy Controller, Reserve Bank of India, Air 1964 Cal. 422. It has been aptly remarked, though the two concepts are quite independent of each other, but sometimes domicile is made one of the important criterion for the acquisition of the nationality or citizenship of a country. S. K. Agrawal, International Law, Indian Courts and Legislature, 1965, page 113. B. Distinction between nationality and citizenship. Often nationality and citizenship are considered to be synonymous of each other. But the fact is otherwise. There is a great difference between nationality and citizenship. By nationality under international law, we mean the legal relationship which exists between the nation and the state. Citizenship, on the other hand, denotes the relation between the person and the state law. In other words, we may say, rights of a person may come under international law, whereas the rights of citizenship are the sole concern of the state law. It is possible that all the citizens possess the nationality of a particular state, but it is not necessary that all the nationals may be the citizens of that particular state. Citizens are those persons who possess all political rights in that state. But a person who possesses only nationality in a particular state may possess all political rights. Thus, there is a great difference between nationality and citizenship. The distinction between nationality and citizenship has been aptly summed up in the following words. Ibid, at pp. 96-97. It is nationality only which is of significance to international law and not citizenship. Citizens are included in nationals, but not all nationals are citizens. It may be noted here that the Indian Citizenship Act, 1955 does not make any distinction between the words nationality and citizenship. Q. 50. Define double nationality and the nationality of a married woman. Uns. Double nationality and nationality of married woman. Because of the conflict of the laws of nationality of different countries, a situation often arises when a person may possess nationality of more than one state. To give example of such a case is that of a woman, who after her marriage acquires the nationality of her husband and also continues to possess her original nationality. The double nationality may also be acquired by birth if the parents are at the time of birth in a state whose nationality they do not possess. Consequently, treaties may provide that the persons may, by their will, select their nationality. The Hague Conference of 1930 made an attempt to remove the difficulty arising out of double nationality in consequence of war. Articles 3 to 6 of the Hague Convention contain the provisions in this connection. For example, Article 5 provides that such a person shall be treated in their state as if he has only one nationality. The third state will either recognize the nationality of the state where he often resides or will recognize the nationality which is more relevant in accordance with the facts and circumstances of each individual case. Articles 8 to 11 provide for the nationality of married women. In these provisions, an endeavor has been made to remove the difficulties. According to the principles contained in these provisions, if a woman marries, then she will automatically acquire the nationality of her husband. In the recent times, the Convention on the Nationality of Married Women is yet another significant attempt to remove the difficulties and problems arising out of the double nationality. Q. 51. Write a short note on statelessness. Uns. Statelessness. Sometimes it so happens that a person does not possess the nationality of any state. Such a state is referred to as the state of statelessness. In Stoic versus the Public Trustee, 1921, 2 ch. 67, it was held that it is generally agreed that if a person is not a national of any state, he will be called a stateless person. Lord Russell observed that such a status is recognized by British law as well as international law. At present, this is one of the burning problems of international law. The person who does not possess the nationality of any nation cannot exercise the rights conferred upon him by international law. Prof. Oppenheim has compared such persons with the ships who are floating in the open sea, without flag of any country. Serious attempt to remove the difficulties arising out of statelessness was made in the Hague Convention of 1930. Later on, after the establishment of United Nations, attention was given to remove the difficulties arising out of this problem. According to Article 15 of the Universal Declaration of Human Rights, each person is entitled to have nationality, and the nationality of any person cannot be taken away or snatched arbitrarily. The Universal Declaration of Human Rights inspires the state to regulate their conduct in accordance with the provisions of the Declaration so far as the problem of statelessness is concerned. Q. 52. What do you understand by extradition? Give in short the law relating to extradition and refer to leading cases. What are the necessary conditions for extradition? Uns. Extradition. Where a person who has committed an offense in one country escapes to another, what is the duty of the latter with regard to him? Should the country of refuge try him in its own courts, according to its own laws, or deliver him up to the country whose law he has broken? To the general question, international law gives no certain answer. The universal practice of nations, however, is to surrender fugitive offenders only in consequence of some special treaty with the country which demands them. and few jurists now affirm any general duty or perfect obligation. This surrender in accordance with treaty and in compliance with formal demand is known as extradition. Lawrence defines extradition as the surrender by one state to another of an individual who is found within the territory of the former and is accused of having committed a crime within the territory of the latter, or who, having committed a crime outside the territory of the latter, is one of its subjects and, as such, by the law amenable to its jurisdiction. Difficulties. There are two practical difficulties about extradition which have prevented the growth of a uniform rule on the subject. They are the variations in the definitions of crime adopted by different countries and the possibility of the process of extradition being employed to get hold of a person who is wanted by his country not really for an ordinary crime, but for a political offense. Modern states almost invariably exclude offenses of a political character from the operation of the law of extradition. It is now generally agreed that surrender is a matter of community and not right. Each state is guided by treaty stipulations, and, in their absence, it has a right to refuse to surrender fugitives by granting them asylum in view of the territorial sovereignty. Necessary conditions. The necessary conditions for extradition generally inserted in extradition treaties are as follows. 1. A fugitive criminal shall not be surrendered if the offense in respect of which his surrender is demanded is one of a political character. The term, political offense, is not easy to define. It has, however, been established according to judicial decisions that to constitute a political offense there must be two or more parties, each seeking to impose government of its own choice on the other or striving for political control in the state where the offense is committed, and the offense must be in pursuance of that objective. 2. Military offenses, e.g., desertion, and religious offenses are also generally not subject to extradition proceedings. The rule is that extradition is not allowed for trifling cases. 3. The fugitive demanded shall not be liable to be tried for any offense committed prior to his surrender other than the specified offense mentioned in the request for his extradition until he has been liberated and has had an opportunity of leaving the country. In the case of United States vs. Russia, 1886, Russia, a sailor, was surrendered by Great Britain to USA upon a charge of murder. He was, however, tried and convicted in USA upon a minor charge of inflicting cruel and unusual punishment to the man of whose murder he was accused before. On appeal, the Supreme Court of the United States quashed the conviction and ordered the release of the prisoner on the ground that, unless otherwise provided for by treaty, the prisoner could only be charged with the offense for which he was extradited unless he was given a reasonable time to return to the country which surrendered him. 4. The crime must be an offense in both the states. This is based on the principle of double criminality. Isla's case. 5. A fugitive criminal who has been accused of some offense, being the offense for which his surrender is asked, shall not be surrendered until after he has been tried and has served his sentence for the offense committed in the state requested to surrender. 6. There must be reasonable prima facie evidence of the guilt of the accused. The requested state shall satisfy itself that the evidence submitted justifies prima facie judicial proceedings against the accused, but it is not within the province of the courts of such a state to try the case on its merits. Case laws. 1. Savarkar's case. Savarkar, an Indian and a British subject, was being transported in the P&O boat Maurya to India for the purpose of his trial on a charge of high treason and abetment of murder. He escaped to the shore on October 25, 1910, while the vessel was in the harbour of Marseille. He was, however, seized by a French policeman, who in mistaken execution of his duty, handed him over to the captain without any extradition proceedings. France demanded that Great Britain should give him up and ask his extradition in a formal way in conformity with international law. Great Britain did not comply with this demand. By consent, the matter was referred to the Permanent Court of Arbitration at The Hague. The award, while admitting that an irregularity had been committed by the handing over of Savarkar to the British authorities, decided in favour of Great Britain, holding that there was no rule of international law imposing in such circumstances any obligation on the power which has in its custody a prisoner to restore him because of a mistake committed by a foreign agent, who delivered him up to that power. 2. Godfrey's case. In Rex vs. Godfrey, the term fugitive came in for interpretation, and it was observed by Lord Hewitt, C.J., that although, at the first blush, it might appear that when a man is spoken of as a fugitive, what is meant is that he has fled from one country to another country. It seems that the words, fugitive criminal, are equally satisfied whether the man has physically been present in that country or not, if he committed the crime there. 3. Mubarak Ali's case. In Re-Government of India and Mubarak Ali Ahmed, the Queen's Bench referred with approval to Recastshani, in which the court refused extradition because the crime of the fugitive was considered to be political. The present case, however, concerned a man charged with forgery, and even if the case had some political implications into which the court could not inquire, there was no reason to suppose that he would not receive a fair trial, and it would be an impossible position for this court to take up, and an insult to the courts of India to say that he would not. 4. Eisler's case. In the Eisler extradition case, 1949, Gerhard Eisler, an alien communist, convicted in America of some criminal offenses, fled from New York to Poland. He was arrested by the British police officers and produced for trial before a Bow Street magistrate. The British magistrate discharged Eisler from custody on the ground that the offence for which Eisler had been convicted in America, viz., perjury, did not fall under the technical head of perjury in England. This emphasizes the principle of double criminality, i.e., the crime must be an offence in both the states. 5. Dr. Ram Babu Saxena vs. the State. Dr. Ram Babu Saxena, member of the UP Executive Civil Service, was appointed in 1948 as Administrator, Tonk State, which was then an Indian state and had extradition treaty with the British government. It was alleged that while serving in Tonk State, B had committed crimes of extortion and cheating. Dr. Saxena contended that both these offences being not included in the extradition treaty, he was not liable for extradition. Their Lordships of the Supreme Court observed that extradition of an Indian subject under S7 for an offence which is not extraditable under the extradition treaty entered into between the British government and the Tonk state in 1869, is not, in any sense, a derogation from the provisions of the treaty which provides for the extradition of offenders for certain specified offences. Assuming that the Treaty of 1869 still subsisted after the accession of the Tonk state to the Dominion of India, the learned judges were accordingly of opinion that the arrest and surrender of the appellant under S7 of the Act was not rendered unlawful by anything contained in the Treaty of 1869, assuming that it still subsisted. 6. Sucha Singh's case. After having murdered the Punjab Chief Minister Pratap Singh Kirong in 1965, Sucha Singh absconded to Nepal. In view of the extradition treaty between India and Nepal, on the request of the Government of India, the Government of Nepal extradited Sucha Singh after initiating proceedings against him in accordance with due law of Nepal. Nepal did not regard the crime as political. Q. 53. Define asylum, discuss various types of asylum, differentiate between territorial asylum and diplomatic asylum. Ans. Meaning and definition. By the term, asylum, we generally mean the shelter and active protection which is extended to a political refugee from another state by a state which admits him on his request. As pointed out by Stark, asylum involves two elements. 1. A shelter which is more than a temporary refuge, and 2. A degree of active protection on the part of the authorities which have control over the territory of asylum. Right to asylum. According to Article 14 of the Universal Declaration of Human Rights, everyone has a right to seek and enjoy in other countries asylum from prosecution. It may, however, be noted that the declaration simply recognizes the right of asylum. It does not grant right to receive asylum. Thus, although everyone has a right to seek asylum, yet there is no corresponding duty of states to grant asylum. Types of asylum and the distinction between them. Asylum may be classified into two categories, I. Territorial asylum, and E. Extraterritorial asylum. Territorial asylum. Territorial asylum is granted by a state in its own territory and is considered as an attribute of territorial sovereignty of the state which grants asylum. On March 28, 1945, a Convention on Territorial Asylum was adopted at Caracas. Article 1 of the said convention runs as follows: every state has the right in exercise of its sovereignty to admit into its territory such persons it deems advisable. This right has also been recognized in the draft Declaration on Asylum adopted by the United Nations Human Rights Commission. Article 3 of the Declaration provides, no one seeking or enjoying asylum in accordance with the Universal Declaration of Human Rights should, except for overriding reasons of the population, be subjected to measures such as rejection at the frontier, return or expulsion, which would result in compelling him to return to or to remain in a territory if there is a well-founded fear of prosecution endangering his life, physical integrity or liberty in that territory. The above principle has also been incorporated in Articles 31, 32 and 33 of Refugee Convention of 1951. Example of Dalai Lama and his Tibetan followers. The grant of asylum to Dalai Lama and his followers was an indication of the exercise of territorial sovereignty by India. India as a sovereign state was within her rights to grant asylum to Dalai Lama and his followers in the territory of India. Example of influx of refugees from Bangladesh. As pointed out earlier, each sovereign state can admit or grant asylum to any individual within its territory. India was within her right to grant asylum to millions of refugees from East Pakistan, now Bangladesh, who fled from their native land due to repressive policies followed by an ruthless prosecution caused by the military regime of General Yahya Khan. Extraterritorial or diplomatic asylum. A state may also grant asylum in its embassy in foreign countries or in its public vessels. Extraterritorial or diplomatic asylum may be classified into following categories. A. Asylum in foreign legation or diplomatic embassies. Since granting of diplomatic asylum involves a derogation from the sovereignty of the state. International law ordinarily does not recognize a general right of a head of mission to grant asylum in the premises of legation. In order to grant diplomatic asylum, it is necessary to establish its legal basis in each particular case. Because of the obvious reason that such a decision leads to the withdrawal of the offender from the jurisdiction of the territorial state and constitutes an intervention in matters which are exclusively within the competence of that state. This was held by the International Court of Justice in the case of the asylum, Colombia vs. Peru. ICJ Reports, 1950. Page 266. A leading case on asylum in foreign legations is Haya della Torre case, ICJ Reports, 1951, page 71. The facts of this case: Haya della Torre, a Peruvian citizen, was charged with rebellion. Colombia granted him asylum in her embassy in Peru. After granting asylum, Ambassador of Colombia requested Peruvian government to provide facility to enable Colombia to take Haya della Torre outside Peru. This request was made on the basis of Bolivian Agreement, 1911 and Pan-American Havana Convention on Asylum, 1928. Colombia contended that asylum was granted because Haya della Torre was accused of a political crime. Peru did not agree with this contention and rejected this request. The matter was referred to the International Court of Justice. The court held that Colombia as the state granting asylum was not competent to qualify the offense as political by a unilateral and definitive decision, binding on Peru. However, the court held that Peru had failed to prove that Haya della Torre was accused of an ordinary crime, and not a political crime. The court added that asylum to Haya della Torre had been irregularly granted because 3 months had passed after the suppression of the military rebellion, which clearly showed that the urgency prescribed by Havana Convention as a condition for the granting of asylum had ceased to exist. But since Haya de la Torre was a political offender, the court held that despite the fact that asylum had been irregularly granted, Colombia was not bound to surrender Haya de la Torre. The International Court of Justice held to infer an obligation to surrender a person to whom asylum has been irregularly granted would be to disregard both the rule of the extra-legal factors involved in the development of asylum in Latin America and the spirit of Havana Convention. b. Asylum in consular premises. The above principles also apply in case of the grant of asylum in consular premises. c. Asylum in the premises of international institution. Generally speaking, international law does not recognize any rule regarding the grant of asylum in the premises of international institution. However, temporary asylum may be granted in case of danger of imminent violence. d. Asylum in warships. There is a controversy in regard to the grant of asylum in warships. Some writers are of the view that asylum can be granted in warships in the territorial waters of a coastal state. On the other hand, some writers have expressed the view that such fugitives should be immediately handed over to the local police, but it is conceded that asylum may be granted to political offenders. a. Asylum in merchant vessels. Since merchant vessels do not enjoy immunity from local jurisdiction, they are not competent to grant asylum to local offenders. Distinction between territorial and extraterritorial asylum. The distinction between territory and extraterritorial asylum has been aptly explained by the International Court of Justice in the asylum case, Colombia vs. Peru, ICJ Reports, 1950, page 266. In the case of extradition, territorial asylum, the refugee is within the territory of the state of refuge. A decision with regard to extradition implies only the normal exercise of territorial sovereignty, the refugee outside the territory of the state where the offense was committed. A decision to grant asylum in no way derogates from the sovereignty of that state. In the case of diplomatic asylum, the refugee is within the territory of the state where offense was committed. A decision to grant diplomatic asylum involves a derogation from the sovereignty of that state. It withdraws offenders from the jurisdiction of the territorial state and constitutes an intervention in matters which are exclusively within the competence of that state. Such a derogation from territorial sovereignty cannot be recognized unless its legal basis is established in such particular case. To sum up, in case of territorial asylum, international law allows a state to grant asylum in exercise of its territorial sovereignty. It may or it may not be treated as a friendly act, but there can be no legal objection to the grant of asylum by a state within its territory. In case of diplomatic asylum, the position is entirely different. Since the offender is within the territory of the state where asylum is to be granted, it is obviously a derogation of the sovereignty of that state and, therefore, in such a case asylum may be granted only in exceptional cases, and it is necessary to establish its legal basis in each particular case. Q. 54. Asylum and extradition are mutually exclusive or asylum stops, as it were, where extradition begins. Comment. Uns. Asylum and extradition are mutually exclusive, or asylum stops, as it were, where extradition begins. As noted earlier, asylum is the protection which a state grants in its territory or in some other place under control of certain of its organs to a person who comes to seek it. On the other hand, extradition is the surrender or delivery of the fugitive criminal to the state on whose territory the alleged criminal happens to be. The institution of asylum confers right upon the state to bring the person concerned within its jurisdiction. In case of territorial asylum, the person is in the territory of the territorial state and hence under its jurisdiction. By granting asylum, it grants protection to the person concerned in its territory. In case of diplomatic asylum, the person is not under the jurisdiction of the state granting asylum. Protection is granted to the person concerned and he is brought under the jurisdiction of the granting state. It, therefore, involves derogation from the sovereignty of the territorial state, for through the institution of the asylum the person concerned is withdrawn from the jurisdiction of the territorial state. In both types of asylum, however, the ultimate purpose is to accord protection to the refugee or person concerned and to bring him under the jurisdiction of the granting state. The institution of extradition does just the reverse. In case of extradition, the fugitive criminal is in the territory and under the jurisdiction of the territorial state and either under an extradition treaty, or arrangement, or otherwise. It surrenders or returns the fugitive criminal to the state where he is alleged to have committed the crime. Thus the fugitive criminal who is under the jurisdiction of the territorial state is transferred to the jurisdiction of the state where he is alleged to have committed the crime. Thus asylum and extradition are mutually exclusive. Once the territorial state decides to extradite the fugitive criminal, the question of asylum does not at all arise, that is to say, asylum stops where extradition begins. On the other hand, once the state concerned decides to grant asylum to a person, the question of his extradition, at least for the time being, does not at all arise. But after a state has granted asylum to refugee or fugitive criminal, it may subsequently decide to extradite him at the request of the state where he is alleged to have committed the crime or to which state he belongs. Q. 55. What are the amicable means of settlement of international disputes? Uns. The method of the settlement of international disputes may be divided into two main categories. 1. Pacific means of settlement, and 2. Compulsive or forcible means of settlement. Pacific means of settlement of international disputes. Following are the pacific means of settlement of international disputes. 1. Arbitration. By arbitration we mean the method through which a dispute is referred to certain persons called arbitrators. Their decision is known as the award. These arbitrators are selected by the parties to the dispute. Although they are selected or appointed on the basis of the consent of the parties to a dispute, their decision or award is binding upon the parties. The history of settlement of international disputes through arbitration may be traced from very ancient times. But in modern times its history dates back from the Judicial Treaty of 1794 between England and America. The next important event in the development of settlement of international disputes through arbitration was Alabama Claims Arbitration, 1872. In this case, America had claimed compensation from Britain on the ground that it had violated the laws of neutrality. The arbitrators gave their award in favor of America and held that Britain was liable to pay compensation. As remarked by Judge Hudson, the success of Alabama Claims Arbitration stimulated a remarkable activity in the field of international law decisions. Kutch Arbitration Award, 1968. It will be desirable to mention here briefly the facts and circumstances which led to the Kutch Arbitration Award, 1968, and the details of the award. The Run of Kutch is a place on the border of Gujarat and West Pakistan. There was a dispute between India and Pakistan in regard to some land in the Run of Kutch. Pakistan claimed 3,500 square miles of the said land. This led to the armed conflict between the two countries in 1965. After the ceasefire, both India and Pakistan agreed to refer this matter to arbitration. An arbitrator, Alves Bieber of Yugoslavia, was nominated by India. The other arbitration, Nasrullah Entezam of Iran, was nominated by Pakistan. And the third was to be nominated with the mutual agreement of both the states. Since India and Pakistan could not agree upon a third arbitrator, on the request of both the countries, Judge Gunnar Lagajaran, the chairman of the arbitral court, was nominated by the Secretary General of the United Nations. The arbitral court gave its award on the 19th of February 1968. According to the award, 320 square miles, i.e., about 10% of the Pakistani claim, of the land belonged to Pakistan and the rest belonged to India. It is one of the well-recognized principles of international law that the award of an international arbitral court is binding upon the parties. Consequently, India accepted and implemented it. 2. Judicial settlement. Thus the International Court of Justice has rendered signal service for the development of international law. However, the court has its own limitations. Its decisions have no binding force except upon the parties to a dispute and only in respect of particular dispute between them. 3. Negotiations. Negotiations are also the means for the settlement of international disputes. It is a much less formal method than judicial settlement. Sometimes disputes are settled only through negotiations. But if negotiations fail to resolve the dispute, then other method, such as good offices, mediation, etc., may be used along with negotiations. 4. Good offices. When two states are not able to resolve their disputes, a third state may offer its good offices for the same. These offices may also be offered by international organizations or some individuals. The third state, individual or international organization creates such an environment as may be conducive for the settlement of the disputes. Some general suggestions may also be put forward, but the third party does not take active part in the negotiations. 5. Mediation. Mediation is yet another method through which efforts are made to the settlement of international disputes. In the case of mediation, The third state or individual not only offers its services but also actively participates in the talks to resolve the dispute. 6. Conciliation. In wider sense, conciliation is a method through which the other states or the impartial persons try to resolve the dispute peacefully through different means. After the matter is referred to a commission or committee which submits its report and recommends certain measures for the settlement of disputes. These proposals are, however, not binding upon the parties. In the words of Judge Hudson, conciliation is a process of formal proposals of settlement after an investigation of the facts and an effort to reconciliate to accept or reject proposals formulated. The Hague Conventions of 1899 and 1907 made the provisions for a conciliation commission. In the present time also conciliation is adopted as a method of settlement of an international dispute. A recent example of this is the 1965 Convention on the Settlement of Investment Disputes between states and the nations of other states, which provides for conciliation commission for the settlement of dispute. 7. Inquiry. Inquiry is also a method which is often resorted to for the settlement of disputes. It may be noted that it is not an independent method and is often applied along with other methods. The main objective of the inquiry is to make investigation of the relevant matters, so as to establish facts which may hold the ultimate solution of the problem. For example, often inquiry commissions are appointed in relation to the settlement of border disputes. The commission clarifies the facts after making inquiry into the relevant facts. 8. Settlement of international disputes under the auspices of the United Nations Organization. Briefly speaking, following are some of the provisions for the United Nations Charter. I. It is one of the purposes of the United Nations that the member states settle their disputes through peaceful means. Under Article 2 of the Charter, the member states have undertaken to resolve their disputes through peaceful means and not to resort to force or threat of force to resolve international disputes. E. The General Assembly of the United Nations may make recommendation for the peaceful settlement of international disputes. Article 14. E. Articles 33 to 38 of Chapter 6 of the Charter make the provisions for the peaceful settlement of international disputes. Q. 56. What are the compulsive means of settlement of international disputes? Ans. If the states are not able to solve their disputes through peaceful means, they resort to compulsive or coercive means, which are as follows. 1. Retortion. When a state behaves in a discourteous manner with another state, then international law confers right upon the state affected to resort to retortion. The word retortion means retaliation. But the affected state can take only those means or measures as retortion which are otherwise also permitted under international law. For example, in retortion diplomatic relations may be ended, privileges of diplomatic agents may be withdrawn and economic facilities may be stopped. As rightly pointed out by Stark, the United Nations Charter has to some extent affected the right of retortion because in accordance with the provisions of Charter no state can take any action in the form of retortion as may endanger international peace and security. 2. Reprisal. Another compulsive means of settlement of international disputes adopted by one state against another for the purpose of settling some dispute brought about by the latter's illegal or unjustified act. In the case of Nolila Incident, Special Tribunal, Germany vs. Portugal, 19282, RIA, 1012, 1019, the tribunal held that the right of reprisal is subject to the following restrictions. A. Reprisals are illegal unless they are based upon a previous act contrary to international law. B. There must be a certain proportion between the offense and the reprisal as a necessary condition for the legitimacy of the latter. C. Reprisals are legitimate only when they have been preceded by an unsuccessful demand of redress. In fact, the employment of force is justified only when it is necessary. Recent example of the use of this means for the settlement of the international dispute is the Israeli action in bombarding certain areas of Lebanon from where the Arab guerrillas operated attacks. From time to time in different parts of the territory of Israel. United Nations Charter has greatly affected the right of the states as to resort to reprisal. No state is entitled to reprisal which may endanger international peace and security. 3. Embargo. Embargo is yet another compulsive means for settlement of international disputes. It is a type of reprisal. By embargo we mean that if a state violates international law or commits some international crime, then the affected state becomes entitled to create obstruction in the transport of its ships which are within the territory of the affected state. 4. Pacific blockade. Pacific blockade is yet another compulsive means of settlement of international disputes. Through Pacific blockade the ingress and regress of the ports of the states are blockaded so that the ships of other states may not reach those ports and the shops of the blockaded state may not go out of the ports. However, there is a distinction between Pacific blockade and the blockade which is used in peacetime. It is often resorted to as a reprisal because through blockade of the ports of a state, that state may be compelled to settle its disputes. 5. Intervention. Intervention is a dictatorial interference by a state in the affairs of another state for the purposes of maintaining or altering the actual conditions of things. In principle, international law prohibits intervention. 6. Under the auspices of the UN. Chapter 7 of the Charter of the UN deals with the provisions under which the Security Council can resort to compulsive means for the settlement of disputes regarding maintenance or restoration of international peace and security. These provisions have been discussed in chapter on the Security Council. Please therefore see the chapter on Security Council for a discussion of these provisions. Q. 57. Differentiate. A. Good offices and mediation. B. Retortion and reprisal. Uns. A. The main distinction between good offices and mediation is that in case of good offices, the third party simply offers its services and does not actively participate in the talks, whereas in the case of mediation, the third party actively participates in the talks and makes suggestions so as to resolve the dispute between the state. A good example of mediation and good offices is that of Tashkent Agreement in the end of 1965 and beginning of 1966, wherein Russia succeeded in bringing about an agreement between India and Pakistan. Ans. B. The main distinction between reprisal and retortion is that while in retortion only that action can be taken which is permitted under international law and depends upon the discretion and sweet will of the states, whereas in reprisal those actions can also be taken which might otherwise be illegal but are allowed as reprisal in certain special circumstances. As pointed out by Stark, reprisal consists of acts which would generally otherwise be quite illegal, whereas retortion consists of retaliatory conduct to which no legal objection can be taken. Q. 58. What do you mean by the term war? What are its immediate effects? Ans. Definition of war. According to Hall, when difference between states reach a point at which both parties resort to force or one of them does acts of violence which the other chooses to look upon as a breach of peace, the relation of war is set up, in which the combatants may use regulated violation against each other, until one of the two has been brought to accept such terms as his enemy is willing to grant. Effects of outbreak of war. 1. General effects. Besides affecting neutral states, war mainly affects the belligerent states. According to Oppenheim, it is wrong to say that due to outbreak of war, all the relations of the belligerent states and of their citizens came to an end. Although limitations and prohibitions in the relations of the belligerent states during war are governed by the laws of war. 2. Diplomatic and consular relations. At the outbreak of the war, the diplomatic and consular relations between the belligerent states are broken immediately. Consequently, the belligerent states recall their diplomatic agents from each other. Often at the outbreak of war, the receiving belligerent states hands over the passport to the diplomatic agents of the enemy country, which means that they should immediately return to their home states. In this connection, Article 44 of the Vienna Convention on Diplomatic Relations 1961 provides that it is the duty of the receiving state to provide necessary facilities to such agents so that they may return safely to their home state. 3. Treaties. According to the old view, all treaties are terminated between the belligerent states after the outbreak of war. In the present times, many significant changes have come in this respect. The present practice of the states shows that all the treaties between the belligerent states do not come to an end. Some treaties are completely terminated, some remain in force, while some others are simply suspended during war times. 4. Trading and intercourse in commerce. All trading and intercourse between the belligerent states are prohibited during the war. It is a well-recognized rule of international law that the treaties relating to trading and intercourse between the belligerent states stand terminated at the outbreak of war. 5. Contracts. The effect of the contracts at the outbreak of war between belligerent states is a matter of municipal law rather than that of international law. Consequently, belligerent states are free to make rules and to enforce them in accordance with the contracts. International law leaves them free to make necessary laws regulating the validity or invalidity of contracts at the outbreak of war. The practice of the states, however, shows that the executory contracts become completely invalid whereas executed contracts remain unaffected at the outbreak war. 6. Enemy property. Enemy property may be of two kinds: public enemy property and private enemy property. I. Public enemy property. At the outbreak of war, all movable public enemy property situated in the enemy state may be seized. The position in regard to the immovable public enemy property is, however, different. Immovable may be temporarily taken but cannot be permanently seized. After the outbreak of war, it is determined as to what should be done in regard to this property. Consequently, the sale or disposal of immovable public enemy property is not possible during war. It can only be used by the belligerent state during war. Private enemy property. The practice of the states shows that private enemy property situated in the territory of the belligerent state may be taken over for a temporary period. After the end of the war, its fate is decided in accordance with the provisions of the peace treaty concluded, if any, between the belligerent states. The belligerent state is not entitled to seize the private enemy property, but can only take it if it is necessary for local needs. There are, however, certain exceptions in this connection. The rules of international law mentioned above are not applicable in case of enemy ship in the sea. The ships of enemy, whether they are public or private, can be seized during war. 7. Combatants and non-combatants. Under international law, the soldiers of the belligerent states are divided into two categories: lawful and unlawful. At the outbreak of war, lawful soldiers can be killed, grievously hurt, arrested or made prisoners of war. Lawful soldiers are ordinarily those soldiers who are in the regular army. Unlawful combatants, however, enjoy certain facilities or concessions. They may also be arrested and made prisoners, but they cannot be killed or grievously hurt during war. Q. 59. Define total war. Uns. Total war. In accordance with the traditional definition of war, war is a contest between the armed forces of the belligerent states. Its object is to overwhelm the enemy and impose conditions upon the enemy. As pointed out earlier, this definition has become inadequate in view of the scientific developments and development of destructive weapons in the modern times. In the modern time, war not only affects the armed forces but also the civilian, and the nature of the war is such that observance of the rules of war becomes impossible. Such a war has, therefore, been called total war. The term total war was first used by Grotians. In this view, 30 Years' War of Europe was total war. According to Joseph Elkins, the religious wars of 16th and 17th centuries were fought with such cruelty and barbarity that they can be called total wars. Q. 60. What factors determine the enemy character of 1. Individuals, 2. Corporations, 3. Ships, 4. Goods. Uns. Immediately after the outbreak of war between the states, a significant change comes in their relations. States bring about changes in their behavior against the of enemies in accordance with the objectives States determine their behavior or treatment in accordance with the enemy character of the individual, goods, corporations, ships, etc. Therefore, in order to regulate their activities and behavior, it is necessary to determine the enemy character of individuals, goods, corporations, etc. Once the enemy character of individuals, goods, corporations, etc. is determined, the belligerent states regulates its behavior towards the enemy state accordingly. From the practice of the states and the rules that have been formulated so far, we can derive the following conclusions. 1. Enemy character of individuals. Enemy character of individuals can be studied under the two headings. A. Enemy character of individuals of the belligerent states, and B. Enemy character of the individuals of neutral states. A. Enemy character of the individuals of the belligerent states. In regard to the enemy character of individuals, there is no uniformity in the practice of different states. They determine the enemy character of individuals of belligerent states in accordance with the different tests and standards. For example, in Britain and America, the enemy character is determined on the basis of their residence and domicile. On the other hand, enemy character of the individuals in the continental countries, European countries excepting England, is determined on the basis of their nationality. In other matters, there is hardly any difference in practice of Britain and America on the one hand and continental country on the other hand. B. Enemy character of individuals of neutral states. The individuals of the neutral states who do not reside in the territory or enemy state are not deemed to be having enemy character. But if they participate in activities against the belligerent state, then they may be deemed to having enemy character. Similarly, in accordance with the practice prevailing in America and England, if the individuals of the neutral state carry goods, etc., to the enemy state or territory or continue intercourse with them, then they will be deemed to be having enemy character, or in other words, they will be treated as enemies. But the citizens of the enemy still living in neutral states will not be deemed to be having enemy character. 2. Enemy character of corporations. The enemy character of corporation can be determined mainly by the following two things. A. Their permanent residence, and B. Their registration. If a corporation is registered in enemy state, then it will be deemed to be having enemy character. Similarly, the enemy character of the corporation is also determined by its permanent residence. By a permanent residence of the corporation means its existence and conduct of business. In regard to the enemy character of corporations, the leading case is Daimler Company Limited versus Continental Tire and Rubber Company Limited, 1916, 2, AC 307, wherein important principles were propounded. In this case, the most important principle that was propounded was that if the persons or agents of the corporation who are in de facto control of the company reside in the enemy state or territory, then the company shall be deemed to be having enemy character. 3. Enemy character of ships. The enemy character of ships is determined by their flags. This rule was adopted in Declaration of Geneva, 1909. By the flag of the ship is meant flag which the ship is legally authorized to use. For example, if a ship of France uses the American flag, then it will be unauthorized. If the ship of an enemy state unauthorizingly uses the flag of a neutral state and is seized by the belligerent state, then such a ship shall be deemed to be having enemy character. Consequently, those ships which use the flags of neutral states but are actually under the ownership of the enemy state, may assume enemy character under the following circumstances. I. If the ship is in the service of enemy state or carries arms or takes part in the conflict. E. If the ship resists the valid right of the belligerent state to visit and search, then such a ship may be seized and it may be deemed to be having enemy character. If such a ship is seized, the onus, burden, of proving rests on the owners of the ship that the ship belongs to neutral state. If it is not proved, then the ship and its cargoes are deemed to be those of enemies. 4. Enemy character of goods. Originally, enemy character of the goods is determined by their ownership. If the owners of the goods are residents of the enemy state, then the goods may be deemed to be having enemy character. On the other hand, if the owners of the goods live in neutral state, the goods will not be deemed to be having enemy character. Different countries have modified and amended this rule in accordance with their convenience and needs of times and circumstances. But the general rule which is evident from the general practice of the states is that the enemy character of the goods is determined by the ownership of the goods. 5. Transfer of goods in sea. If the sale of the goods takes place before war or without its consideration, state law is applied to determine whether the transfer of ownership has been effected. If the change in ownership is attempted during war or in view of the war, the goods are deemed to be of enemy character and such goods are not considered to be the property of neutral state and may be confiscated. Q. 61. A joint stock company was formed in 1905 and has its registered office in London. The company was framed for the purpose of selling in the UK motor tyres made in Germany by a company incorporated in that country under German law. The German company held more than 90% of shares in the company in question and all the directors were German subjects. Only one of the shareholders was a British national. During the First World War, the question arose whether the assets of the company were enemy property. How would you decide this question? Ans. On the fact stated above, it was held in Daimler Company Limited versus Continental Tire and Rubbers Company Limited that the assets of the company were enemy property. The following principles of law were laid down in the above case. 1. The enemy character may be assumed by a corporation if its agents or the persons in de facto control of its affairs are resident in an enemy country, or wherever resident, are adhering to the enemy, are taking instructions from or acting under the control of enemies. 2. A company incorporated in the United Kingdom could, as such, be neither friend nor enemy. Yet such a company could only act through its agents, and these might assume an enemy character in time of war when they were resident in the enemy country or were acting under the instructions of enemy shareholders. 3. The character of individual shareholders cannot, of itself, affect the character of the company. It depends on the question whether the company's agents, or the persons in de facto control of its affairs are in fact adhering to, taking instructions from, or acting under the control of enemies. 4. A company registered in the United Kingdom but carrying on business in a neutral country through agents properly authorized and resident here or in a neutral country is prima facie to be regarded as a friend, but may through its agents or persons in de facto control of its affairs, assume an enemy character. 5. A company registered in the United Kingdom but carrying on business in an enemy country is to be regarded as an enemy. Q. 62. The law of war is based on usage hardened into customary law and modified from time to time by law-making treaties. Examine this statement adverting to rules of land warfare. Uns. Rules of land warfare. The laws of war, which had their origin in custom and convention, have undergone rapid changes in recent times. The preamble to the Hague Convention IV of 1907 declared that population and belligerents remain under the protection and rule of the principles of the law of nations as they result from usages established between civilized nations, the law of humanity and the requirements of the public conscience. The existing laws and customs of war are mostly regulated by customary and conventional law. The savage cruelty and ruthlessness with which wars in early times were fought and the great miseries that these wars brought led thinkers and philosophers to formulate rules to regulate the conduct of war, which they found impossible to abolish. The development of the laws of war began in the Middle Ages, under the influence of the Christian ideals of humanity and chivalry. Since then the rule-making process has been going on through the agencies of conference, conventions, treaties and through the persuasive writings of thinkers and jurists. Gradual development influenced by the principles of humanity, morality and chivalry witnessed great progress in the development of the laws of war because of the occurrences of huge political upheavals and because of the Great War that shook Europe. The Declaration of Paris, 1856, the Geneva Convention of 1864. The Declaration of St. Petersburg of 1868 and the Convention relating to the laws of war on land as a result of the First Hague Conference of 1899 are the most important general treaties which helped the development of the laws of war during the latter half of the 19th century. By the end of the 19th century an elaborate body of customs and usages of war found place in the works of eminent leading jurists, but the law in certain respects was uncertain and doubtful and needed classification. The important agencies of development of laws in the 20th century were the general treaties that were concluded under the auspices of the Hague Conferences. The merit of these Hague Conventions lies in their classification of the uncertain customary rules of war that already existed. Some of these conventions were expressed to be binding only in wars, while the signatories to the convention were the belligerents, and thus they provided a loophole for evasion of rules laid down therein. But in spite of this, General Participation Clause, states in general regarded them to be binding and the British courts held them to be valid. The Nuremberg International Tribunal in 1946 expressed the view that those conventions embodied rules of customary law. The failure of several states to ratify some of these Hague Conventions did not affect their validity and binding force. They are now well recognized as embodying customary laws of war. The First World War with its new weapons of destruction found many of the rules of war inapplicable, and the result was that belligerents felt themselves free in many respects in their conduct of a war. In consequence, many of the rules of war perished under the stress of new conditions of warfare. Only a few survived. In the presence of the League of Nations with its system of collective security, the effort to revise and to formulate new rules of war took a concrete shape in the Washington Conference of 1921. The appearance of the Pact of Paris and other international attempts to abolish war did not allow the conference to reach a final agreement on the subject. Then came the Second World War, which shattered many established traditional rules of war, and the principle of military necessity found its widest scope. After the Second World War, the majority of states met at the Geneva Conference and concluded a final act in 1949 for the protection of war victims. The development of the laws or land warfare may be traced through the following general treaties. 1. Geneva Convention, 1864. The Geneva Convention of August 22, 1864, for the amelioration of the condition of wounded soldiers in armies in the field. 2. St. Petersburg Declaration. The Declaration of St. Petersburg of December 11, 1868, prohibiting the use of any explosive or charged with fulminating or inflammable substances. 3. Hague Conventions of 1899 and 1907. The Hague Conventions of 1899 and 1907, concerning expanding, dum-dum, bullets, projectiles, and explosives launched from balloons, projectiles diffusing, asphyxiating or deleterious gases. Concerning the opening of hostilities and concerning the rights and duties of neutral powers and persons, in land warfare. Article 23 of the Hague Convention of 1907 forbade improper use of flag of truce, of the national flag or of military insignia and uniform of the enemy, as well as the distinctive badges of the Geneva Convention. It also forbade killing or wounding an enemy who laid down his arms or surrendered at discretion, having no longer his means of defense. Non-combatants were made exempt from personal injury, except in so far as it resulted incidentally in the course of the lawful operations of warfare, or was inflicted as a punishment for offenses committed against the invaders. Article 25 prohibited the attack or bombardment by any means whatsoever of undefended cities, villages and buildings. Article 23 of the Hague Regulations forbade a belligerent to compel subjects of the other side to take part in the operations of war directed against their own country, even if they were in his service before the outbreak of hostilities. 4. Treaty of Washington. By Article 5 of the Treaty of Washington, 1922, the signatories agreed to prohibit the employment in war of asphyxiating, poisonous or other gases and all other analogous liquids, material or devices. 5. Protocol of 1925. The Protocol of 1925 concerning the use in war of asphyxiating, poisonous and other gases. 6. Geneva Conventions, 1929. The Geneva Conventions of 1929 concerning treatment of the sick, wounded and prisoners of war. 7. Geneva Conventions, 1949. 4 conventions were concluded at Geneva in 1949 relating to 1. The treatment of prisoners of war. 2. The amelioration of the condition of the wounded and sick in armed forces in the field. 3. The amelioration of the condition of the wounded, sick and shipwrecked members of armed forces at sea. And 4. The protection of civilian persons in time of war. Q. 63. What are the prohibited means of warfare? Ans. Prohibited means of warfare. That the belligerents do not possess an unlimited right to injure their opponent has been recognized by the Fourth Hague Convention, 1907. Article 23 prohibited instruments of warfare of a destructive or painful character, prohibited the use of poison or poisoned weapons and employment of arms, projectiles or material calculated to cause unnecessary suffering, and forbade the discharge of projectiles and explosives from balloons and by other new methods of a similar nature. The use of projectiles, the sole object of which was diffusion of asphyxiating and deleterious gases, was also abstained. It was also prohibited to use expanding, dum-dum, bullets. Article 23 forbade improper use of a flag of truce, of the national flag, or of military insignia and uniform of the enemy, as well as the destructive badges of the Geneva Convention. It also forbade killing or wounding an enemy who laid down his arms or surrendered at discretion, having no longer his means of defense. Non-combatants were made exempt from general injury, except in so far as it resulted incidentally in the course of the lawful operations of warfare, or was inflicted as punishment for offenses committed against the invaders. Article 25 prohibited the attack or bombardment by any means whatsoever of undefended cities, villages and buildings. Article 23 of the Hague Regulations forbade a belligerent to compel subjects of the other side to take part in the operations of war directed against their own country, even if they were in his service before the outbreak of hostilities. The St. Petersburg Declaration, 1868, prohibited the use of any projectile of a weight below 400 grams, which was either explosive or charged with fulminating or inflammable substances. The Hague Conference of 1899 adopted declarations renouncing the use of expanding bullets and the use of projectiles, the sole object of which is the diffusion of asphyxiating and deleterious gases. By Article 5 of the Treaty of Washington, 1922, the signatories agreed to prohibit the employment in war of asphyxiating, poisonous or other gases and all analogous liquids, material or devices. Q. 64. Who are prisoners of war and how are they to be treated? Discuss the provisions relating to repatriation of war prisoners and refer to Korean and Pakistani war prisoners. B. Write a short note on the treatment of the sick and wounded combatants in land warfare. Ans. A. Prisoners of war. Prisoners of war are those soldiers who are captured by either of the belligerents in time of war. Sir Robert Fillimore enumerates the following classes of persons having no claim to the treatment of prisoners of war. 1. Bands of marauders, acting without the authority of the sovereign or the order of the military commander. 2. Deserters, captured among the enemy's troops. 3. Spies, even if they belong to the regular army. The laws of war provide for the execution of spies when found by a commander within the lines of his army, or giving information of his plans and movements to the enemy. Their treatment. Prisoners of war must be cared for and treated with humanity. The captor may employ private soldiers, not officers, in useful work, not in any way connected with the operations of the war. The work should also not be excessive. In all cases they must be paid for their work. Non-commissioned officers under the Hague Convention of 1949 are only required to do supervisory work, but they may ask for other work. According to the regulations of 1907, prisoners are to enjoy complete liberty of worship. They may be released on parole if the laws of the country permit that procedure. Prisoners caught in an attempt to run away may be shot in the last resort. If they are captured, they may be punished. The Hague Conferences of 1899 and 1907 charged each belligerent with the task of establishing an information bureau in its territory and sending the necessary information to the government of Hague. Other belligerent after the termination of hostilities. The Geneva Convention of 1929 also made provisions for the treatment of prisoners of war. As between the ratifying states, the convention replaced those of 1864 and 1906. One of the conventions concluded at Geneva in 1949 related to the treatment of prisoners of war, which applies to any armed conflict recognized or unrecognized arising between the contracting parties. The convention prohibits violence to life and person of prisoners, taking of hostages and humiliating or degrading treatment. No physical or mental torture is allowed to be inflicted on prisoners to compel them to give information. After capture, they have to be removed from the danger area. Captivity may be terminated by repatriation, accommodation in neutral countries, release, escape or death of the prisoner. Korean War prisoners. In the Korean War, the main obstacle to armistice was the repatriation of war prisoners. The Communists demanded wholesale repatriation of North Korean and Chinese prisoners of war to Communist territory on the basis of Arts. 118 and 119 of the Geneva Convention relating to the treatment of prisoners of war, 1949, which provides for the unconditional handing over of the prisoners to the authorities on whose behalf they came to fight without delay after the cessation of active hostilities. The United Nations negotiators objected to forced repatriation of unwilling prisoners to the Communists. The truce agreement signed on July 27, 1953, provided that prisoners not willing to return to their land would, in the first instance, be placed into the care of a neutral commission. The prisoners who were unwilling to return to North Korea or China were ultimately screened and dispersed after release. Pakistani war prisoners. The provisions of the Geneva Convention, 1947, lay emphasis on the release of civil internees, while in the case of military prisoners of war on their repatriation. In the case of military prisoners of war, who in the present case constituted 93,000 imprisoned in India during 1971 Indo-Pakistan War, the Geneva Convention does not enjoin automatic repatriation. The phrase, cessation of active hostilities, used in Art. 118 of the Convention means not the suspension of hostilities in pursuance of the ordinary armistice, which leaves open the possibility of a resumption of the conflict, but a cessation of hostilities so as to render a resumption of hostilities highly improbable. It is always a matter of negotiations, and the question of repatriation should only arise simultaneously with the conclusion of a treaty or the prospects of durable peace in the subcontinent. B. Treatment of sick and wounded combatants. The rules for ameliorating the condition of the sick and wounded were laid down by the Geneva Convention of 1864. They were subsequently modified at Geneva in 1906. The Hague Conference of 1907 accepted the obligations of belligerents towards the sick and wounded in land warfare. The sick and wounded combatants, according to the regulations, were to be cared for by the belligerent without distinction of the side or nationality. It was the duty of victorious commanders to protect wounded soldiers on the field from pillage or other maltreatment, as also to collect all the personal belongings found on the persons of the dead, and to forward those things to the authorities of the enemy's country for transmission to those interested. The regulations further provided that it was the duty of the government capturing the sick and wounded to feed and clothe them and treat them in these respects on a level with its own troops. After the First World War, the Convention of 1906 was supplemented by another convention of 1929, which revised the existing rules on the treatment of the sick and wounded in armies in the field. The Geneva Convention of 1864 was finally revised by an international conference at Geneva in the year 1949. The Convention for the Amelioration of the Condition of the Wounded and Sick in Armed Forces, the Field of 1949, provides that sick or wounded persons officially attached to armies must be respected, protected and cared for without distinction of nationality, sex, race, religion or political opinion. It protects aircrafts used as a means of medical transport for the time they are used in transporting medical personnel and material and evacuating wounded and sick. Q. 65. Distinguish between stratagem and deceit, as understood in the law of war. To what extent is either of these legitimate? Illustrate your answer by examples. Uns. Stratagem. According to Lawrence, stratagems are rules practiced on the enemy in order to mislead him and put him off his guard. That they may be used at all is due to the fact that war is a conflict of its quite as much as a conflict of arms. Article 24 of the Hague Regulations permits ruses of war and the employment of methods necessary for obtaining information about the enemy and the country as lawful. Stratagems that do not violate any express or tacit understanding between the belligerents are perfectly lawful and legitimate, as every general is expected to guard against them by his own vigilance and prudence. Stratagem and deceit. Halleck distinguishes between stratagem and deceit, which he calls perfidy, by observing that, whenever a belligerent has expressly or tacitly engaged, and is therefore bound by moral obligation to speak the truth to an enemy, it is perfidy to betray his confidence, because it constitutes a breach of good faith. Thus, for example, stratagems must not be applied where the enemy had been taken off its guard by any of the recognized signs, such as a flag of truce or the Red Cross emblems, of a desire to establish communication or enjoy immunity from attack, nor should they be resorted to in connection with the carrying out of capitulations, which must be done to the letter. Assassination of enemy generals, soldiers or heads of the states, as also the feigning of surrender with the ultimate desire to entrap the enemy, are all sheer perfidies and must not be looked upon as stratagems. The laying of ambushes and traps, the concealing of military operations through false marches, erection of barriers, etc. The feigning of attacks or flights or withdrawals are examples of bona fide ruses of war. Use of pretended signals or the use of the enemy's watchword and giving wide publicity to deceitful intelligence are further examples of ruses of war. Troops engaged in actual conflict must not wear the uniform or carry the ensigns of the enemy. Article 23 of the Hague Regulations forbids belligerents from the improper use of the national flag or of the military insignia or the uniform of the enemy. A stratagem may be retaliated by a stratagem. Thus, as Lauterpacht observes, if a spy of the enemy is bribed to give deceitful intelligence to his employer, or if an officer, who is approached by the enemy and offered a bribe, accepts it feigningly, but deceives the briber and leads him to disaster, no perfidy is committed. Q. 66. Discuss the legality or otherwise of espionage, war treason, ruses and stratagems during the conduct of hostilities between two belligerents. Uns. Espionage. The use of spies in time of war was a measure of recognized legality, notwithstanding the severe penalty inflicted upon the spy if caught by the enemy. In international practice, however, difficulties arose from lack of a sharp distinction between spies, scouts, dispatch bearers and war traitors. The Hague Regulations of 1899 followed the customary law in making the escape of spying to consist in acting, clandestinely or on false pretenses, with the object of obtaining information in the name of operations of a belligerent and of communicating it to the enemy. It was further provided that soldiers not in disguise, properly known as "scouts," might penetrate the enemy's lines to obtain information without being considered spies. So also dispatch bearers, whether soldiers or civilians, were not considered spies if they carried out their missions openly. Persons sent in balloons to deliver dispatches or maintain communications between different parts of the army or territory came within the same category. Upon the outbreak of the Russo-Japanese War, Russia announced the intention of treating as spies war correspondents who should communicate news to the enemy by wireless telegraphy. But the threat was not carried into effect. The regulations provided for the trial of spies before punishment. And they emphasized the legality of the use of spies by providing that a spy who had escaped and was afterwards captured was to be treated as a prisoner of war. The American rules of land warfare emphasized the customary rules that no distinction of sex was made in respect to the penalty inflicted upon spies. War treason. A difficult problem of military occupation during both world wars that arose was what is technically known as war treason. The Hague Regulations forbade the military occupant to compel the population to take the oath to the hostile state, but it was well established by customary law that individual citizens must refrain from communicating in any way with the armies of their own country and from giving them other aid and comfort. Customary law recognized that war traitors might be severely punished and the death penalty imposed for betraying information concerning the condition or operations of the occupying army. Ruses and stratagems. Ruses of war are stratagems employed with a view to misleading the enemy in its military operations. Article 24 of the Hague Regulations does not disallow the employment of ruses of war for the purpose of deceiving the enemy. Laying of ambushes and traps, masking of military operations, the feigning of attacks or withdrawal afford examples of legitimate ruses of war. Q. 67. Discuss the rules or international law in regard to enemy occupation. Illustrate your answer by reference to some justified and unjustified events in the two world wars. Ans. Enemy occupation. Occupation is completed by taking possession of the territory and establishing an administration over the same in the name of the occupying or acquiring state. Article 42 of the Hague Regulations attached to the Fourth Hague Convention of 1907 declares that a territory is said to be occupied when it is actually placed under the authority of a hostile army, and that such occupation is effective only when it is supported by a force sufficient to maintain the authority of the occupant. The inhabitants of the occupied territory are under the military control of the occupant and have to render obedience to his commands. Article 43 of Hague Regulations declares that the occupant shall take all steps in his power to re-establish and ensure, as far as possible, public order and safety while respecting, unless absolutely prevented, the laws in force in the country. The Hague Regulations forbid the occupant to compel the population of the occupied territory to take an oath of allegiance to the hostile power, but permit him to demand from them an oath of neutrality as also an oath to give the same obedience and loyalty though temporary as the lawful sovereign was entitled to. The occupant cannot compel the inhabitants of the occupied territory to give him information about their own troops. Article 56 of the Hague Regulations expressly forbids the seizure or destruction of institutions dedicated to public worship, charity, education, science and art. Historical monuments and works of art or science are likewise to be protected. A movable property as a general rule is incapable of appropriation by an invader. It is bound up with the territory. The profits arising from them are free from confiscation, and the owners are to be protected in all lawful use of them. Article 45. But troops may be quartered in private houses, though the inhabitants may not be ejected from their homes to make more room from the soldiery. Moreover, the need of actual conflict may justify the destruction of buildings or the use of them as fortified posts. Article 53 gives immunity to movable property of the non-combatant population of occupied districts from its seizure unless it consists of arms, war material, etc. Private property has to be respected and cannot be confiscated. Art. 46. Pillage of private property is strictly forbidden. The invader, however, can use neutral property found in the occupied territory on payment of proper compensation. Article 54 provides that submarine cables connecting an occupied territory with a neutral territory are not to be seized or destroyed except in the case of absolute necessity. In the latter case they are to be restored at the conclusion of peace, and indemnities paid for them. The invader, under the Hague Regulations, can punish severely acts falling under war treason. Article 52 of the Hague Regulations forbids the occupant to compel the nationals of the hostile party to take part in the operations of war directed against their own country. The non-combatant inhabitants, however, can be forced to perform any service of non-military character. Non-combatants are prohibited under penalty of death from hostile operation against the occupant, such as giving information to the enemy. Article 50 lays down that no collective penalty, pecuniary or otherwise, might be inflicted on the inhabitants for the acts of individuals, for which they cannot be regarded as collectively responsible. This rule was followed in breach by Germany both in the Great War of 1914–18 and the World War of 1939–45 when that country imposed collective punishment on the inhabitants of that occupied territory in several cases. Article 43 provides that the occupant must respect, unless prevented by laws in force in the country, but he may set up military courts instead of the ordinary courts. The courts, however, pronounce judgment in the name of the legitimate government and not in the name of the occupant power. Requisitions, contributions and fines. The Hague Regulations permit requisitions so far as they are required for the necessities of the army of occupation and are in proportion to the resources of the country. They can be demanded only on the authority of the commander in the locality occupied. They should be made in writing and receipts are to be given for the articles supplied. Contributions are permissible only when the yield is small from taxes and is insufficient to provide for the expenses of the administration. Receipts are to be given to the contributories, although no provisions have been made for the repayment. Article 50 of the Hague Regulations declares that no general penalty, pecuniary or otherwise, can be inflicted on the population on account of the acts of the individuals for which they cannot be regarded as collectively responsible. Geneva Convention, 1949. The ruthless atrocities committed by Germany as a belligerent occupant on the civilian population of the occupied territory during the Second World War necessitated revision of the Hague Regulations and the adoption of the Geneva Convention of 1949. Articles 47–78 of the Convention relating to the protection of civilian persons in time of war deal exclusively with occupied territories and are declaratory of existing provisions, though in some respects they go beyond the provisions of the Hague Regulations. Under Article 49, individual or mass forcible transfers, as well as deportations of protected persons from occupied territory to the territory of the occupying power or to that of any other country, are prohibited. The Convention forbids the occupying power to compel the inhabitants of the occupied territory to serve in its armed or auxiliary forces. The occupying power may not alter the status of public officials or judges in the occupied territories. Art. 54. Destruction of real or personal property of individuals, of the state, or other public authorities is prohibited, except where such destruction is rendered absolutely necessary by military operations. Art. 53. The penal laws of the occupied territory shall remain in force, with the exception that they may be repealed or suspended by the occupying power in cases where they constitute a threat to its security. The death penalty may be imposed by the occupying power on a civilian inhabitant only in cases where the person is guilty of espionage, of serious acts of sabotage against the military installations of the occupying power, or of international offenses which have caused the death of one or more persons. Protected persons shall not be arrested, prosecuted or convicted by the occupying power for acts committed or for opinions expressed before the occupation, with the exception of breaches of the laws and customs of war. Art. 70. Article 55 casts a duty on the occupying power of ensuring the food and medical supplies of the population. Q. 68. Distinguish between military occupation, belligerent occupation and annexation. Give in brief the facts and the principles laid down in Rev. Mons. Sebastião Francisco Xavier dos Remedios Monteiro vs. the State of Goa, decided by the Supreme Court of India. Uns. Military occupation, belligerent occupation and annexation. Military occupation is temporary de facto situation which does not deprive the occupied power of its sovereignty, nor does it take away its statehood. All that happens is that pro tempore the occupied power cannot exercise its rights. In other words, belligerent occupation means that the government cannot function and authority is exercised by the occupying force. Annexation, on the other hand, occurs when the occupying power acquires and makes the occupied territory as its own. Annexation gives it the jure right to administer the territory. Annexation means that there is not only possession but uncontested sovereignty over the territory. As Greenspan put it, military occupation must be distinguished from subjugation, where a territory is not only conquered, but annexed by the conqueror. There is, however, a difference between true annexation on the one hand and premature annexation, or as it is sometimes called, anticipated annexation, on the other. Jurists regard annexation as premature so long as hostilities are continuing and there is an opposing army in the field, even if the occupied power is wholly excluded from the territory. Anticipated annexation by unilateral action is not true annexation. True annexation is only so when the territory is conquered and subjugated. In Reverend Mons. Sebastião Francisco Xavier dos Remedios Monteiro vs. the State of Goa, the 26th of March 1969. The Supreme Court of India observed that the Geneva Conventions rightly lay down that annexation has no effect on the protection. But they speak of premature or anticipated annexation. Premature or anticipated annexation has no effect. Such a plea was negatived for the same reason by the Nuremberg Tribunal. In fact, when the convention itself was being drafted, the experts were half inclined to add the word "alleged" before annexation in art. 47 to distinguish between annexation following conquest and subjugation and annexation made while hostilities are going on. Subjugation puts an end to the state of war and destroys the source of authority of the existing government. In subjugation, which is recognized as one of the modes of acquiring title, not only the de facto but also the de jure title passes to the conqueror. After subjugation, the inhabitants must obey the laws such as are made and not resist them. Thus the principle which is accepted is that the occupying power must apply the convention even when it claims during conflict to have annexed the occupied territory. However, when the conflict is over and there is hostile army in the field, annexation has the effect of creating a title to the territory. The question, when does title to the new territory begin, is not easy to answer. Some would make title depend upon recognition. Mr. Stimmon's doctrine of non-recognition in cases where a state of things has been brought about contrary to the Pact of Paris, was intended to deny root of title to conquest. But when Italy conquered Abyssinia, the conquest was recognized because it was thought that the state of affairs had come to stay. Thus, although the United Nations Charter includes the obligation that force would not be used against the territorial integrity of other states, Art. 2, Para 4, events after the Second World War have shown that transfer of title to territory by conquest is still recognized. Prof. R. Y. Jennings poses the question, what is the legal position where a conqueror having no title by conquest is nevertheless in full possession of the territorial power, and not apparently to be ousted? He recommends the recognition of this fact between the two states. If cession after defeat can create title, occupation combined with absence of opposition must lead to the same kind of title. In the present case, Goa, which was a Portuguese colony for about 450 years, was occupied by the Indian Armed Forces on December 19, 1961, following a short military action. The military engagement was only a few hours' duration and then there was no resistance at all. The Geneva Convention ceased to apply after December 20, 1961. The Indian government offered Reverend Father Montero Indian nationality and citizenship, which he refused and retained his Portuguese nationality. As a Portuguese national, he could only stay in India on taking out a permit. He was, therefore, rightly prosecuted under the laws applicable to him. Q. 69. Write a note on the warfare on the sea. Point out the main laws of maritime warfare. Uns. Laws of maritime warfare. Before the 19th century, laws of maritime warfare were mostly in the form of customs. Since 19th century, several international conferences have been held, and as a result of which at present, besides the customs The laws of maritime warfare are mainly in the following international treaties or declarations. 1. Declaration of Paris, 1856. 2. Hague Convention, 1907. 3. Geneva Submarine Protocol, 1936. Following are the main laws of maritime warfare. 1. Attack on public and private enemy ship. During naval war, the belligerent states are entitled to attack the enemy ships and destroy their property. The general rule admits the following exceptions. A. Hospital ships. According to Hague Convention, 1907, hospital ship cannot be attacked. B. Vessels employed in religious, scientific and philanthropic works. According to Hague Convention of 1907, vessels employed for religious, scientific and philanthropic missions can neither be seized nor attacked. To attack or seize such ships has been declared illegal according to the said convention. C. Cartel ships. Cartel ships or ships carrying prisoners of war cannot be attacked. Attack on such ships has been prohibited by the rules of maritime warfare. D. Fishing smacks and market boats. In accordance with the provisions of the Hague Convention, fishing smacks and market boats engaged in their local profession and which are unarmed cannot be seized or otherwise destroyed during naval war. A. Immunities of merchants. Hague Convention of 1907 provides the following immunities to the merchants. I. After the beginning of the war, the merchants detained in the ports are given certain facilities. E. Those merchants and persons who have reached the ports because of their lack of knowledge of war have also been provided certain facilities. E. Mail boats and mail bags. Maritime rules of international law provide certain immunities in regard to mail bags and mail boats. On the basis of the experience of the First World War, states have entered into treaties in this connection and have agreed to provide certain protections and immunities to mail boats and mail bags. 2. Merchant ships of enemy. Merchant ships of enemy can be destroyed during maritime warfare. 3. The crew of the ship. As pointed out earlier, enemy ships can be destroyed during naval warfare. However, it is provided that while sinking or destroying the ship, proper and necessary articles, papers, etc., on the board of the ship. Such crew and passengers of the ship cannot be attacked unless and until they resist valid right of the belligerent state to visit and search the ship. 4. Merchant ships are entitled to defend themselves against the attack of the enemy. 5. During maritime warfare, merchant ships can be converted into men of war, warships. According to British practice, the conversion of merchant ships into men of war can be made by belligerent state in its own port. It cannot be made in a neutral port. 6. Bombardment of the coastal cities. According to Hague Convention, coastal cities can be bombarded or otherwise attacked during maritime warfare, but bombardment over undefended cities has been prohibited. This could be done only when the local inhabitants resist the supply of food materials and other essential supplies to the enemy. 7. Ordinarily only the places of military importance can be bombarded. Other places can be bombarded only when they are necessary for the achievement of military objectives. 8. Contact mines. It is laid down in the Hague Convention that the laying of anchor-less contact mines is contrary to international law. As regards the laying of floating mines under the sea, it is provided that they should not be laid indiscriminately. It is the duty of the belligerent state laying such mines to give intimation of the area where such mines have been laid to neutral and other states. As rightly pointed out by Stark, unfortunately the law as to mines is uncertain because of the weakness of the text of the Hague Convention 8, submarine contact mines, and because of the development of new types of mines and new kinds of mine-laying methods. Q. 70. State the law that governs submarine warfare. Uns. Law of submarine warfare. Following are the main rules relating to the laws of submarine warfare. 1. It was laid down in the Treaty of Washington, 1922 that the use of submarine to destroy merchant or commercial ship was against international law and hence it was prohibited. 2. Next important treaty which laid down rules relating to submarine is the London Naval Treaty of 1930 signed by the US, UK, France, Italy and Japan. Article 22, Part 4, of the treaty provided that rules of international laws relating to surface vessels would also apply to submarines, particularly in respect of the attack on merchant ships. Thus a submarine should not sink a merchant vessel without ensuring the safety of the passengers, crew and papers of the ship. As made clear in Article 23 of the treaty shall remain in force for an indefinite period. 3. Yet another landmark is the London Submarine Protocol of 1936 which was signed by the US, UK, France, Italy and Japan in London. It incorporated Part 4 of the Naval Treaty of 1930 mentioned above. Germany and USSR acceded to the protocol in 1936 and 1937 respectively. But as pointed out Prof. DPO, Council, in the case of submarine warfare, the rules in London of 1936 are viable only in the ideal circumstances which are unlikely to ever occur in practice. Self-defense is then the only criterion of submarine warfare and it becomes a matter of technological evaluation to ascertain the factors proportionality and necessity which legitimize submarine warfare in times of limited hostilities. 4. Last but not the least instrument is the Neon Agreement of September 1937 dealing with the suppression of attacks by submarines against merchant vessels. A remarkable thing about this agreement is that it provided that the provision of the Treaty of 1930 and London Protocol of 1936 were declaratory of international law. As with other rules of war, the above rules were also flagrantly violated during Second World War. Q. 71. What steps have been taken to regulate the use of aerial warfare? Uns. Aerial warfare. The Second World War brought about a complete transformation in the conception of international law in relation to aerial warfare by the use of atom bomb. The rules laid down at various conferences may, however, be summarized as under. The Brussels Conference. In 1874 at the Brussels Conference convened at the instance of the Emperor of Russia rules on law and usages of air warfare were laid down. The rules laid down that towns, agglomerations of houses, or villages, which were open or undefended, could not be attacked or bombarded. All necessary steps should be taken to spare, as far as possible, buildings devoted to religion, arts, science, and charity, hospitals and places where sick and wounded were collected, on condition that they were not used at the same time for military purposes. The Hague Conference. The First Hague Conference of 1899 attempted to prescribe definite rules with regard to aerial warfare. It laid down that the attack or bombardment of towns, villages, dwellings or buildings which were undefended was prohibited. It forbade the discharge of projectiles and explosives from balloons, or by other similar new methods for a period of 5 years. The convention laid down that a neutral power was bound to see that no fight on the air took place. The Institute of International Law at Madrid. The Institute of International Law at Madrid in 1911 adopted the principle that aerial war is allowed provided that it does not present for the person or property of the peaceable population greater dangers than land or sea warfare. First World War. During the First World War, the distinction between combatants and non-combatants almost disappeared, and by the end of the war, bombardment of open towns outside the region of military objectives had almost become a common feature. Washington Conference. As a result of the First World War, it was found that the regulations for the use of aircraft in war were utterly inadequate to meet the exigencies of the situation. Accordingly, in 1922 at the Washington Conference on the Limitation of Armaments, a resolution for the appointment of a commission of jurists to consider the problem of aerial warfare was passed, and the Committee on Aircraft to the Washington Conference enunciated in 1923 various provisions of the proposed Code of Air Warfare Rules. The code was, however, not ratified, but still the various provisions serve as a guide for the use of aircraft in land and naval warfare. The important clauses embodied in the Air Warfare Rules, 1923, may be summarized as under: 1. Arming of private aircraft even in self-defense is absolutely forbidden. 2. Aerial bombardment for the purpose of terrorizing the civilian population, of destroying, damaging private property not of military character, or of injuring non-combatants is prohibited. 3. Aerial bombardment for the purpose of enforcing compliance with requisitions in kind or payment of contributions in money is prohibited. 4. Aerial bombardment is legitimate only when directed at military objective, the destruction of which would constitute distinct military advantage to the belligerent, e.g. military establishments, munition factories, and lines of communication used for military purposes. 5. Aerial bombardment is not legitimate even when directed at a military objective if it cannot be bombarded without the indiscriminate bombardment of the civilian population. 6. Bombardment of cities, towns or buildings not in the immediate vicinity of the operations of land forces is prohibited. 7. Bombardment in the immediate neighborhood of the operations of land forces is permitted only when there exists a reasonable presumption that the military concentration is sufficiently important to justify such bombardment. 8. Buildings devoted to public worship, art, religion, science, charity, historical monuments and hospitals for refugees are to be spared. 9. The laws of war and neutrality applicable to land troops are applicable to aerial warfare also. 10. A belligerent state is liable to pay compensation for injuries to persons or to property caused by the violation by any of its officers or forces of the provisions of the above rules. The Geneva Protocol. The Geneva Protocol of 1925 prohibited the use of gas and bacteria in warfare. Disarmament Conference. The General Commission of the Disarmament Conference adopted a resolution in July 1932 which provided that air attack against civilian population shall be absolutely prohibited. Second World War. The Second World War witnessed an utter disregard of the rules of aerial warfare. There was a complete violation of the rules by indiscriminate bombing by German aircraft. The British and American air fleets also in their turn carried on an equally indiscriminate and ruthless bombing of German cities. The whole war was fought without any regard of the rules of warfare, and non-combatants were mercilessly killed and buildings devoted to public worship, art, religion and historical monuments were bombarded. As the climax of it all came the use of the flying bomb by Germany and atomic bomb by America against Hiroshima and Nagasaki on August 6 and 9, 1945, respectively. Without giving due warning of danger to non-combatants and in defiance of the protests of many of the scientists who had worked on the project. While the use of flying bombs was spread over a number of months, the atom bombs caused heavier destruction in a very short time. The use of atom bomb in the war was a violation of the rules of international law governing civilized warfare from times immemorial. Its use is a crime against international law and humanity. The Nuclear Test Ban Treaty, 1963, banned nuclear tests in the atmosphere, in outer space and underwater. This agreement greatly reduced the dangers of radioactive fallout by restricting nuclear tests to underground. The Outer Space Treaty of 1967 prohibited the stationing of nuclear arms in space. Under the Treaty on the Non-Proliferation of Nuclear Weapons, which came into force on March 5, 1970, the signatories pleaded not to assist other countries in any way to acquire nuclear weapons. The ban on emplacement of nuclear weapons on the seabed, banning nuclear weapons on the Moon or in orbit around the Earth, the UN Convention on the Prohibition of Bacteriological and Toxic Arms, 1972, and the US-Soviet Treaty on the Limitations of Anti-Ballistic Missile Systems, 1972, are other achievements in the field of arms limitation. On July 3, 1974, the USA and the USSR agreed on a partial ban on underground nuclear testing to be effective from March 31, 1976. Q. 72. What do you understand by the legality of nuclear tests? Give you answer with examples. Ans. The Pokhran explosion. On May 18, 1974, India successfully carried out her maiden underground nuclear explosion at Pokhran in the Thar desert of Rajasthan. While it was hailed by some countries as a significant achievement, others, for example, Canada, Japan, United States and Pakistan, reacted adversely to it. Indian Prime Minister and other Indian government spokesmen repeatedly assured the world that the explosion was not designed to manufacture nuclear weapons, but to harness the energy for the peaceful purposes. The Pokhran test raised the question whether it violated any rules of international law. Two treaties are relevant to the present discussion, namely, the Nuclear Test Ban Treaty, 1963 and the Treaty of Non-Proliferation of Nuclear Weapons of 1968. The Nuclear Test Ban Treaty under Article 1 prohibits nuclear explosion in the atmosphere including outer space, water and in any other environment if such explosion causes radioactive debris to be present outside the territorial limits of the state under whose jurisdiction or control such explosion is conducted. Thus, under this treaty, underground nuclear test is not prohibited. Moreover, a nuclear explosion which causes radioactive debris to be present at the territorial limits of the state under whose jurisdiction or control such explosion is conducted will also be contrary to this treaty. It is now well established that the Pokhran test was fully contained one. It did not lead to an considerable increase in radioactivity in the atmosphere and it did not at all affect the neighboring or other sovereign states. A sovereign state is free to do anything within its territory so long as its act does not affect other states. As regards the Treaty on Non-Proliferation of Nuclear Weapons 1968, India is not party to it and therefore, the question of violation of its provisions does not at all arise. It may be noted that India did not join this treaty because in her view this treaty would perpetuate the already established monopoly of the big powers over nuclear weapons. Besides, being highly discriminatory, the treaty places totally unjustified restrictions on the peaceful uses of atomic energy. Besides this, the Pokhran explosion is also not contrary to general and customary international law. In view of the above discussion, it may be concluded that nuclear test conducted by India at Pokhran was not contrary to the rules of general international law or applicable treaty norms. India was within her legal rights to explode the nuclear device. The criticism by some nations of India was clearly motivated by extra-legal and political considerations. Case of shooting down of a Pakistani plane by Indian armed forces during Kargil conflict. Pakistan filed a case in the International Court of Justice against India claiming compensation for shooting down of a Pakistani plane by Indian armed forces. India challenged the jurisdiction of the World Court on the ground that under the similar agreement India and Pakistan had agreed to settle their disputes bilaterally and not to refer it to a third party. Accepting India's claim, the World Court held that it had no jurisdiction to decide the case and dismissed the case. It was yet another Pakistani defeat in respect of the Kargil conflict. Q. 73. What do you mean by war crimes? Discuss the various categories of war crimes. Ans. Professor Oppenheim has given a wider definition of war crimes in the following words. War crimes are such hostile or other acts of soldiers or other individuals as may be punished by the enemy on capture of the offenders. The Nuremberg Tribunal classified the crimes punishable under international law into the following three categories. 1. Crimes against peace. 2. war crimes, and 3. Crimes against humanity. 1. Crimes against peace. Article 6 of the Charter of Nuremberg enumerated following crimes against peace: planning, preparation, initiation, or waging of a war of aggression, or a war in violation of international treaties, agreements or assurances, or participation in a common plan or conspiracy for the accomplishment of any of the foregoing. 2. War crimes. An exhaustive definition of war crimes has been given in Principle IV of the said report. According to it, war crimes are the violation of the laws and customs of war, which include but are not limited to murder, ill treatment or depredation to forced labor or for any other purpose of civilian population or in the occupied territory, murder or ill treatment of the prisoners of war or persons on the seas, killing of hostages, plunder of public property, wanton depredation of cities, towns or villages, or devastation not justified by military necessity. 3. Crimes against humanity. The Nuremberg Charter described crimes against humanity as the crimes such as murder, extermination, enslavement, deportation and other inhumane acts committed against any civilian population before or during the war of persecutions on political, racial or religious grounds in execution of or in connection with any crime within the jurisdiction of the tribunal, whether or not in violation of the domestic law of the country where perpetrated. While speaking before the Committee of the General Assembly considering the report of the International Law Commission, Indian Ambassador Mr. G.R. Gharekhan said that India extended her support to the formulation of a comprehensive code of crimes against peace and security of the mankind, and that it should be made an effective instrument of international legal significance. Crimes such as genocide, apartheid and slavery should be included in the list of crimes against humanity. As regards war crimes, he said that India favored replacement of the term with violations of rules of armed conflict. Recently, i.e. in October 1992, the UN Security Council authorized to investigate the war crimes committed in Bosnia. Though its scope is not very wide, it represents a landmark in the history of the United Nations. It is no doubt not a permanent machinery, but it will certainly establish an important precedent. Q. 74. Present briefly the main arguments, A. for and B. against the validity of the Nuremberg trial, and evaluate the importance thereof in the future development of international law. Ans. A. Nuremberg trial. The justification for the Nuremberg trial was sought on the ground that the League of Nations, including Germany, had declared aggressive war to be a crime, on September 24, 1927. Then the Kellogg-Briand Pact, or the Pact of Paris, which was signed in 1928 on the initiative of Frank B. Kellogg, at the time U.S. Foreign Secretary, in cooperation with Briand, French Foreign Minister, condemned war as an instrument of settling international disputes and undertook to settle such disputes by peaceful methods. The signatory nations were almost all the nations of the world, including Germany, Japan and Italy. They had bound themselves not to resort to war as an instrument of national policy. Unprecedented atrocities aroused a united determination in all the Allied countries to exact retribution, and the victory of the Allied armies by occupation of Germany enabled them to take immediate steps for the constitution of a military tribunal to avoid the fiasco of the Versailles War trial provisions. B. Criticism of the trial. Great reliance was placed on the Pact of Paris or the Kellogg-Briand Pact of 1928. Such implicit reliance could not be placed on it for the launching of the prosecution of the vanquished leaders and generals. In the first place, neither the Pact of Paris nor the Hague Conventions of 1899 prescribed any sanctions for the enforcement of the provisions contained in them. The words of the pact were not those of a penal statute. They were the language of theology, not of law. In the second place, although the Kellogg-Briand Pact declared aggressive wars as illegal, such illegality could by no stretch be transformed into international crime so as to make each individual participant liable for the same. In the last place, the Pact of Paris ever since its inception was followed in breach. Schick, in his book, The Nuremberg Trial, entertains grave doubts about the correctness of the assertion of the Allies that the Charter of the International Military Tribunal was based on a historical legal precedent. It has also been suggested that the Court of Victors was not a proper tribunal which should have been represented by neutral and German judges as well. It could by no stretch be termed an international court. Professor Smith contends that the trial violated the fundamental principle of impartiality, the ideal symbolized by the traditional figure of justice blindfolded and holding a balanced scale. Although the tribunal refuted the contention raised by the defendants that there can be no punishment of crime without a pre-existing law and that ex post facto punishment is abhorrent to the law of all civilized nations, eminent jurists have doubted the correctness of the principles of law laid down by the tribunal on this point. Schick observes that the Charter applied with retrospective effect, which was a rule contrary to municipal law of civilized nations and was, therefore, in violation of international law. Professor Smith further observes that until 1942 the British Manual of Military Law contained an article, ch. 14, art. 443, to the effect that superior orders constituted a good defense to charges of war crimes. In April 1942, the War Office by an amendment destroyed the defense of superior orders. This, observes Professor Smith, was an extreme example of legislation ex post facto. The main objection against the trial was that the prosecution of members and servants of a government for leading their country into aggressive war amounted to retroactive criminal legislation and violated the salutary principle of criminal law that no punishment was to be imposed for an act not defined as a crime with stated penalties by law in force at the time of commission. Importance of the trial in international law. The Nuremberg trial has set up a new precedent in the history of international law and constitutes a milestone in its progress. The trial clearly establishes that the plea of obeying orders of a superior or of his government does not relieve him from responsibility under international law provided a moral choice was, in fact, possible to him. This trial has enhanced the sanctity of solemn agreements and undertakings like the Kellogg Pact. International law is now no more regarded a branch of ethics. It received new vigor and strength on account of the principles laid down at the trial. The trial emphasized that international law cannot work in vacuum, and for its proper functioning with greater momentum it has to depend upon the spirit of cooperation of the individuals who are to be regarded as the pillars for the preservation of international law by showing that it is no respecter of persons. Any person committing a crime under international law, whether highly placed or not, shall be adjudged guilty and punished on a fair trial on the facts and law. The trial has enunciated in unambiguous terms the principles of international law regarding preparation of war, occupation of enemy territory, execution of hostages and treatment of prisoners. Q. 75. A German officer instructed an escort of British airmen not to interfere with civilians who might molest the prisoners. When the prisoners were marched through Essen, a crowd collected and killed the prisoners. The officer who gave the instructions, the sergeant in charge of the escort, and 3 civilians who are alleged to have actively participated in the killing are accused of having committed war crimes. Discuss. Uns. Ill-treatment and killing of prisoners of war amounts to war crime because these are in violation of the recognized rules of warfare. So the German officer, the sergeant in charge of the escort, and the 3 civilians who participated in the killing of the prisoners of war have committed war crime according to the established rules of international law and custom. Q. 76. Define. A. The Scuttled and Boats case. B. Tokyo trial. Uns. A. The Scuttled U-Boats case, 1940, 1 Law Reports of Trials of Criminals 55. This case relates to war crimes and the punishment of war criminals. The Northwestern Command of the German Armed Forces surrendered on May 4, 1945 before the Allied nations. The surrender included all the sea vessels in the said area. The surrender was made in consequence of an armistice agreement. After the signing of the instrument of surrender but before it came into effect, the German officers ordered their subordinate officers to scuttle the U-boats. Later on this order was countermanded. But the accused, who was an instructor of the U-boats, ordered the scuttling of U-boats, and consequently the U-boats were scuttled. The accused was arrested and was prosecuted for violating the laws of war. In his defense, the accused put forward the following 2 arguments. I. The terms of the instrument of surrender were not known to him as they were not intimated to him. E. He did not know or receive the information of countermanding of the original order regarding cutting of U-boats. The accused was held guilty and was sentenced to 5 years imprisonment. The court held that by May, it had become clear that the U-boats had become the property of the Allied nations and could not therefore be destroyed. The court propounded the following principles. I. If the armed forces of a state surrender after an armistice agreement, then the agreement shall be binding on both the states, i.e. the surrendering state and the state to whom the surrender is made. If after the surrender, the soldiers do not observe and follow this agreement, they will be guilty of the violation of the law of war. E. If a person scuttles the boats or otherwise causes harm to them after the armistice agreement and surrenders in pursuance thereof, he will be guilty of war crimes because after the surrender war boats become the property of the conquering state. Ans. B. Tokyo Trial. As Nuremberg Tribunal was established to try war criminals of Germany, the Tokyo Tribunal was established to try the war criminals of Japan. The Tokyo Tribunal was established by the victorious states by making an agreement and subsequently by issuing a charter conferring jurisdiction upon the court. The Tokyo trial started hearing on June 4, 1946, and was presided by Sir William. A special feature of this trial was that its judges were not only from the victorious states, but some of the judges belonged to other states also. For example, the eminent Indian jurist Dr. Radha Vinod Pal was one of the judges of the Tokyo Tribunal. Besides this, there were some judges from Philippines and other countries of the Commonwealth of the Nations. During the trial, the accused objected that they could not get justice from this trial because most of the judges belonged to the nations which defeated Japan. But this objection was rejected by the court. The Tokyo Tribunal awarded death sentence to those persons who were guilty of conducting and organizing war and awarded imprisonment for different terms to other persons accused of war crimes. Q. 77. Define. A. Peleus trial. B. Eichmann case. C. My Lai trial. Ans. A. Peleus trial. Peleus was a Greek ship which was sunk by the German U-boat. After sinking the ship, the commanders of the U-boat ordered firing upon the members of the crew of the ship who were trying to save their lives through lifeboats. Thus, out of 35 people, 22 members of the crew lost their lives in consequence of firing. After some weeks, when on account of air attacks, the U-boats were compelled to come to the coast, officers on board of the boats were arrested and were prosecuted for war crimes. The court ruled that it is the fundamental usage of war that firing on unarmed enemies is prohibited. The court referred to an old case, namely, Llandovery Castle, 1921, wherein it was laid down, to war of land the killing of an unarmed enemies is not allowed. Similarly, in war at sea the killing of shipwrecked people who have taken refuge in lifeboats is forbidden. During the trial, the accused contended that they were not guilty because they fired on the orders of the superior officers. But the court rejected the plea of superior orders and held that they were bound to obey only lawful orders of their officers. There is no duty to observe orders which are not lawful. Consequently, the accused were held guilty and were duly punished. B. Eichmann case, 1962. Under Hitler, Eichmann had committed many Nazi atrocities upon the Jews. The charge against him was that he was responsible for the murders of lakhs of Jews and for inhuman treatment towards them. The spies of Israel were after him for a long time, but he was fleeing from one country to another and escaping arrest and trial. Ultimately, the Israeli spies caught him in Argentina. But on account of the fear that the government of Argentina might not extradite him for prosecuting him for having committed war crimes, the Israeli spies took him from Argentina to Israel in an irregular way. In Israel, Eichmann prosecuted for war crimes and was sentenced to death. An appeal was filed in the Court of Israel. It was contended on behalf of Eichmann that the courts of Israel did not possess the jurisdiction to try him because when the crime were committed by him, Israel as a state did not exist. That is to say, crime was committed during the Second World War and Israel came into existence after that. But the Supreme Court of Israel rejected this argument and propounded the principle of universal jurisdiction in respect of war crimes and genocide. See My Lai trial. My Lai is a village in Vietnam, the whole of population which was killed by American military personnel. It was clearly a war crime. Consequently, there was a great reaction in the international community. America was charged of having encouraged perpetration of war crimes of military officers in Vietnam. American nationals also expressed their resentment against atrocities and war crimes. Due to the reaction of the international community as a whole and the pressure of the American nationals at home, the government of America was compelled to hold a trial of the officer responsible. Lieutenant Cale. The court held the accused guilty and awarded punishment to him. My Lai trial is a landmark event, in respect of the punishment awarded to war criminals for the violation of the war crimes. Hitherto war trials were such wherein the victorious state had conducted the war crimes trials against the criminals of the vanquished nations. But My Lai trials marked the beginning of a new trend which shows that there will be circumstances wherein because of the reaction or public opinion of the international community and the pressure of its own nationals, a state may be compelled to hold war criminals trials against its own officers. It is undoubtedly an auspicious beginning and augurs well for the observance of laws of war in future. Q. 78. Define genocide with at least one example. Ans. Meaning and definition of genocide. Article 2 of the Genocide Convention defines the term genocide. According to it, genocide means any of the following acts committed with intent to destroy in whole or in part a national, ethnical, racial or religious group as such. A. Killing the member of the group. B. Causing bodily or mental harm of the group. C. Deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. D. Imposing measures intended to prevent births within the groups. A. Forcibly transferring children of one group to another group. Genocide, a crime under international law. The term genocide was coined by Lemkin, a private individual, whose efforts played a large part in promoting the United Nations work on genocide. Article 1 of the Genocide Convention, 1948, therefore, provides that the contracting parties confirm that genocide, whether committed in time of peace or in time of war, is a crime under international law which they undertake to prevent and punish. Under Article 3 of the Convention, following acts are punishable: b. Conspiracy to commit genocide. c. Direct and public incitement to commit genocide. d. Attempt to commit genocide. And a. Complicity in genocide. Article 5 of the Genocide Convention. Example of genocide in Bangladesh. The military regime of Pakistan under General Tikka Khan committed genocide which is unprecedented in the annals of world. As pointed out by M.K. Nawaz, the Bengali people have a language and culture different from the people of West Pakistan. Can accordingly be considered as ethnical group within the meaning of Article 2 of Genocide Convention. Justice V.R. Krishnaiyer, the then member of the India Law Commission, has also pointed out, the Bengali population of East Pakistan probably falls under the national and ethnical group, not merely territorial or linguistic. Thus the genocide committed by Pakistani military personnel in Bangladesh was clearly and without a shade of doubt an international crime. Justice V.R. Krishnaiyer has remarked, the scenes of blood and bestiality ensuing from the military crackdown under General Tikka Khan's deadly direction was such the like of which no eye had seen and no tongue would adequately tell. Bangladesh is fortunately free today, but its sweetest songs of freedom are those that tell of saddest thought of the million dead. The appalling human annihilation perpetrated by military personnel of Pakistan in Bangladesh, its dimensions and dastardliness prima facie constitutes an international crime. Q. 79. What are the different modes of termination of war? Ans. Modes of termination of war. Generally, the following are the modes of termination of war. 1. Simply cessation of hostilities. Sometimes, during the war the belligerent states cease hostilities without any definite understanding being reached between them. The examples of such types of cessation of war are between France and Spain, 1770, war between Russia and Prussia, 1801, war between Spain and Chile, 1878, etc. Termination of war through this mode is not in accordance with the present circumstances because in this mode of termination of war, no agreement or understanding is reached and it does not determine as to what will be the fate of prisoners of war. How shall boundaries be fixed or determined, and what shall be the fate of the property under the occupation of the belligerent state or other type of property? Consequently, this mode of termination of war presents many difficulties. 2. Conquest followed by annexation. Sometimes it so happens that a belligerent state conquers another state and annexes it into its territory. According to international law, the annexed territory or state ceases to have any independent importance under international law. This mode of termination of war may present difficulties when the belligerent state concerned has annexed the territory in violation of the rules of international law. There is no clear rule of international law in this connection. However, it is definite that the war comes to an end after one belligerent state conquers the other belligerent state and annexes the territory of that state into its own territory. 3. By a peace treaty. War may also be terminated by the conclusion of a peace treaty. The advantage of this mode of termination of war is that some understanding is reached in regard to that treatment of prisoners of war, property and other relevant matters connected with war. The principle of post liminum also comes into force when war comes to an end through this mode. According to this principle, in the absence of any agreement to the contrary, the persons and things come to their original position after their release from the occupation of the enemy. 4. by armistice agreement. Sometimes wars are terminated by the conclusion of armistice agreement. Under this mode of termination of war, the hostilities cease for temporary period, but since the state of war continues between the states, the war may erupt at any time. 5. By unilateral declaration of one or more of the victorious powers. Sometimes war may come to an end by the unilateral declaration of one or more of the victorious powers. For example, Indo-Pak War of 1971 came to an end in consequence of the unilateral declaration by India to end the war. The war came to end because Pakistan also respected this declaration and ceased hostilities. It is not essential that the date of the termination of war should also be the date of conclusion of peace treaty, or the date when the hostilities actually ceased. It is a matter to be determined by state law. There is no rule of international law which binds states to treat the conclusion of war as the date of the conclusion of peace treaty. Q. 80. Explain doctrine of postliminium with a case law. Also describe the limitations of the doctrine. Ans. Doctrine of postliminium. The doctrine of postliminium was incorporated into international law from Roman law. According to it, persons and things released from the occupation of the enemy come to their original position, or they are restored to their original position after the end of war. According to Roman law, this was applied on persons and things. According to international law, this is applied in the context of war. If any state remains under the occupation another state for a temporary period and then consequently becomes independent after its independence, persons and things come to their original position in accordance with the principles of postliminium. This principle cannot, however, be applied in matters of neutral states. Private movable property can be seized by the occupying power and therefore, the principle of postliminium does not apply on such properties. However, public property can be seized by the belligerent states only when and insofar as is essential for the objectives of war. If after withdrawal of the enemy the property remains, then it comes or is restored to its original position. The principle of postliminium also applies on a movable property. In fact, the principle of postliminium applies only when the occupying power has exceeded its powers or has acted beyond its rights. Thus the legal and valid acts performed by the occupying power are beyond the scope of the principle of postliminium. Limitation of the doctrine of postliminium. Following are the limitations of the doctrine of postliminium. 1. It does not apply upon the valid and lawful acts performed by the occupying power. They remain valid even when such occupation ends. 2. This principle also does not apply in case of the realization of taxes made by the occupying powers. 3. The principle of postliminium does not apply in respect of the neutral states. 4. It does not apply when one state incorporates another state into its state conquest because conquest followed by annexation changes the status of things and persons. 5. Another limitation of the doctrine of postliminium is that it does not apply when an enemy state has finally incorporated the territory concerned as of its territory. Case of Elector of Hesse-Kassel. This case is related to the principle postliminium. Hesse-Kassel was a neutral state which was conquered and annexed by France in 1806. Consequently, a elector of Hesse-Kassel fled away from its territory. In 1898, in accordance with a treaty, a elector regained his lost territory. After the death of former elector, his son claimed to realize past debts on the basis of the principle of postilminium. But he could not succeed. In this case, it was held that after the conquest, the conquering states is fully entitled to realize taxes, etc. Napoleon was therefore within his rights to realize debts, etc. Since it was a valid act performed by the occupying power and it was within the right of Napoleon, the principle of postilminium could not be applied in this case. Q. 81. What do you mean by neutrality? Mention the essential elements. Discuss the development of law of neutrality. Ans. Meaning and definition of the term neutrality. As pointed out by Oppenheim, neutrality is the attitude of impartiality adopted by third states towards the belligerent and recognized by belligerent. Such attitude creating rights and duties between the impartial states and belligerents. On the basis of the above definitions, we may conclude that there are following three essential elements of neutrality. 1. Attitude of impartiality. Neutral state is a state which does not take part in war and remains impartial. This impartiality is one of the essential elements of neutrality. 2. Recognition of impartiality by belligerent states. It is also necessary that this impartiality should be recognized by the belligerent states. 3. Creation of rights and duties. The recognition of attitude of impartiality of the neutral state gives rise or creates certain rights and duties. It gives certain rights to neutral states and also imposes certain duties upon it. Similarly, the neutral state also acquires certain rights because of the attitude of impartiality and adopted during the war between the two belligerent states. These rights and duties are recognized under international law and should be observed by the belligerent states as well as the neutral states. Development of the law of neutrality. The term neutrality has been derived from the Latin word neuter, which means impartiality. In wider sense, by neutrality we mean an attitude of impartiality adopted by the states who do not take part in the war. So far as the modern international law is concerned, the law of neutrality started in the Middle Ages. In fact, the word neutrality began to be used since 17th century. But its systematic development could not be achieved until 18th century. In 18th century, the two famous jurists Bjarnkershock and Vattel contributed much to the development of the law of neutrality. In 18th century it was agreed that the states which do not take part in war are entitled to remain impartial and this impartiality may confer upon them certain rights. The development of the law of neutrality received a great impetus in the United States of America in 19th century. Much of the credit for this goes to the United States because in the Napoleonic Wars of Europe, America remained a neutral country. The systematic development of the law of neutrality also owes much to the Civil War of America. A leading case of this period relating to neutrality is Albemarle Claims Arbitration 1872. In the Civil War of America, Britain was neutral. But Britain provided the facilities to the southern states for the fitting and construction, etc., of Alabama and others destroyers in its territory. America claimed that it was a clear violation of the neutrality adopted by Britain. America contended that it was the duty of Britain to prevent such types of acts in its territory. America, therefore, claimed compensation for the violation of law of neutrality by Britain. Britain and America agreed to entrust this matter to the Court of Arbitration. The Court of Arbitration gave its award in favor of America and ruled that Britain should pay $15,500,000 in gold to America. The permanent neutralization of Belgium and Switzerland in 19th century was also a landmark event so far as the development of the law of neutrality was concerned. This encouraged the development of the law of neutrality. The establishment of the League of Nations and then the United Nations greatly affected the law of neutrality in the 20th century. Q. 82. What do you know about the position of neutrality under the UN Charter? Discuss. Ans. Position of neutrality under the United Nations Charter. Some jurists are of the view that the United Nations Charter has put an end to the old law of neutrality. Prof. Kelson has remarked that the rule of impartiality by neutral states is superseded by the Charter. Some other jurists have supported this view. In the view of these jurists, when a state resorts to war there could be only two conditions. It could either be an aggressor or a defender. If it is an aggressor then preventive or enforcement action can be taken against it under the Charter. If it is a defender then it should be assisted by the United Nations. Thus the member states of the United Nations cannot remain neutral. Before we criticize the view of these jurists, it will be desirable and necessary to refer to the relevant provisions in the United Nations Charter which have affected the old law of neutrality. Such provisions are as follows. 1. Article 2(5). Article 2(5) provides that all members shall give the United Nations every assistance in any action. It takes in accordance with the present Charter and shall refrain from giving assistance to any state against which the United Nations is taking preventive or enforcement action. 2. Article 25. Article 25 provides that the members of the United Nations agree to accept and carry out the decisions of the Security Council in accordance with the present Charter. That is to say, if the Security Council decides to take any the sick, member states have no option but to carry out this decision. Under such circumstances they cannot remain neutral. 3. Articles 41, 42 and 43. Articles 41, 42 and 43 are relating to the right of enforcement action conferred upon the Security Council in respect of maintenance of peace and security. Under these articles the Security Council has been empowered to ask other states to assist it. These provisions are in fact detrimental for the observance of the rules of the old law of neutrality. 4. Article 49. Article 49 provides that the members of the United Nations shall join in affording mutual assistance in carrying out the measures decided upon by the Security Council. It has also affected the old law of neutrality. 5. Article 51. Article 51 of the Charter confers upon all the member states of the United Nations the right of individual or collective self-defense if any armed attack occurs against a member of the United Nations. It is clear from the above provisions that the United Nations Charter has greatly affected the old law of neutrality. It is on the basis of these provisions that many jurists have expressed the view that the Charter of the United Nations has put all end to the old law of neutrality. But as against the above view, some jurists have expressed the view that although the provisions of the Charter have greatly affected the old law of neutrality, they have not completely abolished it. That is to say, neutrality can still be practiced under certain circumstances. Thus, the old law of neutrality has not been completely abolished and can be practiced by the member states of the United Nations in certain special circumstances, although in principle the member states of the United Nations cannot claim to remain neutral. Q. 83. What are the rights and duties of neutral states and belligerent states? Ans. Rights and duties of neutral states and belligerent states. Ordinarily following are the duties of the neutral states. 1. Abstention. It is duty of the neutral state to abstain from rendering direct or indirect help to the belligerent states. For example, the neutral states cannot assist either belligerent through forces or cannot guarantee the loans to be given to them. 2. Prevention. It is also the duty of the neutral states to prevent certain things within their territory. For example, it is their duty to ensure that persons are not recruited for the war forces of belligerent states within their territory. They should also prevent the preparation of war in favor of either of the belligerent states. 3. Acquiescence. It is also the duty of neutral states to give their acquiescence in respect of certain matters. For example, they should give their acquiescence when a ship using the flag of their state is seized for carrying contraband. If they oppose such seizure, it will be deemed to be the violation of the law of neutrality on their part. In addition to the above-mentioned duties, the neutral states have certain other duties, although the following duties are in consequence or connected with the above-mentioned three duties. Such duties are as follows. 1. Restoration. It is the duty of the neutral states not to allow any act connected with the war within their territory, and in case any such act takes, it is their duty to restore it. That is to say, if either of the belligerent seizes enemy ship within the territory of the neutral state, then it becomes the duty of the neutral state to get such ship restored to the other belligerent state. 2. Reparation. If a neutral state contravenes the above-mentioned duties, it may be held liable to pay compensation for the same. A leading case on the point is Alabama Claims Arbitration, 1872. In this case, Britain had to pay America $15,500,000 in gold in the form of compensation for the violation of the laws of neutrality. Rights and duties of the neutral states have been mentioned in Hague Convention of 1907. Duties of the belligerent states. Following are the duties of the belligerent states. 1. Abstention. It is the duty of the belligerents to abstain from committing act of war within the territory of the neutral states. 2. Prevention. It is their duty to prevent bad treatment towards the ambassadors, citizens, etc., of the neutral states. 3. Acquiescence. Like the neutral states, belligerent states are under duty to give their acquiescence in respect of certain matters. For example, if a state gives asylum or refuge to some members of its forces or allows temporary asylum or refuge to the enemy within its port, or allows the enemy state to get its ships repaired in its port, then it is the duty of the other belligerent state not to oppose it and to give its acquiescence in this respect. Rights of the neutral states. According to Lawrence, following are the rights of neutral states. 1. The first right of neutral states is that no warlike act should be committed in their territory. 2. Secondly, their cable lines and seas, etc., should not be damaged as far as possible. 3. The belligerent states should not use their territory for making preparation of war. 4. They are also entitled to get certain rules formulated for the protection of their territory and to make the belligerent states observe them. 5. Neutral states also possess right that if their neutrality is violated, then they get compensation for the same. It may, however, be noted that there is a lack of definite principles in this respect, but at least this is definite that they should get adequate compensation for the violation of the law of neutrality, and compensation should be proportionate to the loss or damage suffered by them. Q. 84. What are the different kinds of neutrality and distinction between them? Ans. Kinds of neutrality and distinction between them. Neutrality may be of following kinds. 1. Perpetual or permanent neutrality. When a state is neutralized through a special international treaty, then such a neutrality is called perpetual or permanent neutrality. 2. General and partial neutrality. When only a part of the state is neutralized, it is called partial neutrality. On the other hand, when the whole state adopts the attitude and policy of neutrality, it is called general neutrality. 3. Voluntary neutrality and neutrality based on some treaty. A voluntary neutrality is a neutrality which is declared by a state voluntarily without being bound by a treaty. On the other hand, a state may become neutral being bound by any general or special treaty. 4. Armed neutrality. When a state uses armed force for the defense or neutrality, it is called armed neutrality. 5. Benevolent neutrality. When a state, while remaining neutral, favors belligerent state or otherwise helps it, is called benevolent neutrality. 6. Perfect and qualified neutrality. When a state remains completely impartial and does not, directly or indirectly, assist either of belligerents, then it is called perfect neutrality. But if a state remains neutral generally but as a result of some provisions of treaties entered into before start of war, directly or indirectly assists any belligerent state, then it is called qualified neutrality. Q. 85. Differentiate. A. And neutralization. B. Neutrality and neutralism. Ans. A. Distinction between neutrality, and neutralization. Neutralization is the permanent status of neutrality of a state. Often it is guaranteed by the international agreement or treaty. Such a state cannot participate in war without violating its neutrality. Prof. Schwarzenberger has clarified the distinction between neutrality and neutralization in the following words. Whereas under international customary law a neutral power remains free to exchange its status of neutrality for that of war. Neutralized state which is a party to a treaty prescribing its permanent neutrality may not do so. It cannot resort to war without a breach of its treaty obligation or release from these by the other parties to the treaty. Switzerland represents this type of state. Switzerland is an ideal neutralized state to the extent that in order to adhere to its neutrality it has not even joined the membership of the United Nations. Austria is also a neutralized state and its neutrality has also been guaranteed under an international treaty. But Austria has become the member of the United Nations. In the words of Stark, following is the distinction between neutralization and neutrality. Neutralization differs fundamentally from neutrality, which is a voluntary policy assumed temporarily in regard to a state of war affecting other powers and terminable at any time by the state declaring its neutrality. Neutralization, on the other hand, is a permanent status conferred by agreement with the interested powers, without whose consent it cannot be relinquished. B. Distinction between neutrality and neutralism. According to Schwarzenberger, neutralism is a political and ideal concept, the meaning of which may change in different contexts and circumstances. There is a great difference between neutrality and neutralism. Neutrality is an attitude of impartiality as well as legal status. As compared to it, neutralism is only used to denote the political attitude of a state. As pointed out by Dr. Peter Leo, neutrality is meant non-involvement in war, while by neutralism is meant non-involvement in Cold War. Prof. Schwarzenberger has also remarked, in contrast to neutrality, which presupposes state of war between at least other states, neutralism understood as policy of non-alliance or non-involvement is available as a pattern of policy in times of both peace and war. Q. 86. What is meant by Angari? State the leading features by reference to some decided cases. Ans. Right of Angari. The right of Angari denotes the right of a belligerent state in times of war or other public danger to use or even, when necessary, to destroy such neutral property as happens to be within its territorial jurisdiction at a particular time. It affords a belligerent state to requisition or appropriate, in times of public urgency, vessels, rolling stock, aircraft and other means of transport belonging to the nationals of neutral powers, but lying at the time within its own territorial jurisdiction. This is founded on the principle that the supreme interest of the state overrides the law. It is as well based on the general principle the neutral property in belligerent territory is exposed to like risks as the property of belligerent nationals and is subject to similar liability to requisitions and contributions in time of war and other national emergency. Oppenheim observes that in contradistinction to the original right of inquiry, the modern right of inquiry is the right of belligerents to destroy or use in case of necessity for the purpose of offense and defense neutral property on their territory, or on enemy territory, or on the open sea. According to him, this right is a right deriving from the law of war and must not be confused with the right, which every state undoubtedly possesses, of seizing in case of emergency, and subject to compensation, any foreign property on its territory. One ought not, therefore, to speak of a right of inquiry belonging to neutrals as well as to belligerents, or of a right of inquiry in peace as well as war. Limitations. I. The right of inquiry is a sovereign right and can be exercised by any sovereign state in case of national emergency, provided the goods and means of transport requisitioned are lying within the territorial jurisdiction of the state requisitioning them. E. The right is confined to the territorial waters of the requisitioning state and does not extend beyond its territorial limits. E. The right can as well be exercised by a neutral in grave national emergency. Such requisition can only be made subject to the payment of full compensation. IV. The right cannot be exercised by a belligerent in occupation of an enemy territory. V. The right of inquiry does not extend to the services of the foreign crew of the ships or aircraft. V. The application of this right could not be extended to neutral property only passing within a belligerent state. V. The right would not be used to justify destruction of property is distinguished from appropriation. The Zamora. In the case of Zamora, it was observed by Lord Parker that a belligerent has in a proper case the power to requisition ships and goods of neutrals in the custody of the prize court for adjudication. The legal right or dominion is, no doubt, still in the neutral. The right of requisition is not an absolute right, but a right exercisable in certain circumstances and for certain purposes only. It was, therefore, held that requisition of a vessel or cargo of copper awaiting the judgment of the prize court was allowed provided that the vessel or the goods in question must be urgently required for use in connection with the defense of the realm, the prosecution of the war, or other matters involving national security. B. There must be a real question to be tried. And C. The prize court determines judicially whether, under the particular circumstances of the case, the right is exercisable. Q. 87. The principle of contraband is that you are entitled to stop and capture any cargoes which are going to help your enemy in carrying on the war. Discuss the above statement and classify contraband. Goods. Uns. Contraband of war. Contraband of war is the designation of such goods as are forbidden by either belligerent to be carried to the enemy on the ground that they enable him to carry on the war with greater vigor. Oppenheim. According to Kelson, contraband of war are goods the transport of which to the enemy is forbidden by either belligerent in conformity with general international law. Contraband of war denotes such articles as are considered objectionable to be carried by a neutral to a belligerent because they are calculated to be of direct service in carrying on war or otherwise assist one of the belligerents in time of war. The same view is expressed in the given statement that, the principle of contraband is that you are entitled to stop and capture any cargoes which are going to help your enemy in carrying on the war. Essentials of guilt. Lawrence sums up the essentials of guilt in the matter of contraband in the following words. In the first place, it is transport and not bargain and sale which the law of contraband aims at. Secondly, a belligerent destination is essential. And, thirdly, the offense is complete the moment a neutral vessel laden with contraband leaves neutral waters for belligerent destination. The Imana. Division of commodities. Grotius divided commodities into three classes. 1. Things useful for war only, e.g., arms, projectiles, powder, etc. 2. Things useless for warlike purposes, e.g., fashion and fancy goods, clocks and watches, soap, etc. And 3. Things useful in war and peace indifferently, i.e., money, provisions, ships, naval stores, etc. According to him, the first was liable to capture while on their way to an enemy destination, the second was always immune from capture, and the third depended upon circumstances in each case. There is a divergence of opinion as to what articles are to be termed as contraband. The British view favored a long list of contraband goods and divided articles into absolute contraband and conditional, occasional, or relative contraband. Absolute contraband included articles such as arms, machinery for manufacturing them, ammunitions, powder, clothing of military character, etc., while conditional, occasional or relative contraband consisted of articles such as provisions, coal, gold, etc., which were contraband or not according to circumstances. The French view, which was followed by other continental powers, deemed comparatively few articles to be contraband and held that there could not be conditional contraband articles. The same thing was either contraband or not and could not be both, i.e., contraband in one set of circumstances and innocent in another. The unratified Declaration of London, 1909, made an attempt to settle the long drawn-out controversy between the two conflicting views. It divided articles into three categories, viz. Absolute contraband, conditional contraband and non-contraband. The subject of contraband engaged the attention of the Supreme Court of America in the case of the Peterhof, where it was observed that a strictly accurate and satisfactory classification is perhaps impracticable, but that which is best supported by American and English decision may be said to divide all merchandise into three classes. 1. Articles manufactured and primarily or ordinarily used for military purposes in time of war. 2. Articles which may be and are used for purposes of war or peace according to the circumstances. And 3. Articles exclusively used for peaceful purposes. Merchandise of the first class, destined to a belligerent country or place occupied by the army or navy of a belligerent, is always contraband. Merchandise of the second class is contraband only when actually destined to the military or naval use of a belligerent, while merchandise of the third class is not contraband at all. though liable to seizure and condemnation for violation of blockade or siege. Article 30 of the Unratified Declaration or London lays down that absolute contraband is liable to capture if destined to territory belonging to, or occupied by, the enemy.